ಕೇಸು ಐಡಿಯಾದಲ್ಲಿ ಕೊಡು. பெரியவங்கள சின்னவங்களன்னு இல்ல, தாட் எவருக்கு வருமோ அது இம்பார்ட்டன்ட். பெரியவங்க சின்னவங்க
मिलने थोड़ी
ಕಂಪ್ಲೇಂಟ್ಸ್ ಇತ್ತು. ಕೊಡಿ ಎಲ್ಲ ಮೆಂಬರ್ಸ್ ಕೊಡಿ ಆಸ್ ಪರ್ ರೋಸ್ಟರ್. ವೇಟ್ ಮಾಡಿ. 61
74
62 to 74, 75 to 85, 76. ಏನಪ್ಪ ಕೇಳಿ. ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೋ ದಾಖಲೆ ಇದೆಯಾ? ರಿಟೈರ್ಮೆಂಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋದು ಎಲ್ಲಿದೆ ದಾಖಲೆ? ಮತ್ತೆ ಕೊಡ್ಬೇಕಲ್ಲ. ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೋ ನೋಟಿಸ್ ಕೊಟ್ಟು ರಿಟೈರ್ ಆಗ್ಬೇಕು. ಹಂಗೆ ನೀವು ಬಂದು ಮೆಮೋ ಹಾಕೋಕ್ಕಾಗಲ್ಲ. ನೋ ಸಚ್ ಪ್ರೊಸೀಜರ್. You should intimate your client and then you retire. '86 to '97 ಯಾರು ಇಲ್ಲ. 98 to 112 ತೋಳಿ ಮ್ಯಾಮ್. 101 ಏನ್ ರೀಸನ್ ಏನು? ರೀಸನ್ ಅಲ್ಲೇ ಹಾಕ್ತೀವಿ ನೋಡಿ. Petitioner counsel has filed memo seeking permission to withdraw the petition. And counsel submitted that petitioner is not pressing the petition and intend to approach the trial court and hence permitted to withdraw. And 13 to 18. ಇಲ್ಲ ಇದೇನ್ ಮೇಡಮ್ ಟಾಪ್ ಅಪ್ ದಿ ಲಿಸ್ಟ್ ಅಂತ ಮಾಡಿದ್ವಿ. ಲ್ಯಾಕ್ ಕೊನೆಗೆ ಹಾಕ್ತಿದ್ದಾರೆ. ಮತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್ ನಾವು ಸಬ್ಮಿಷನ್ ಮಾಡಿದಾಗ ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ, ಇದಾರ ಅದರ ಸೈಡ್ ಶೇಖರ್ ಶೆಟ್ಟಿ ಅದರ ಇವರು ಇಲ್ವಾ? ಆಯ್ತು ಬಿಡಿ. ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಇದು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮನೆ ಮಾಡಿದ್ನಲ್ಲ, ನಾನೇ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ನಲ್ಲ ಮೇಡಮ್. ಟಾಪ್ ಅಪ್ ದಿ ಲಿಸ್ಟ್ ಅವತ್ತು ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ. ವೆನ್ he insisted for stay, ಆಯ್ತು. Yes, come. Council 6 2 days time granted. Muddu Raja. Withdrawal. Petitioner counsel has filed memo seeking permission to withdraw the petition with liberty to file criminal appeal. Hence permitted to withdraw. Mahesh Kumar absent 2 weeks time granted. Bhadravadi Siddeshwara absent 2 weeks time granted. Ananda same. Venkat Reddy counsel 6 1 week time granted. Onur Ali weeks time granted as sought. Parmeshwaran Hegde absent 2 weeks. Ravi Shankar KP absent 2 weeks granted. Second time. Radha Krishna Hospital 98 the council submission is only offense mentioned in main prayer is not tallying with the same criminal miscellaneous number 847 and charge sheet copy to be clarified. The council submission is accepted. This objection is overruled. HCGP is directed to take notice and file objections if any. This matter next Monday date, madam. 6th. Non-compliance of office objection 4th time. ಏನಾಯ್ತು? ನಾನ್ ಪೇಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ನೋಡಿ. ನಾನ್ ಪೇಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ 4 ಹೋಗೋದಲ್ಲ ಇಟ್ಟಿರಿ. ಆಮೇಲೆ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಕಸ್ ಮಾಡಿ. ಪಾಸ್ ಓವರ್ ಆಲ್ 4 ಪಾಸ್ ಓವರ್. 6th time ನೋಡಿ. This matter is listed for 6th time and this court earlier imposed cost of ₹1,500 and cost also not paid and hence petition is dismissed. Muzaffar Ahmad ಇದೇ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಮೊನ್ನೆ ಇತ್ತಲ್ಲ ಅದ ಮತ್ತೆ ಯಾಕೆ ಹಾಕಿದ್ರು? ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ಲ ಮೇಡಮ್ ಅದು. ಏನ್ ಮಾಡಿದೀವಿ ಆರ್ಡರ್ ಅಲ್ಲಿ? ಫಸ್ಟ್ ಏನೋ ಇವ್ರು ಹೇಳಿದ್ರಲ್ಲ, ಏನೋ ಗಂಡನ ಮನೇಲಿ ಇದೆ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ನಲ್ಲ ಮೇಡಮ್ ಅವತ್ತು. ಫಸ್ಟ್ ಒಬ್ರಿಗೆ ಮಾಡಿದ್ವಿ, ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ವಿ. ಕೊನೆಯವರು ಬರ್ದ್ಬಿಟ್ರು ಇದು ಎಷ್ಟು ಅಂತ ಆಯ್ತು. ಏನದು ಗಂಡನ ಮನೇಲಿ ಇರೋ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ. The counsel appearing for the petitioner would submit that the address given in the petition belongs to husband, and in the and in the FIR address mentioned in respect of her parental address, and hence office objection is overruled. ಆಯ್ತಾ? ಆಯ್ತು, ಹೇಳಿ. ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳ್ತೀರಾ? ಏನು ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕಾ? ಏನು ಪಾಸ್ ಓವರ್ at 2:30? ಹೇಳಿ. ಏನು ಹೇಳಿ. Inlaws. Husband. Mother of Artula. Victim mother no accused ಮಾಡಿದಾರಾ? After the marriage. First facts ಹೋಗಿ, case facts ಹೋಗಿ. Who gave the complaint actually? Anita Lakshmi SP PSI. Right. What she says? Yeah. Of 17 years, 18 years, 7 months ಅಂತ ಹೇಳ್ತಾರೆ. ಏನ್ರಿ ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ? ಅವಳ ಏಜ್, ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಏನ್ 2004 ಸ್ಕೂಲ್ ರೆಕಾರ್ಡ್ಸ್ ಪ್ರಕಾರ. ಅಲ್ಲಿ she is minor, aged about 16 years. ಇನ್ಸಿಡೆಂಟ್ ಯಾವಾಗ? ಮದುವೆ ಮಾಡಿದ್ದು ಯಾವಾಗ? 2011 ಮದುವೆ ಮಾಡಿದ್ದು ಡೇಟ್ ಹೇಳ್ತಾರೆ ನೋಡಿ, 10/10/21. ಆಗ ಎಷ್ಟಾಗಿರುತ್ತೆ ಅವಳಿಗೆ ಏಜ್? 16 years 11 months. ಏನ್ರಿ ಇದು? ಮದುವೆ ಮಾಡಿದ್ಮೇಲೆ ಸೆಕ್ಸುವಲ್ ಆಕ್ಟ್ ಬಿಫೋರ್ ಏನಾರು ಇದೆಯಾ? ಆತರ ಏನಿಲ್ಲ. 164 ಏನಿಲ್ಲ. ಬಟ್ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ she is pregnant. Heard the petitioner counsel and also the counsel. ನಿಮ್ದೇನ ಹೇಳೋದಿದೇನ್ರಿ? ಎಲ್ಲ counsel for the state as well as counsel appearing for the respond number 2. The factual matters of the case of the prosecution is that based on the PSI, a case has been registered, and in the complaint the PSI has stated that when the victim girl was taken to hospital for medical examination and doctor reported that she was a minor and performed the child marriage, as a result she became pregnant. The victim girl statement also recorded before the learned magistrate, wherein she has stated that she is aged about 18 years 7 months And her marriage was solemnized on 10/10/21. And after the marriage, they were happily living. Happily, she is residing along with her husband. And nobody has given any trouble to her. The petitioners are in-laws, husband, and also the mother of respondent number 2. An allegation is made against them. They have performed the child marriage. In spite of the victim is aged about 16 years 11 months as per the school records. And counsel appearing to the petitioner would submit that the very victim herself has stated that she is aged about 18 years 2 months in her 164 statement. And also the counsel would submit that they are the residents of Bombay and they stayed for a period of 7 years at Bombay and thereafter shifted to Mysore and wherein she is pursuing the education. And counsel also would submit that at the most it attracts offences 9(11) of Child Marriage Act and not attracts the offence of section 376(2) of IPC. And hence may be enlarged on bail. The counsel appearing to the respondent number 2 also submits that there are no any documentary proof regarding her birth is concerned, but only school records discloses the age as 16 years 11 months. But she is a major and marriage was performed by the parents of the victim. And the victim as well as the husband are living happily. And victim herself has stated that she was not subjected to any harassment. And hence they may be enlarged on her date of birth is 2011-2014. And she is aged about 16 years 11 months. And only it has comes to the knowledge of the doctor when she went for examination in relation to her pregnancy, and the doctor has reported the same and performed the marriage even though she is a minor. Having heard the respective counsel and also taking into note of the contents of the complaint as well as statement of victim girl, and victim girl not stated anything against these petitioners. Apart from that, she claims that she is aged about 18 years 2 months. And also taking into note of the fact that child marriage was solemnized on 10/10/21 itself. And as a result, she became pregnant in view of performing her marriage. And taking into note of no grievance of the instance of the victim's family or the family of her husband, and based on the information given by the doctor, the PSI has registered the case. And taking into note of peculiar facts of the case on hand, it is appropriate to enlarge the petitioners on bail. At the most, it attract the offence on section 9 and 11 of Child Marriage Act with conditions. All 438 petitions. Only the statement. First time orders, any matters notice order ಆಗೋದು ಯಾವ್ದಾರು ಇದೆಯಾ? 57 ಅಲ್ಲ? Age
36 my lordship.
27 madam, notice. HCCP is directed to take notice and also directed to notify the complainant / victim or informant. 27 ಇನ್ಯಾವುದು?
My lordship, serial number 36 my lordship.
36 ಅಲ್ಲೂ ಕೂಡ ಮೈನರ್ victim?
No, this is a PTI.
Notice
my lordship.
Notice ಹೋಗ್ಬೇಕಾ?
Yes my lordship. ಇಲ್ಲ ಅವ್ರಿಗೆ ಹೋಗಂಗಿಲ್ಲ my lordship. Only the
ಸ್ವಲ್ಪ ಕೂತ್ಕೊಳ್ಳಿ, ಸ್ವಲ್ಪ ಸಮಾಧಾನವಾಗಿ ಕೂತ್ಕೊಳ್ಳಿ. ಯಾವ್ದಾದ್ರು ನೋಟಿಸ್
matter 55 your lordship.
55 ಹೇಳಿ.
Notice has to be given my lords.
Age
My lord, this is a cattle smuggling case, my lord. There is no agent.
ಅಲ್ಲ ರೀ ಮತ್ತೆ ಯಾಕೆ ಹೋಗ್ಬೇಕು ನೋಟಿಸ್? ಕಂಪ್ಲೇನೆಂಟಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು. ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಆಲ್ ಇನ್ ಆಲ್ ಕೇಸಸ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಟು ಟೇಕ್ ನೋಟಿಸ್.
Yes.
ಬೇರೆ
Yes.
ಏನಾರು ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಬೇರೆ ಏನಾರು ವಿಕ್ಟಿಮ್ ಏನಾರು ಮೈನರ್ ಆ ರೀತಿ ಇದ್ರೆ ಇನ್ಯಾವ್ದು ಇಲ್ಲೇನ್ರಿ?
Appearance for the petition, my lord.
Serial number 17, except 27, 60, serial number 60 where HCCP is directed to take notice and file objections if any. Common 6th of March, June. ಹೇಳಿ ಏನು? No such business in my court, no interim bail.
Serial number 18, my lord. Serial number 18, my lord.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ. If you want an order, I will reject it. No such business interim order. ಏನಾಗೋದಿಲ್ಲ. 438. 438. That's all. No counsel, no business.
My lord, serial number 18, my lord.
59 ಅಲ್ಲಿ ಮೈನರ್ ಇದಾರಾ? 29 ಒಂದ್ ಸೆಕೆಂಡ್. ಯಾವ್ದಾರು ಬೇರೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕೌನ್ಸಿಲ್ ಇದಾರಾ? 29. ಕಾಪಿ ಸರ್ವ್ಡ್ ಆನ್ ದಿ ಅಮಿತ್ ದೇಶಪಾಂಡೆ ಅಂತಿದೆ. ಅಮಿತ್ ದೇಶಪಾಂಡೆ ಯಾಕೆ? ಅವ್ರೇನು ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್? ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಅಲ್ಲಿ ಇದನ್ನ ತಗೋಬಿಡಿ. ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್ ಅಮಿತ್ ದೇಶಪಾಂಡೆ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್. ಅದು ಸೇವ್ ಮಾಡ್ರು. ಇನ್ಯಾವ್ದಾರು ಇದೆಯಾ ಮೇಡಮ್? ಯಾವ್ದು ಇಲ್ಲ. 30 ಏನಾಗ್ಬೇಕು ಕೇಳಿ. ಅದೆಲ್ಲ ಮೋಸ್ಟ್ಲಿ ಯಾವ್ದೋ ಫೈಲ್ ಇದ್ದಿದ್ದು ಅದು ಮಾತ್ರ ಅಷ್ಟೇ. ಅದಕ್ಕೆಲ್ಲ ಏನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲ. ಆಲ್ 60 ಮ್ಯಾಟರ್ಸ್ 6th of June. ಹೇಳಿ ಏನಾಗ್ಬೇಕು? ನೋ ಟ್ಯೂಸ್ಡೇ ಮಂಡೇ ಆಗಲ್ವಾ ನಿಮಗೆ? ಬೇಡವಾ? ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 35 ಒಂದು ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ಟ್ಯೂಸ್ಡೇ ಅಂದ್ರೆ 7th. 30 ಆಲ್ಸೋ 7th. ಆಯ್ತು. 30, 35, 7th. ಬಾಕಿ ಇವೆಲ್ಲ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ 6. ಎಸ್, ಸೀರಿಯಲ್ ನಂಬರ್ 61. Devanand. Sorry, petitioner counsel absent, and in the earlier occasion also counsel was absent, and counsel is not pursuing the matter diligently. However, in the ends of justice, one more opportunity is given, and this matter on 6th. And if counsel doesn't appear on the next date of hearing, matter will be discussed for non-prosecution. 62 Harish Kumar RS. ಎಲ್ಲ absent ಕೇಸ್ ಕಲ್ರಿ. ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಆರ್ಡರ್ ಮಾಡಿದೀವಾ? ಸೇವ್ ಮಾಡ್ರು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಕೌನ್ಸಿಲ್ ಆಬ್ಸೆಂಟ್ ಸೇವ್ ಮಾಡ್ರು. 62
ಇದೀರಾ ಸರ್? ಡಿಸ್ಟರ್ಬ್
ಯಾರಿದು? ಕೌನ್ಸಿಲ್
I'm appearing for petition, my lord. Serial number 64, my lord.
ಕಾರಲ್ಲಿ ಇದ್ದೀರಿ ಆಬ್ಸೆಂಟ್ ಡಿಸಪಿಯರ್ ಆಗಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಐ ವಿಲ್ ಇಶ್ಯೂ ಕಂಟೆಂಪ್ಟ್ ಅಗೇನ್ಸ್ಟ್ ಯು. ಇನಿಷಿಯೇಟ್ ಕಂಟೆಂಪ್ಟ್ ಅಗೇನ್ಸ್ಟ್ ಯು. ಕಾರಲ್ಲೆಲ್ಲ ಕುತ್ಕೊಂಡು ಕೋರ್ಟಲ್ಲಿ ಅಪಿಯರ್ ಆಗೋದು ಏನ್ರಿ ಇದು? ವಾಟ್ ಇಸ್ ದಿಸ್ ಕೌನ್ಸಿಲ್? ಯಾವ್ದು ನಿಮ್ ಸೀರಿಯಲ್ ನಂಬರ್? ಯಾವ್ದು ನಿಮ್ದು? People have no sense at all. 63 ಏನ್ರಿ? 11. Again he is repeating. ಯಾರೊಬ್ರು ಮರ್ದ ಕೆಳಗಡೆ.
Sorry, my lord. Serial number 64, pending pass over, my lord.
I will reject your petition. Third serial number 64. The counsel
Pending pass over. Sorry, my
has
lord.
nuisance, and he appeared in the car, and also now he is under the tree. And hence petition is dismissed. ಯಾವ್ದು ಮೇಡಮ್? 63 ಏನಾಯ್ತು? ಶ್ರೀನಿವಾಸ್ ತಗೊಂಡ್ರಿ. 62 ನಾ? 62 ನೀವಾ? ತಗೊಳ್ಳಿ. ಇದು ತಗೊಳ್ಳಿ. ಏನು ಮಾಡಿದ್ವಿ? ಏನೋ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ. ರಕ್ಷಿತ್ ಇರ್ತಾರ ಯಾರು ಇನ್ನೊಂದ್ರಲ್ಲಿ? ನೀವ್ ಯಾವ್ದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗೋದು? ಹರೀಶ್ ಕುಮಾರ್. ಕೊಡಿ. ಕೇಸಲ್ಲಿ ರಕ್ಷಿತ್ ಅವ್ರಿಲ್ವಾ? ಏನಾಗಿದೆ ಅರ್ಜೆಂಟ್ ನೋಡಿ ಮೇಡಮ್, ಅದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ? ನೀವು 2 ಕ್ಲಬ್ ಆಗಿದೆಯಾ? 2 ಕ್ಲಬ್ ಆಗಿದೆ, ಮತ್ತೆ ಅವ್ರನ್ನ ಏರ್ ಮಾಡ್ಬೇಕಲ್ಲ ಕ್ಲಬ್ ಆದ್ಮೇಲೆ. ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳ್ಬಿಡ್ತೀರಾ? ಏರ್ ಮಾಡ್ತೀನಿ ಅಥವಾ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. ನಾಳೆ ನಾಡಿ ಕಷ್ಟ. ಯಾರು ಬರ್ತಾ ಇಲ್ವಾ ನೋಡಿ, ಏನಾಗಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ? ಲಾಸ್ಟ್ ಟೈಮ್ ಅಬ್ಸೆಂಟ್. ಯಾಕೆನೆ 2 ಅಬ್ಸೆಂಟ್ ಅಂತಿತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್, ನೋಟ್ ಮಾಡಿದ್ ನಾನು. ಅದು ಯಾರು ಕೊಡಿ, ಹೋಗ್ಲಿಕ್ಕೆ ಪಿಟಿಷನ್ ಕೊಡಿ ನೋಡಿ. ಇವ್ರಿಗೆ ಕೊಡೋದಿದ್ರೆ ಅವ್ರಿಗೂ ಕೊಡೋಣ. ನಮ್ಮಂತ ಬಂದಿದ್ಯಾ? ವಿಡಿ ಫೈಲ್ ಒಂದು ಇಟ್ಟಿದ್ದಾರೆ. ಯಾರ್ದು ಇದು? ನಿಮ್ ಕ್ಲೈಂಟ್ ಹೆಸರೇನು? ಶಿವಣ್ಣ ಅಲಿಯಸ್ ಕಪ್ಪೆ ಶಿವ ಅಂತನೋ ಯಾರೋ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ. ಇದಾಗಿದೆ ಯಾರ್ದು ಮೇಡಮ್? ಅಕ್ಯೂಸ್ ನಂಬರ್ ತಿಗಡಿ ಏನು ಅಪೇರ್ ಆಗಿದ್ರಲ್ಲ? ಅಕ್ಯೂಸ್ ನಂಬರ್ 5 ಇದು ಅದ್ರಲ್ಲಿ ಇದೆಯಾ? ಇದರಲ್ಲಿ A5 ಆಲ್ರೆಡಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಇದ್ರಲ್ಲಿ ತಗೋಬಿಡಿ ಮೇಡಮ್, ತಗೋಬಿಡಿ. ದಿ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಇನ್ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ 2036/22 is absent and hence office is directed to D-Link criminal petition number 2036/2022. ಈಗ ನಿಮ್ ಮಾತ್ರ ಹೇಳಿ 9514 ಅಲ್ಲ? ಹೇಳಿ 307. 302 ಆಲ್ಸೋ ಇದೆಯಾ? ಆಮೇಲೆ FIR ಇದ್ದಾಗ ಓನ್ಲಿ 307. ಈಗ ಇವನು ಅಕ್ಯೂಸ್ ನಂಬರ್ ಎಷ್ಟು? A3. Not shown in the FIR, no name. Oh, now charge sheet is also filed. Where is the charge sheet? At page 30. 26 ಅಲ್ಲ 30 ಅಲ್ಲಿದೆ ನೋಡಿ, ಕಾಲಮ್ ನಂಬರ್ 7 ಚಾರ್ಜ್ ಶೀಟ್. 3 ರಿಂದ 7 ರವರೆಗೆ ತಿಳಿಸಿದ್ದು ಹೊಡೆದಿರ್ತಾರೆ ಸದರಿ ವಿಷಯವನ್ನು ಆರೋಪಿ 1 ಮತ್ತು 2 ರವರು ಆರೋಪಿ 3 ರಿಂದ 7 ರವರೆಗೂ ಆತನಿಗೆ ಒಂದು ಪ್ರತಿಕಾರವನ್ನು ಮಾತನಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಅವರುಗಳು ಮದ್ಯಪಾನ ಮಾಡುತ್ತಾ ಮಾತನಾಡಿಕೊಂಡು ಕುಳಿತಿರುತ್ತಾರೆ. 18/7 ಅರ್ಲಿಯರ್ ಇನ್ಸಿಡೆಂಟ್ ಯಾವಾಗ? ಏನಷ್ಟು A3 ವಾಟ್ ಇಸ್ ದ ಎಲಿಗೇಷನ್? ಭೂತ ಹೇಮಂತನನ್ನು ಕರೆದಾಗ ಭೂತ ಹೇಮಂತನಿಗೆ ಹಾಗೂ 7 ಗಲಾಟೆಗೆ ಹೇಮಂತನನ್ನು ಕೆಳಗೆ ಈಚೆಗೆ ಕಳೆದುಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ. ಆಗ ಸಾಕ್ಷಿ 1 ರವರು ಆತನನ್ನು ಬಿಡಿಸಲು ಮುಂದಾದಾಗ ಆರೋಪಿ 1 ಜೋರಾಗಿ ಕಿರಿಚಿಕೊಂಡಿದ್ದು, ಆಗ ಆರೋಪಿ 3 ರಿಂದ 7 ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಸಾಕ್ಷಿ 1 ಮತ್ತು ಭೂತ ಹೇಮಂತನಿಗೆ ಕೈಗಳಿಂದ ಕಾಲುಗಳಿಂದ ಮನಬಂದಂತೆ ಹಲ್ಲೆ ಮಾಡಿರುತ್ತಾರೆ. ಆರೋಪಿ 1 ರಿಂದ 3 ರವರು ಭೂತ ಹೇಮಂತನನ್ನು ರಸ್ತೆಗೆ ಎಳೆದುಕೊಂಡು ಹೋಗಿ ಆತನ ತಲೆ ಹಾಗೂ ದೇಹದ ಭಾಗಗಳಿಗೆ ಕೈಗಳಿಂದ ಹೊಡೆದು ಕಾಲುಗಳಿಂದ ತುಳಿದು ಒದ್ದು ಮಾರಣಾಂತಿಕ ಹಲ್ಲೆ ಮಾಡಿ ನಂತರ ಆರೋಪಿ 1 ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಠಾಣೆಯ ಮಾಲುಪಟ್ಟಿ ಸಂಖ್ಯೆ ನಮೂದಿಸಿದ ಪ್ಲಾಸ್ಟಿಕ್ ಚೇರ್ ನಿಂದ ಆತನ ತಲೆಗೆ ಹೊಡೆದಿದ್ದು, ಆರೋಪಿ 3 ರಿಂದ 7 ಆತನನ್ನು ಎಳೆದುಕೊಂಡು ಬಂದು ಮನಬಂದಂತೆ ಕೈಗಳಿಂದ ಕಾಲುಗಳಿಂದ ಹಲ್ಲೆ ಮಾಡಿದ್ದು, ಇಬ್ಬರು ತಪ್ಪಿ ಬಿದ್ದಿರುತ್ತಾರೆ. ಸಾಕ್ಷಿ 4 ರವರು ಸ್ಥಳಕ್ಕೆ ಬಂದು ಸಾಕ್ಷಿ 6 ರವರನ್ನು ಬರಮಾಡಿಕೊಂಡು ಭೂತ ಹೇಮಂತ ಮತ್ತು ತಾತ್ಕಾಲಿಕ ಚಿಕಿತ್ಸೆಗಾಗಿ ಲಕ್ಷ್ಮೀ ಸ್ಪೆಷಾಲಿಟಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಮಾಡಿಕೊಂಡು ದಾಖಲಿಸಿರುತ್ತಾರೆ. ಆಯ್ತು, ನಾವು injured is also one of the eyewitness. Hmm. 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 PM report ಎಲ್ಲಿದೆ? ಅಲ್ಲಿ ಇರೋದು ಯಾವ್ದೋ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅದು FI ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ಆಫ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ನೋಡಿ PM ರಿಪೋರ್ಟ್ ಯಾರು 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೂಡ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದೆ. ಯಾರ್ದು ಇದು 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ? ಅದರಲ್ಲಿ ಇದೆಯಾ? ಡಿಸ್ಮಿಸಲ್ ಆಗಿರೋದ್ರಲ್ಲಿ ಅಲ್ಲೇ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅದರಲ್ಲಿ ಕೊಡಿ. ವಾಟ್ ಈಸ್ ಹಿಸ್ ನೇಮ್? ಇವನ ಹೆಸರು ಮಂಜುನಾಥ. ಕಂಪ್ಲೇನೆಂಟ್ ಅಲ್ರಿ, ಈಗ ಪಿಟಿಷನರ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಡಿಪೋ. ದೀಪು ಸುಮಂತ್ ಅವರನ್ನು ನಾನು ಗುರುತಿಸಿ ಅವರೇ ಅಲ್ಲೇ ಮಾಡಿರ್ತಾರೆ ಎಂದು ತಿಳಿಸಿರುತ್ತೇನೆ. 164 ಸ್ಟೇಟ್ಮೆಂಟ್ 101 ಎಲ್ಲ ಇದೆಯಲ್ರಿ? 101 ಮಂಜುನಾಥ್ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಹಿ ವಾಸ್ ದಿ ಐ ವಿಟ್ನೆಸ್. ಹೌದಾ? ಸುಮಂತ he was not an eyewitness according to the police. He took the injured to the hospital ಅಷ್ಟೇ ಅಲ್ವಾ? CW ಎಷ್ಟು ಅವನು ಸುಮಂತ್? ಚಾರ್ಜ್ ಶೀಟ್ ಪ್ರಕಾರ ಅವನು ಐ ವಿಟ್ನೆಸ್. ನಾನು ಮತ್ತು ರಕ್ಷಿತಲು ಬಿಡಿಸಲು ಹೋದಾಗ ನಮ್ಮನ್ನು ಸಹ ಹೊಡೆದಿರುತ್ತಾರೆ. ರಕ್ಷಿತ್ ಅದೇ ಇವರು CWS ಯಾರ್ಯಾರ್ರಿ ಐ ವಿಟ್ನೆಸ್? 11 to 16. ಕೊಡಿ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಕೊಡಿ ಮೇಡಮ್. ಸೆಷನ್ ಜಡ್ಜ್. ಯಾವಾಗ ಎನ್ಲಾರ್ಜ್ ಮಾಡಿದಾರೆ ರೆಡಿ ಇದೆಯಾ? ಏನ್ರಿ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಕಾಪಿ? ನಿಮ್ಮ ಹತ್ರ ಆರ್ಡರ್ ಕಾಪಿ ಇಲ್ಲ. ಆಯ್ತು. Hmm. Hmm. Good. That he dragged him and assaulted him. He dragged him and assaulted him. And also the same is witnessed by CW 11 to 16. Other witnesses, eyewitnesses statements are also recorded before the magistrate under 164(5). That's all, madam. Heard the petitioner, counsel, and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 18/7/2021, an incident was taken place in the wine shop at 5 p.m. The injured succumbed to the injuries on 5/8/2021 due to coma as a result of head injury. At the first instance, a case has been registered against unknown persons. Unknown 7 persons, sir. No, unknown 7 persons. Thereafter, some of the surrender agidana berevara. Surrender agidana arrest agirodu. Arrest agid. Thereafter, accused number 1 was surrendered before the trial court on 12/8/21. The police also investigated the matter and filed the charge sheet after the arrest of this petitioner. The counsel appearing for the petitioner submitted that this petitioner has been arraigned as accused number 3. And at the first instance, no name of this petitioner was found in the FIR. And also there was no any intention to take away the life, having taken note of the court act alleged against the assailants. Against the assailants. The prosecution mainly relies upon the statement of CW 11 to 16 are the alleged eyewitnesses. The counsel also submits that no recovery at the instance of this petitioner. And when there is no any premeditation, and also there was no any earlier motive to this petitioner, offense under section 302 on not attracts, and hence he may be enlarged on bail. The counsel also would submit that CW 4 and 6 have already been granted bail by the trial court, not placed any such order before the court. The counsel appearing for the petitioner would submit that the CW 14 gave the statement before the learned magistrate under section 164 of CRPC. And other witnesses who have witnessed the incident also gave the statement under section 164(5) of CRPC. And cause of death is very clear that due to coma as a result of head injury, the victim must succumb to the injuries. And also counsel would submit that the other injured also sustained the injuries when he made an attempt to rescue the victim from the hands of these assailants. The counsel also submits that this court already rejected the bail petition of accused number 5 in criminal petition number 7372 of 2021, which has been filed after filing of charge sheet. Having heard the respective counsel, and also on perusal of material available on record, CW 11 to 16 are the eyewitnesses to the incident. And CW1 also sustained the injury in the incident. Hence, prosecution also invoked the offense section 307 of IPC against the assailants. No doubt, on perusal of FIR, names of any of the accused has been mentioned, but only it is mentioned that assault was made by 7 unknown persons. On perusal of the post-mortem report, wherein it is disclosed that the vertical fracture of mandible present over lower lateral incisor on right side. Apart from that, fractured bone end shows extended extravasations. MRI brain plane mild shown facial injuries. Having taken note of the injury so far as cause of death is concerned, it is clear that death is due to coma as a result of head injury. The very contention of the petitioner counsel that name was not found in the FIR. And I've already pointed out that specifically 7 persons assailants assaulted. And the same is mentioned, but names are not mentioned. And eyewitnesses statements were also recorded before the learned magistrate. And no doubt, no recovery is also made at the instance of this petitioner as contended by the petitioner counsel. But the fact is that an allegation is made against this petitioner as well as other accused persons, all are the part of unlawful assembly and assaulted mercilessly and also assaulted with plastic chair. And court has to take note of the injuries found on the PM report and the cause of death is on account of head injury. When the eyewitnesses CW 11 to 16 speaks with regard to the very presence of this petitioner and also the war act that dragged along with accused number 1 and 2, the victim, and all of them have assaulted her. And cause of death is also on account of multiple injuries sustained by him, particularly the head injury. I do not find any force in the contention of the petitioner counsel to enlarge this petitioner on bail. The counsel also would submit that. 17 days. The counsel also submits that the death was taken place after 17 days. But he was in the hospital. He was in the hospital only. But he was in the hospital after he had sustained injuries. And the apex court also in the judgment reported in Kumair Singh versus State of Rajasthan and another in 2021 Criminal Law Journal 4244. Wherein in paragraph number 14, the apex court, while setting aside the bail order granted by the High Court, categorically held that it is required to be noted that all the accused are charged for the offences punishment of section 302 and 307, read with section 149 of IPC. In the case on hand, also the offences under section 143 also invoked. And when such being the material on record, and when the cause of death is on account of head injury, as a result of injuries sustained by him, the individual role of the accused is not required to be considered when they are alleged to have been the part of unlawful assembly. And hence, I do not find any force in the contention of the petitioner that no recovery. And it is not the case of the prosecution also inflicted injury with any weapon by this petitioner. And question of recovery doesn't arise, but only sharing of common object in eliminating. And the motive is also that there was a galata between accused number 1 and 2 prior to that, and thereafter all of them joined together and part of unlawful assembly and inflicted the injuries. And hence, the very contention of the petitioner counsel cannot be accepted. This court already rejected the bail petition after filing of charge sheet in respect of accused number 5, also who is also similarly placed that he was also the part of unlawful assembly and part of inflicting the injury on the victim. When suspending the circumstances and material, and when there are direct evidence against the petitioner, not a case to enlarge him on bail. The other contention that the accused number 4 and 6 have enlarged on bail by the trial court and the said order has not been placed before the court either by the petitioner, counsel, and also the counsel appearing for the state. And enlarging of other accused persons is also not a precedent. Petitioner. Is accused number 11. What is the material against him? Charge sheet agide illa agide. Go to charge sheet. Hmm. 40 and only I am reading. Hmm. 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 Then roll in vote act any. ಏನ್ರಿ ಏರ್ ಲೆವೆಲ್ ಮೇಲೆ ಏನ್ರಿ ಅಲಿಗೇಷನ್? ಎಲ್ಲರೂ ಸೇರಿಕೊಂಡು ಹಣ ತರಿಸುವಂತೆ ರಾತ್ರಿಯೆಲ್ಲ ಕುಮಾರ್ ಮತ್ತು ವಿಜಯ್ ಕುಮಾರ್ ಹಲ್ಲೆ ಮಾಡಿ ಹಿಂಸೆ ನೀಡಿದ್ದು 11 ಆರೋಪಿಗಳನ್ನು ಸ್ಥಳಕ್ಕೆ ಕರೆಯಿಸಿಕೊಂಡು ಕೂಗಾಟ ಕಿರುಚಾಟ ಮಾಡುತ್ತಿದ್ದರಿಂದ ದಿನಾಂಕ 7 ಬೆಳಗ್ಗೆ ಆರೋಪಿಗಳು ಕುಮಾರ್ ಅಲಿಯಾಸ್ ಮುಖವನ್ನು ಬ್ಲಾಂಕೆಟ್ ನಿಂದ ಮುಚ್ಚಿ ಕಾಲಿನ ಹಿಂಬದಿಯ ಸೀಟಿನ ಮಧ್ಯದಲ್ಲಿ ಮಲಗಿಸಿಕೊಂಡು ಕಾಲುಗಳನ್ನು ನೈಲಾನ್ ಹಗ್ಗದಿಂದ ಕಟ್ಟಿ ಕಾರಿನಲ್ಲಿ ಸುತ್ತಾಡಿಸುತ್ತಾ ಹಣ ತರಿಸುವಂತೆ ಹಲ್ಲೆ ಮಾಡಿದ್ದು, ಹಣ ತರಿಸದೆ ಸತಾಯಿಸುತ್ತಿದ್ದರಿಂದ 4 ಡಾಂಗಲ್ ಬಳಸಿ ವಾಟ್ಸ್ಆಪ್ ಕಾಲ್ ಮೂಲಕ ಆರೋಪಿಗಳಿಗೆ ಕರೆ ಮಾಡಿ ಕುಮಾರ್ ವಿಜಯ್ ಕುಮಾರ್ ಈತನ ಹಣ ತರಿಸಿದ ವ್ಯವಸ್ಥೆ ವಿಚಾರವನ್ನು ತಿಳಿಸಿ ಈತನನ್ನು ಬಿಟ್ಟರೆ ಈತನ ನಮಗೆ ತೊಂದರೆ ಆಗ್ತದೆ, ಕ್ರಮ ಮಾಡುತ್ತೆ ಎಂದು ತಿಳಿಸುತ್ತಾನೆ. ಒಂದು ಆರೋಪಿಯು ಕುಮಾರ್ ವಿಜಯ್ ಕುಮಾರ್ ಸಾಯಿಸಿ ಸವಾಸಿಗರಂತೆ ವೇತನ ಪ್ರಯತ್ನ ಸೂಚಿಸಿತ್ತು. ಅದರಂತೆ ಆರೋಪಿಗಳು ಕುಮಾರ್ ವಿಜಯ್ ಕುಮಾರ್ ಕಾರಿನೊಳಕ್ಕೆ ಹಾಕಿಕೊಂಡು ಕೈಗಳಿಂದ ಹೊಡೆದು ಕಾಲುಗಳಿಂದ ತುಳಿದು ಸಾಯಿಸಿ ಕೊಲೆ ಮಾಡಿರುತ್ತಾರೆ. ಕೃಷ್ಣಗಿರಿ ಜಿಲ್ಲೆ ವೇಪನಹಳ್ಳಿ ತಾಲೂಕು ವೇಪನಹಳ್ಳಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಕೊಂಗನಹಳ್ಳಿ ಗದ್ದಪರ್ತಿಯ ಗೌಡ ಮೇಲೆ ಬಾಳೆ ಎಲೆಯ ತರಗಳನ್ನು ಮುಚ್ಚಿ ಬಂದಿರುತ್ತಾರೆ. ಏನ್ ಕೇಸ್ ಇಸ್ ರೆಸ್ಟ್ ಅಪಾನ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್ ಏನ್ರಿ? This? 46 ಓದ್ತಾ ಇದ್ದೀನಿ. Hmm. Hmm. ಅಲ್ಲ ಆಯ್ತು ಮರ್ಡರ್ ಮಾಡಿದ್ರು ತಗೊಂಡೋಗಿ ಬಿಸಾಕಿದ್ರು ಬಂದ್ರು ಈಗೇನು ಆಯ್ತು ಆಯ್ತು ಫಾರೆಸ್ಟ್ ಏರಿಯಾದಲ್ಲಿ ಮಾಡಿ ಬಂದ್ರು ಈಗೇನ್ ಮೆಟೀರಿಯಲ್ ಏನು ಎಗನೆಸ್ಟ್ ಹಿಮ್ ರಿಕವರೀಸ್ ಏನಾರು ಆಗಿದೆಯಾ ಬಾಡಿ ಯಾರ ಕಡೆಯಿಂದ ರಿಕವರಿ ಆಗಿದ್ದು ಆಯ್ತು ಎಗನೆಸ್ಟ್ A1 ಹಾ had taken the deceased. The body ಎಲ್ಲಿ ರಿಕವರಿ ಆಗಿದೆ ಯಾರ ಕಡೆಯಿಂದ ಅಂತ ಇನ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ಡಿಸ್ಕವರಿ ಆಫ್ ದಿ ಬಾಡಿ ಯಾಕೆಂದ್ರೆ ಯಾವ್ದೋ ನಿರ್ಜನ ಪ್ರದೇಶಕ್ಕೆ ತಗೊಂಡೋಗಿ ಹಾಕ್ತಾರಲ್ಲ A1 and 3 na A1 and 3 shown the ಬುಲೆಟ್ ಬೈಕ್ ಅನ್ನು ಅಮಾನತುಪಡಿಸಿಕೊಂಡು ಮಾಲನ್ನು ಅವನ ಬೈಕ್ ನು ಕೂಡ ಸೀಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ A1 A3 ಇಂದ A5 A8 ಆರೋಪಿಗಳಿಂದ ಕೃತ್ಯಕ್ಕೆ ಉಪಯೋಗಿಸಿದ ಮೊಬೈಲ್ ಫೋನ್ಗಳನ್ನು ಅಮಾನತುಪಡಿಸಿಕೊಂಡು ಮಾಲಪಟ್ಟಿ ಸಂಸ್ಥೆಯಲ್ಲಿ ಕೃತ್ಯಕ್ಕೆ ಉಪಯೋಗಿಸಿದ ಜುಪಿಟರ್ ಸ್ಕೂಟರ್ ಅನ್ನು ಅಮಾನತುಪಡಿಸಿಕೊಂಡು absconded. This man is absconded. ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ವ ಮನೇಲೆ ಇದ್ದಾರ ಮನೇಲಿ ಇದ್ದ ಅಂತ ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ಆಧಾರ್ ಕಾರ್ಡ್ ಇರುತ್ತೆ ಆಧಾರ್ ಕಾರ್ಡ್ ಇದ್ರೆ ಮನೇಲಿ ಇದ್ದ ಅಂತಲ್ಲ ತೊಳಿ ಮೇಡಮ್ order the petitioner counsel and also the counsel appearing to the state. The case of the prosecution is that the victim was the accused in crime number 180 of 2017. And he was in jail from 7/12/2017 to 22/2/2018. And he came to know about accused number 1, who was also in jail in crime number 220 of 2015. For the offense punishment from 392 of IPC. And he was also in custody from 4/12/2017 to 3/2/2019. And developed the acquaintance with each other. The victim disclosed that he is a financier with accused number 1. And also he had promised that he would help him after he was enlarged on bail. And he came out from the jail and other accused number A2, A3, A4, A5, A6 and A7 were also accused in other crime. And they developed the acquaintance with accused number 1. and came out from the jail. The A1 contacted the victim that he had taken the money from him and to repay the same. And victim called him twice or thrice to his house, but he did not repay the amount. And hence ill will was developed between them. And victim also informed him that he is purchasing the property for worth of rupees 3 crores. And hence A1 had the plan that victim is having crores of rupees and planned along with other accused persons. And using the internet dongle, made for WhatsApp call. And at the instance of accused number 3, victim was apprehended and he was kept in their custody from 5/7/21. And accused number 3, along with accused number 1 and 4, took him to different places in his Skoda car. And also secured the other accused persons, including this petitioner. And all of them were touch with each other. And when the victim did not get the money, all this petition, all the accused assailants, including this petitioner, committed the murder and thrown the body in a remote place in a forest. The complainant wife, the victim wife, had lodged the complaint against accused number 1. And missing complaint was also registered at the first instance, and thereafter body was recovered at the instance of accused number 1 and 3. And voluntary statement of other co-accused also recorded, and this petitioner is absconding from the date of the offense. And police have also investigated the matter and filed the charge sheet showing this petitioner as absconded. The petitioner, invoking section 438 of CRPC before this court, the counsel would vehemently contend that this petitioner was not involved in any such crime, and he has been falsely implicated in the case, and no any material before this court. And recovery is also made at the instance of other accused persons. And only on the statement of co-accused statement, this petitioner has been implicated as accused number 11. And hence there are no material against this petitioner. For contra, the counsel appearing to the state would submit that this petitioner is absconded and hence no recovery was made at the instance of this petitioner. And specific allegation is made against this petitioner also. He was also the part of conspiracy and also in kidnapping the victim, who committed the murder and screened the evidence by throwing the body in the dense forest area. And hence, when an heinous offense of murder is committed by committing an offense of kidnapping, the petitioner is not entitled for bail. Having heard the respective counsel and also on perusal of material, no doubt case is based upon the circumstantial evidence. And also allegation in the charge sheet is that this petitioner is also the part of conspiracy and also eliminating the victim when he did not get the money when he was kidnapped. And specific allegations also made that the victim was taken in the Skoda vehicle, and this petitioner was also along with this other assailants in the said vehicle and committed the murder and destroyed the body, throwing the same in a dense forest area. And body was also secured at the instance of accused number 1 and 3. And the same is a discovery. And when such serious allegations are made, and also when this petitioner is also the part of in eliminating the victim, when he did not pay the amount, it is not a fit case to exercise the discretion by exercising the powers of 438 of CRPC when an heinous offense of murder is alleged against the petitioner. The counsel would submit that petitioner also produced the Aadhaar card and he is in the house itself and he has not absconded as contended by the prosecution. And the said contention cannot be accepted mere filing of Aadhaar card. This court cannot come to the conclusion that this petitioner is not absconded. And in an heinous offense of committing the murder, the presence of the petitioner is required. And hence not a case for exercising the discretion of the you have the discussions made above, bail petition is rejected. 64. By mistake ಹೆಂಗ್ರಿ ಆಗ್ತದೆ ಆಡಿಯೋ ಬಟನ್ ಹೆಂಗ್ ಆಗ್ತದೆ ಮಿಸ್ಟೇಕ್ ಹೆಂಗ್ ಆಗ್ತದೆ ಅಂದೆ ಏನ್ ಆಡಿಯೋ ಬಟನ್ ಓದ್ತಾರೆ ಕಾರಲ್ಲಿ ಕುತ್ಕೊಂಡು ಕೋರ್ಟ್ಗೆ ಅಪಿಯರ್ ಆಗಕ್ಕೆ ಎಲ್ಲಿದೆ ಪ್ರಾವಿಷನ್ ವೇರ್ ಇಸ್ ದಿ ಪ್ರಾವಿಷನ್ ಆಯ್ತು ಹೇಳಿ ಏನು ಮಧುಕರ್ ದೇಶಪಾಂಡೆ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ MA ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಇದೆ ಅಲ್ರಿ ಏನ್ರಿ ಎಷ್ಟ್ ಸರಿ ಇಡ್ರಿ ಟೈಮ್ ಕೊಡೋದು ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ MA ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಲಿಸ್ಟ್ ಆಗಿತ್ತಲ್ಲ ನಿಮ್ಗೆ MA ಫೈಲ್ ಮಾಡಕ್ಕೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ಗೆ ನೋಡಿ ಮೇಡಮ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ MA ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಇದೇ ಮ್ಯಾಟ್ರು Madhukar Deshpande is directed to take notice for the respondent. Learned counsel petition is directed to serve the copy of the petition and its enclosures on the learned counsel for the respondent forthwith. Last time ಆಗಿರೋದು ಇದು ಆರ್ಡರ್ 23/5 ಅಲ್ಲಿ why one time ಏನ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ರೀ MA ಫೈಲ್ ಮಾಡಕ್ಕೇನ್ರಿ ಮತ್ತೆ 24/5 ಅದೇ ಆರ್ಡರ್ ಆದ್ ನೆಕ್ಸ್ಟ್ ಡೇ ಮಾಡಿದಿರಿ ನೀವು ಆಯ್ತು ನೋಡ ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ ಅವ್ರು ಟೈಮ್ ಕೇಳ್ತಾ ಇದಾರಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಎಷ್ಟು ದಿವಸ ಬೇಕ್ರಿ ಯಾಕೆ ವೈ ವಾಂಟ್ ವೀಕ್ ಏನ್ ಸಮ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಏನ್ರಿ ವಾಟ್ ಇಸ್ ದಟ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ವೆನ್ ಯು ಹ್ಯಾವ್ ಬೀನ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಸೀನಿಯರ್ ಆದ್ರೆ ನಿಮ್ ಸೀನಿಯರ್ಗೆ ಏನ್ ಬೇರೆ ಸಪರೇಟ್ ಕೋಡ್ ಇದೆಯಾ ಮತ್ತೆ ವೇರ್ ಇಸ್ ಈ ನೌ ವೈ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಫೈಲ್ಡ್ MA ಆಯ್ತು ಬೇರೆ ಡೈರೆಕ್ಟ್ ಮಾಡೋಣ ಬಿಡಿ ನಿಮ್ಗೆ ಯಾಕೆ ಡೈರೆಕ್ಟ್ ಮಾಡ್ಬೇಕು MA ಆಲ್ಸೋ ನಾಟ್ ಫೈಲ್ಡ್ you have been directed to take notice on 23rd itself. Why you have not filed MA till date? MA ಫೈಲ್ ಮಾಡಕ್ಕೆ ನಿಮ್ದೊಂದು ಸೈನ್ ಮಾಡಕ್ಕೂ ನಿಮ್ ಸೀನಿಯರ್ ಟೈಮ್ ಇಲ್ವಾ ಅಲ್ಲ MA ಗೆ 40 ಸಿಗ್ನೇಚರ್ ಬೇಕಾಗಿಲ್ಲ ಏನಿಲ್ಲ ಒಂದು MA ಫೈಲ್ ಮಾಡಕ್ ನೀವೇನ್ ಮಾಡ್ತೀರಿ ಆಫೀಸಲ್ಲಿ ಒಂದು MA ಸೀನಿಯರ್ ಕೇಳಿ ಒಂದು ಸೈನ್ ಮಾಡಿಸ್ಕೊಂಡು ತಗೊಂಡ್ಬಂದು ಹಾಕಕ್ಕಲ್ವಾ ಆಫೀಸ್ಗೆ That madam, respondent counsel seeks time to file MA and 1 week time to file objections. This matter on. 180 days ಆದ್ರೆ ಆಯ್ತು ನೀವು ಬಂದಿರೋದೇ ಕೋರ್ಟ್ಗೆ ಈಗ ಅಲ್ವಾ ಬಂದಿರೋದೇ ಕೋರ್ಟ್ಗೆ ಈಗ ಲಾಸ್ಟ್ ವೀಕ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅಷ್ಟೇ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಎಷ್ಟು ಮೇಡಮ್ 6th ಸರಸ್ವತಿ ಎನ್ This petition, the petitioner counsel is absent and earlier occasion also counsel was absent. ಮಾಡಿದೀವ ನೋಡಿ. And same order in ಬಾಕಿದೆಲ್ಲ ಮಾಡ್ತೀವಲ್ಲ, will be dismissed in the next date of hearing 6th June. Petition file ಮಾಡೋದು ಕೋರ್ಟಿಗೆ ಬರಂಗಿಲ್ಲ. ಸೋಹಾನಿ ಹೊಳ್ಳ, ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಇವ್ರು ಯಾಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿಲ್ಲಲ್ರಿ? ನಾರ್ಮಲಿ ಅಸಿಸ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ವಾ? ಬೇಲ್ ಆಗಿ ಮತ್ತೆ ಈಗೇನಕ್ ಬಂದವ್ರು ಕೋರ್ಟಿಗೆ? ಅಂದ್ರೆ ಈಗ ಅಲ್ಲಿ ಬೇಲ್ ಆಗಿದೆ, ಇಟ್ ಬಿಕಮ್ಸ್ ಇನ್ಫ್ರಕ್ಚುಯಸ್. ಕರೆಕ್ಟ್ ಆಗಿದೆ ನಿಮ್ ಪ್ರಕಾರ? ಡೇಟ್ ಹೇಳ್ಬಿಡಿ. ದಿ ಕೌನ್ಸಿಲ್ ಅಫೇರಿಂಗ್ ಟು ದ ಸ್ಟೇಟ್ ವುಡ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ the HCGP would submit that already bail granted by the trial court. Trial date idea? Granted by the trial court, and petitioner petitioner who is representing through amicus curiae is also not assisting the court and also not made any submission. And earlier occasion also counsel was absent. And in view of the submission of HCGP, petition is dismissed for non-prosecution as infructuous. Idea special case number? Special case I3 date of order. 4/4 all order ತಗೋಬಿಡಿ. Bail has been granted with order dated 4/4/22 ಅಂತ ಹಾಕ್ಬಿಡಿ. ಗಜೇಂದ್ರ ಸಿವಿ ಈ ಮನುಷ್ಯನು ಕೋರ್ಟಿಗೆ ಬರೋದೇ ಇಲ್ಲ. ತಗೊಳ್ಳಿ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ ಅಲ್ವಾ? 2 ಸರಿ ಹಾಕಿದ್ಯಾ? ತಗೊಳ್ಳಿ. This matter listed on several occasions. And that on 21/4/22 the counsel was absent. And again matter was listed on 23/5/2022. And again counsel was absent. And hence it appears the petitioner counsel is not interested in pursuing the matter and hence petition is dismissed for non-prosecution. Chandra Hasarai. ಹೇಳ್ರಿ ಏನು? A1. See? Connected, how it is connected? Same crime or different crime? Wife, husband and wife. A1 and A2. A1 and A2. Separate crime. Separate crime. First in the ಹೇಳ್ಬಿಡಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಬೇರೆ ಮಿಕ್ಸ್ ಮಾಡೋದು ಬೇಡ. If same crime I can consider together. They confessed that they are Bangladesh resident of Bangladesh, national of Bangladesh. Indian passport and Aadhaar card and they went to Maldives. Maldives they read about reported back because of their holding. They are not holding the gold certificate, not because of pride. So on confession they go and charges to investigate and charges filed. But they could not produce that the passport is not available. Only on the basis of their confession that they are Bangladesh national. They came without any document in 2007, and they are still, and thereafter they are working here. First they were in Mumbai, later they shifted to Surat. In Surat they obtained all these documents and they went to Maldives on work permit. And they reported back. That is their idea. They are not having any criminal activities. They're having one small child also. That's the conclusion. They're not holding any criminal activities. Only allegation that they have obtained fraudulently, but the government failed to produce any document stating that these passports are
are not working. What I do, they are 25/9/2021. They are
What is it? How you come to know that his name is different? Ismail Hussein ಆಗಿದ್ದು ಅಕ್ರಮವಾಗಿ ಭಾರತಕ್ಕೆ ಬಂದು ನೆಲೆಸಿದ್ದು ಮರೆಮಾಚಿ ಇಸ್ಮಾಯಿಲ್ ಹಬೀಬ್ ಶೇಖ್ ಎಂಬ ಹೆಸರಿನಲ್ಲಿ ಭಾರತೀಯ ಆಧಾರ್ ಕಾರ್ಡ್ ಮಾಡಿಸಿಕೊಂಡು ಸದರಿ ಮಾಹಿತಿಯನ್ನು ಬಳಸಿ ಸೂರತ್ ಪಾಸ್ಪೋರ್ಟ್ ಕಚೇರಿಯಲ್ಲಿ ಭಾರತೀಯ ರಹದಾರಿ ಪತ್ರ anyhow he has obtained Aadhaar card. Based on the Aadhaar card only he got it registered passport. Similar case? Forgery ಹೆಂಗ್ ಅಟ್ರಾಕ್ಟ್ ಆಗುತ್ತ್ರಿ ಇದರಲ್ಲಿ? 465 468 fail to prove ಎಲ್ಲ ಮಾಡೋದೆಲ್ಲ ಟ್ರಯಲ್ ಆದ್ಮೇಲೆ ಕೌನ್ಸಿಲ್ ಪ್ರೂವ್ ಮಾಡೋದೆಲ್ಲ ಟ್ರಯಲ್ ಆದ್ಮೇಲೆ ಈಗಲ್ಲ. anyhow now he is in India only ಅಲ್ವಾ, ಸೆಟ್ಲ್ ಆಗಿದ್ದಾರೆ, ಆಧಾರ್ ಕಾರ್ಡು ಎಲ್ಲ ಇದೆ. ಎರಡು ಒಟ್ಟಿಗೆ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದ ಬೇರೆ ಬೇರೆ ದಿವಸ? ಸೇಮ್ ಡೇಟ್. ಸೇಮ್ ಸಿಮಿಲರ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಒಂದು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೇನೆ, ಅದ್ರ ವೈಫ್ ಇದರಲ್ಲಿ ಇದೆ, ಟ್ರೈನ್ ನಂಬರ್ ಮಾತ್ರ ಚೇಂಜ್. ಟ್ರೈನ್ ನೋಡ್ಕೊಳ್ಳಿ 68 and 69. The factual matters of the case of the prosecution is that on 24/9/2021 night at 8 p.m. this petitioner traveled from Maldives to KIAL, and when the CW4 inquired, and they revealed, and the petitioner revealed that he is national of, he is Agutal, she is Agutal, national of Bangla, and his name is Ismail Hussein, and he came to India in 2007 itself and obtained Aadhaar card and got the passport in the name of Ismail Habib Sheikh, and using the passport and he went along with his wife to Maldives and returned. In spite of he was a national of Bangladesh, suppressed his nationality and obtained the documents. And based on the created documents, obtained the passport. And hence invoke the offence punishment on section 465, 468, 471 of IPC and section 12(1)(a), small a of Passport Act and 14(b) of Foreigners Act. The council would suppose that this petitioner came to India in 2007 itself, and thereafter obtained passport and travelled as Maldives along with his wife, and not indulged any such act of forgery. And based on the genuine document only, passport was obtained, and a false case has been registered without any proof. The council also relied upon the order passed by this court with the 21st day of August 2019 in Penal Petition number 4054 of 2019. In similar circumstances, granted bail. And in another case in Penal Petition number 6401 of 2019, dated 29th day of June 2020. Similar offences are also invoked. The council also relied upon the other order passed by this court, dated 19th day of May 2020, Penal Petition number 6578 of 19. And similar offences are invoked and enlarged and bail. Hence, petitioner may be enlarged and bail. For contrary, the council appearing to the state would submit that suppressed the nationality of the petitioner and obtained the Aadhaar card, and based on that Aadhaar card obtained passport and travelled from India to Maldives, and indulged in committing an offence of creation of document and violation of Passport Act as well as Foreigners Act. Having heard the respected council and also on perusal of petition available on record, the fact reveals that this petitioner is in India from 2007 and also travelled from India to Maldives on several occasions. Only on the based on the voluntary statement of the petitioner, invoke the offences against the petitioner, and prosecution also not disputes the fact that Aadhaar card was also obtained, and based on the Aadhaar card got the passport. When assessing the material available on record, the allegation is that he is a foreign national and suppressed the fact and obtained the passport fraudulently, and the same is a matter of proof. And this petitioner is in custody from the date of arrest, and when assessing the material on record, petitioner may be enlarged on bail, since this court also earlier occasion enlarged the accused who are similarly placed with conditions. ಅದನ್ನ ಹಾಕೊಳ್ಳಿ, ಅದನ್ನ ಇದು ಮಾಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ಜೆಂಡರ್ ಮಾತ್ರ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು, he or she ಅಂತ ಬಂದಾಗ ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಸೇಮ್ 70 ಪ್ರವೀಣ್ ಸಿ.
For this, for petitioners in this case, my lord.
This counsel.
Lord, this is a bail application filed under section 439.
By A1. 302(1). ಹೇಳಿ.
A4 has been released by this honorable court in criminal petition 6597 by 2021. 6597 son.
97 of 21. ಏನ್ ಗ್ರೌಂಡ್ ಏನ್?
ಅವರು ಕಾರಿನ ಡ್ರೈವರ್ ಅಂತ ಈಸ್ ಬಿನ್ ರಿಲೀಸ್.
ಡ್ರೈವರ್ ಮಾತ್ರ ಅಂತ.
ಹೌದು.
ಮೇಲೆ ಅಲಿಗೇಷನ್ ಏನು?
ಸ್ವಾಮಿ, the complaint I produced at page number 12.
ಕಂಪ್ಲೇಂಟ್ ಬೇಡ, ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹೋಗಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಗೋ ಟು ಪೇಜ್ ನಂಬರ್ 50.
My lord, there are two eyewitnesses to this. The page number 79 I produced the charge sheet. In that the eyewitness statement has been recorded.
79.
Also. My submission to this honorable court before reading the statement, there is a delay in recording the eyewitness statement of 5 days.
5 days.
Also. Ad bitre bere enu merits mele enu case illa. The only contention urging before this my lord is that there is a delay of 5 days registering the recording the statement. May I read the eyewitness statement, my lord? ನಾನು ಮೇಲೆ ತಿಳಿಸಿದ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ ತಂದೆ ತಾಯಿಯೊಂದಿಗೆ ವಾಸವಾಗಿರುತ್ತೇನೆ. ನಾನು ಗುಡ್ಡೇನಹಳ್ಳಿಯ ಅಭಿಲಾಷ್, ಹೊಳೆತಿಮ್ಮನಹಳ್ಳಿ ಮನೋಜ್ ಗೌಡ ಅಲಿಯಾಸ್ ಹೊಲಿಗೆ, ಕೆಂಚಮಾರ್ನಹಳ್ಳಿ ಶಶಾಂಕ್, ಬೇಲೂರಿನ ತೇಜಸ್, ದಟ್ ಈಸ್ A1 ಪ್ಲೀಸ್, ಮತ್ತು ಗೌರಿ ಕೊಪ್ಪಲಿನ ರೋಹನ್ ಎಲ್ಲರೂ ಕ್ರಿಕೆಟ್ ಆಟ ಆಡುವಾಗ ಪರಿಚಯವಾಗಿ ಎಲ್ಲರೂ ಸ್ನೇಹಿತರಾಗಿರುತ್ತೇವೆ. ದಿನಾಂಕ 4/4/2021 ನಾನು ಮತ್ತು ನನ್ನ ಸ್ನೇಹಿತರಾದ ರೋಹನ್ ಇಬ್ಬರಿಗೂ ಹಾಸನದ ಹೈಸ್ಕೂಲ್ ಗ್ರೌಂಡಿನಲ್ಲಿ ಆಟವಾಡುತ್ತಿದ್ದಾಗ ಅಲ್ಲಿಗೆ ಸಂಜೆ ಸುಮಾರು 6 ಗಂಟೆ ವೇಳೆಗೆ ತೇಜಸ್ ಬಂದರು. ತೇಜಸ್ ಅವರಿಗೆ ತಲೆ ಏಟಾಗಿತ್ತು. ನಾವು ವಿಚಾರ ಮಾಡಿದಾಗ ಯಾವುದೋ ಹುಡುಗಿಯ ವಿಚಾರದಲ್ಲಿ ದೊಡ್ಡ ಮಂಡಿಗನಹಳ್ಳಿ ಮನೋಜ್, ಗಾಂಡು ಮನು, ದಟ್ ಈಸ್ ದಿ ಡಿಸೀಸ್ ಮೈ ಲಾರ್ಡ್, ಮತ್ತು ರಾಘುಗೌಡ ಅವರು ಕಡೆಯವರು ಸೇರಿ ಹೊಡೆದರೆಂದು ತಿಳಿಸಿದರು. ಸ್ವಲ್ಪ ಹೊತ್ತಿನಲ್ಲಿ ಶಶಾಂಕ್, ಮನೋಜ್ ಗೌಡ ಅಲಿಯಾಸ್ ಹೊಲಿಗೆ ಮತ್ತು ಅಭಿಲಾಷ್ 3 ಜನರು ಶಶಾಂಕ್ ರವರ KA02 ME 8189 ನಂಬರಿನ ಸ್ಯಾಂಟ್ರೋ ಕಾರಿನಲ್ಲಿ ನಾವು ಇದ್ದ ಹೈಸ್ಕೂಲ್ ಗ್ರೌಂಡಿಗೆ ಬಂದರು. ತೇಜಸ್ ನನಗೆ ಹೊಡೆದ ಬಗ್ಗೆ ಅವರಿಗೆ ತಿಳಿಸಿ ತೇಜಸ್ ಅಲಿಯಾಸ್ ತೇಜು, ಶಶಾಂಕ್, ಮನೋಜ್ ಮತ್ತು ಅಭಿಲಾಷ್ 4 ಜನರು ನಮ್ಮಿಂದ ಸ್ವಲ್ಪ ದೂರ ಹೋಗಿ ಏನೋ ಮಾತನಾಡಿಕೊಂಡರು. ಅನಂತರ ನಾವು 6 ಜನರು ಶಶಾಂಕ್ ರವರ KA02 ME 8189 ನಂಬರಿನ ಸ್ಯಾಂಟ್ರೋ ಕಾರಿನಲ್ಲಿ ಕುಳಿತುಕೊಂಡೆವು. ಶಶಾಂಕ್ ರವರು ಕಾರನ್ನು ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದು ಹಾಸನ ಟೌನಿನಲ್ಲಿ ಎಲ್ಲಾ ಕಡೆಗಳಲ್ಲಿ ಸುತ್ತಾಡಿದೆವು. ಕಾರಿನಲ್ಲಿ ತೇಜಸ್, ಶಶಾಂಕ್, ಮನೋಜ್ ಮತ್ತು ಅಭಿಲಾಷ್ 4 ಜನರು, ಮನೋಜ್ ಅಲಿಯಾಸ್ ಗಾಂಡು ಮನು, ಈಸ್ ದಿ ಡಿಸೀಸ್ ಮೆಲೋಡ್, ಸಾರಿ, ಮತ್ತು ರಘುಗೌಡ ಎಂಬುವರು ಎಲ್ಲಿಯಾದರೂ ಇದ್ದಾರೆಯೇ ನೋಡಿ ಎಂದು ಹೇಳುತ್ತಾ ಕಾರಿನ ಕಿಟಕಿಗಳಿಂದ ಸುತ್ತಮುತ್ತ ನೋಡುತ್ತಿದ್ದರು. ರಾತ್ರಿ ಸುಮಾರು 8:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಹಾಸನದ ಸಾಲುಗಾಮೆ ಗೇಟ್ ಕಡೆಯಿಂದ ಹೊಸಲೈನ್ ರಸ್ತೆಯಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದಾಗ ಪುಷ್ಪಗಿರಿ ಹಾಸ್ಟೆಲ್ ಮುಂಭಾಗ ರಸ್ತೆಯ ಬದಿಯಲ್ಲಿ ಬಾಗಿಲು ಮುಚ್ಚಿದ್ದು ಒಂದು ಅಂಗಡಿ ಮಳಿಗೆ ಮುಂಭಾಗ ಮನೋಜ್ ಅಲಿಯಾಸ್ ಗಾಂಡು ಮನು ಕುಳಿತಿದ್ದನ್ನು ನೋಡಿದ ತೇಜಸ್ಸು, ಗಾಂಡು ಮನು ಇಲ್ಲಿಯೇ ಕುಳಿತಿದ್ದಾನೆ, ಕಾರನ್ನು ನಿಲ್ಲಿಸು ಎಂದು ಹೇಳಿದ ತಕ್ಷಣ ಶಶಾಂಕ್ ಕಾರನ್ನು ನಿಲ್ಲಿಸಿದರು. ತಕ್ಷಣ ತೇಜಸ್, ಶಶಾಂಕ್, ಮನೋಜ್ ಮತ್ತು ಅಭಿಲಾಷ್ 4 ಜನರು ಕಾರಿನಿಂದ ಕೆಳಗಡೆ ಇಳಿದರು. ನಾನು ಮತ್ತು ರೋಹನ್ ಸಹ ಕಾರಿನಿಂದ ಕೆಳಗಡೆ ಇಳಿದೆವು. ತೇಜಸ್, ಶಶಾಂಕ್, ಮನೋಜ್ ಮತ್ತು ಅಭಿಲಾಷ್ 4 ಜನರು ಮನೋಜ್ ಅಲಿಯಾಸ್ ಗಾಂಡು ಮನು ಅವರವರನ್ನು ಬಲವಂತವಾಗಿ ಎಳೆದುಕೊಂಡು ಬಂದು ಶಶಾಂಕ್ ರವರ ಕಾರಿನಲ್ಲಿ ಮಧ್ಯದ ಸೀಟಿನಲ್ಲಿ ಹಾಕಿಕೊಂಡು ರಘು ಗೌಡನೊಂದಿಗೆ ಸೇರಿಕೊಂಡು ನಮಗೆ ಹೊಡಿತಿದ್ದೀಯಾ, ಈ ದಿನ ನಿನ್ನನ್ನು ಜೀವ ಸಹಿತ ಬಿಡುವುದಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾ ತೇಜಸ್, ಶಶಾಂಕ್, ಮನೋಜ್ 3 ಜನರು ಅಲ್ಲಿಯೇ ಕಾರಿನಲ್ಲಿ ಇಟ್ಟುಕೊಂಡಿದ್ದ ಚಾಕುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು 3 ಜನರು ಚಾಕುಗಳಿಂದ ಮನೋಜ್ ರವರಿಗೆ ಎದೆಯ ಭಾಗಕ್ಕೆ, ಕುತ್ತಿಗೆ ಭಾಗಕ್ಕೆ, ಇತರ ಕಡೆಗಳಿಗೆ ಮನಸೋ ಇಚ್ಛೆ ಚುಚ್ಚಿ ಗಾಯಪಡಿಸಿ ಕೊಲೆ ಮಾಡಿದರು. ಇದನ್ನು ನೋಡಿದ ನಾನು ಮತ್ತು ರೋಹನ್ ಇಬ್ಬರು ಎದುರಿ ಕಾರಿನಿಂದ ಹತ್ತಿರವಾದ ಸಾಲಗಾಮೆ ಗೇಟ್ ಕಡೆಗೆ ಸ್ವಲ್ಪ ದೂರ ಓಡಿ ಹೋಗಿ ನಿಂತುಕೊಂಡು ನೋಡಿದೆವು. ತೇಜಸ್, ಮನೋಜ್, ಅಭಿಲಾಷ್ ಅವರು 4 ಜನರು ಅದೇ ಕಾರಿನಲ್ಲಿ ಕುಳಿತುಕೊಂಡು ಪೆನ್ಷನ್ ಮೊಹಲ್ಲಾ ಕಡೆಗೆ ಹೊರಟು ಹೋದರು. ತೇಜಸ್, ಶಶಾಂಕ್, ಸೋ ಅಂಡ್ ಸೋ ಮೆಲಡ್. ದೇರ್ ಆಫ್ಟರ್ ಇದಾದ ಮಾರನೇ ದಿನ 5/4/2021 ದೊಡ್ಡ ಮಾಂಡಿಗನಹಳ್ಳಿ ಮನೋಜ್ ಅಲಿಯಾಸ್ ಗಾಂಡು ಮನು ಎಂಬಾತನ ಶವವು ಕಂದಲಿ ಸಮೀಪದ ಯಗಚಿ ಹೊಳೆಯ ಹಳೆಯ ಬ್ರಿಡ್ಜ್ ಕೆಳಗಡೆ ಪತ್ತೆಯಾಗಿದ್ದು ಯಾರೋ ಕೊಲೆ ಮಾಡಿರ್ತಾರೆ, ಬಿಸಾಡಿರ್ತಾರೆ ಎಂದು ಜನರು ಮಾತನಾಡುತ್ತಿದ್ದರು. ತೇಜಸ್, ಮನೋಜ್, ಅಭಿಲಾಷ್ ಮತ್ತು ಮನೋಜ್ ಅವರ ಶವವನ್ನು ಕುಂದಲಿ ಸಮೀಪ ಯಗಚಿ ಹೊಳೆಯ ಹಳೆಯ ಬ್ರಿಡ್ಜ್ ಕೆಳಗಡೆ ಬಿಸಾಡಿರುತ್ತಾರೆಂದು ಗೊತ್ತಾಯಿತು. ಈ ದಿನ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಯರು ನನ್ನನ್ನು ನಮ್ಮ ಕಚೇರಿಗೆ ಕರೆಸಿ ವಿಚಾರ ಮಾಡಿದಾಗ 4/4/2021 ತೇಜಸ್, ಮನೋಜ್, ಶಶಾಂಕ್, ಅಭಿಲಾಷ್ ರವರು ಮನೋಜ್ ಅಲಿಯಾಸ್ ಗಾಂಡು ಮನು ರವರನ್ನು ಚಾಕುಗಳಿಂದ ಚುಚ್ಚಿ ಕೊಲೆ ಮಾಡಿದ ವಿಚಾರವನ್ನು ತಿಳಿಸಿರುತ್ತೇನೆ. ಶಶಾಂಕ್ and there are 2 eyewitnesses statement being recorded, my lord, that is 79 and page 81.
Yes.
My submission to this honorable court is these are concocted eyewitnesses to the incident. The incident might have happened on the ill will of as per the narration of this eyewitness, but this petitioner is not directly involved in any such cases, my lord. Second submission is there is a delay of 5 days, my lord. Now, apart from this, there are no much grounds to urge, my lord.
Yes,
on this ground, I am urging the bail.
These witnesses. Knife was recovered from whom? Oh, A1.
And staying in the seat of the car.
Seat cover of car. Car belongs to even again.
This having criminal antecedents, having 3 more cases.
3 more cases. Yeah. Hmm. 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 Good. Good, madam. Order the petition of counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the victim was assaulted. There was a galata between the victim and this petitioner. And hence, this petitioner informed about his friends. And thereafter all joined together and searched the victim in the car. And when the victim was found, this petitioner along with other accused persons inflicted the injury with knife along with other accused, and hence case has been registered and investigated the matter and filed the charge sheet. The counsel appearing for the petitioner submits that there was a delay of 5 days in lodging the complaint.
Recording the eyewitness statement.
Sorry, recording the eyewitness statement. And hence it is clear that the eyewitnesses are created and they have not witnessed any incident. Counsel also submits that no other material is collected during the course of investigation except the alleged 2 eyewitnesses statement. And the reason for not giving any complaint or making statement immediately with the police has not been properly explained by the alleged eyewitnesses. The counsel also admits that investigation has already been completed and charge sheet is also filed. And no material against the petitioner and no need of custodial trial, and the petitioner may be enlarged on bail. For counter, the counsel appearing for the state would submit that knife which was used for committing the murder was recovered at the instance of this petitioner. The counsel also submits that stained seat cover of the car belongs to this petitioner was also recovered. The counsel also would submit that this petitioner is having criminal antecedents and criminal case has been registered against this petitioner for the offence section 295 and in 2 cases, and also offence section 279. And when there are 2 eyewitnesses who have witnessed this incident and they were also along with these assailants at the time of committing the murder, and they ran away from the place being witnessed the incident of murder, inflicting the injury. And hence there is a prima facie case against the petitioner herein. Having heard the respective counsel and also on perusal of material available on record, it is the case of the prosecution that the incident was in connection with this petitioner having grudge against the victim in connection with the girl, and earlier an incident was taken place, and he came and told other assailants about the incident of assaulting him, and due to that said motive searched the victim along with other accused persons, and when found the victim inflicted injury mercilessly with the saps, with the knife. PM report ಇದೆಯಾ? PM report ಇದೆಯೇನ್ರಿ? The PM report discloses Most injuries is there? Multiple external injuries. Well in number, including the stab wound injuries. The cause of death is also due to cardiac tamponade as a result of stab injury. Specific allegation against this petitioner is also that he inflicted injury with knife. And injuries also corresponds with the allegation made against this petitioner. And when there are two eyewitnesses, and also in the statement of eyewitnesses, I have also stated that they were witnessing the incident, they were afraid of the incident, and hence not given the statement immediately. And when there are eyewitnesses to the incident and there is a direct evidence, and post-mortem report also discloses cause of death is also on account of stab injury. And hence I do not find any merit in the petition to enlarge the petitioner on bail. And regarding delays concerned as contended by the petitioner counsel, it is a matter of trial and the same has to be explained during the course of time. In view of the discussions made up, I pass the following order. Bail petition is rejected. Lokanath. ಏನು ಲಾಸ್ಟ್ ಟೈಮ್ ನಾನು FSL ರಿಪೋರ್ಟ್ ಅನ್ನು ತರಿಸ್ಕೊಳ್ತೀನಿ ಅಂತ ಟೈಮ್ ತಗೊಂಡಿದ್ದೀನಿ. ಹಾ ಬಂದಿಲ್ವಾ? ಹಾ ಮತ್ತೆ ಇನ್ಸಿಡೆಂಟ್ ಏನ್ ಡೇಟ್ ಡ್ಯೂ ಡೇಟ್ FSL ರಿಪೋರ್ಟ್ ಇನ್ನು ಬಂದಿಲ್ಲ. ಏನು ಅಲಿಗೇಷನ್ ಏನು? You next to accuse number 1 A1 ಮೇಲೆ ಏನು ಅಲಿಗೇಷನ್ ಮೇನ್? ಯಾರ್ಯಾರಿಗೆ? A2. Cause of death ಏನು? Cause of death strangulation. ಅದೇ strangulation. Other all accused are enlarged on bail. Now why it rejected in respect of this petitioner? What is the material? Case is rest upon circumstantial evidence. ಏನಿದೆ ಸ್ಟ್ರಾಂಗ್? Just before murder. Notice ಏನಾಯ್ತು? ರಿಪ್ಲೈ ಕೊಟ್ರ? ಮತ್ತೊಂದು ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಮರ್ಡರ್ ಮಾಡಿದ್ರು ಅಂತ. ಆಯ್ತು, ಈಗ ಮರ್ಡರ್ ಮಾಡಿದ್ರ ಬಗ್ಗೆ ಏನು ಸರ್ಕಮ್ಸ್ಟೆನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್? ನೋಟಿಸ್ ಒಂದೇನಾ? ಆಯ್ತು. A5 and A3 ಆಯ್ತು. A5 ಯಾರು? A1 and 2 are brothers. Brothers of A5 ಆಯ್ತು. Hmm. 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 ಆಯ್ತ್ರಿ motive ಇದೆ ಸರಿ but what is the material connect him except the notice ಏನಾರ recovery ಏನಾರ ಆಗಿದೆಯಾ A2 and deceased ಹಾ ಹಾ auto belongs to A1 ಹಾ Hmm. 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 ಅವನು victim was the brother-in-law of A1 and A2. Yeah. Hmm. 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 A1 assaulted with club on his head ಅಂತಿದೆ. Hmm. 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 ರಿಕವರಿ ಇದೆಯಾ ಕ್ಲಬ್ ರಿಕವರಿ ಇದೆಯಾ ರಿಕವರಿ ಆಗಿದೆ ಯಾರ ಕಡೆಯಿಂದ ಬ್ಲಡ್ ಸ್ಟೈನ್ ಯಾರ್ದದು A1 ಬ್ಲಡ್ ಸ್ಟೈನ್ ಕ್ಲಾತ್ ಇದೆಯಾ ಹ್ಮ್ 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 FSL ರಿಪೋರ್ಟ್ ಬಂದಿದೆಯಾ ಬ್ಲಡ್ ಸ್ಟೈನ್ ಕ್ಲಾತ್ ಬಂದಿಲ್ಲ ಅದೇ ಅವೈಟೆಡ್ ಅಂತ ಕೋರ್ಟ್ heard the petitioner counsel and also the counsel appearing for the state. The case of the prosecution before the court is that A3 and A5 were having illicit relationship and victim is the husband of A5 and victim was not supporting financially to A5 to perform the marriage of her daughter. The accused number 1 and 2 being the brothers of A5 conspiring with other accused took the victim in an auto rickshaw and this petitioner assaulted with the club on the head of the victim and A2 also inflicted the injury with the club on the forehead. So also A3 on the left hand with the club. When the victim fell down, this petitioner strangulated the victim with his right leg, pressing the same on his neck. And accused number 1 to 4 carried the dead body in an auto rickshaw with an intention to screen the evidence. And kept the body in the auto rickshaw and moved the auto rickshaw with an intention to pretend that it is an accidental death. And hence case has been registered and investigated the matter and filed the charge sheet. The counsel appearing to the petitioner would submit that already accused number 3, 4, 5 have been enlarged on bail. Even A2 also. And this petitioner also placed in the same circumstances. Placed the same circumstances, and this court granted bail to A3 in criminal petition number 9333 of 2021. And Unestano 7045 and A4 granted bail in criminal petition number 7045 of 2021. And Hinando and A5 was granted bail in criminal petition number 5895 of 2021. And hence, on the ground of parity, this petitioner also may be enlarged on bail. For contrary, the counsel appearing for the state would submit that bloodstained cloth of this petitioner was recovered, and club was also recovered, which was used for committing the murder. And specific court act allegation is made against this petitioner that he inflicted injury with club on the head, that is on the vital part. And this court granted bail in respect of accused number 3, considering the bail granted in favor of accused number 4. And allegation is that he had played an active role of kicking the deceased on his private part. And allegation against A4 and the reasons are that the accused number 1 and 2 conspired with other accused and took the deceased along with them for committing the murder. And other accused is not the part of committing the murder, only allegation that A3 and A5 were having illicit relationship with each other. And hence not entitled for on the ground of parity. Having heard the respective counsel and also on perusal of petition available on record, a specific case of the prosecution is that A3 and A5 were having illicit relationship. And A5, there was no any role except the illicit relationship between A3 and A5. And no doubt A2 was also granted bail. And an allegation is made that he assaulted with club on the forehead. But allegation against this petitioner is that he inflicted injury with club on the head of, that is on the vital part of the victim. And also weapon was recovered. And apart from that, bloodstained cloth of this petitioner was also seized. And FSL report is awaited. And granting of bail to other accused persons is not a precedent to enlarge this petitioner, since specific allegation is made against this petitioner that he conspired with his brother accused number 2 and secured the accused victim through A2 and committed the murder. When the FSL report is awaited with regard to the stained cloth of this petitioner, and when there is a strong circumstances regarding recovery of stained cloth of this petitioner as well as the weapon it was used for inflicting the injury on the head of the victim, at this juncture it is not a fit case to exercise discretion in favor of the petitioner. However, liberty is given to the petitioner to approach this court after receipt of the FSL report. Padri essay. Absent. Yesterday absent. Sorry, no. Absent, na? Good. The petitioner counsel is not pursuing the matter diligently, and in the earlier 2 occasions also not appeared before the court. When the matter was listed on 19/4, madam, time and on 2 occasions took the time. And last occasion absent, and hence one more opportunity is given to the petitioner counsel. If counsel doesn't appear in the next state of hearing, matter will be discussed for non-prosecution. This matter on 6th of June. 73 Harish MG. Ah. Hmm. 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 ಪ್ರೊಟೆಸ್ಟ್ ಕೊಡಕ್ಕೆ ಏನೋ ಕುಡಿಸ್ತೇ ನೀನು ಅಂತ ಹೇಳ್ತಾರೆ. ಏನ್ ರಿಕವರಿ ಸಿಗ್ತದೆ? ಜ್ಯೂಸ್ ಕುಡಿಸಿದ್ರೆ, ಇಂಟಾಕ್ಸಿಕೇಟೆಡ್ ಜ್ಯೂಸ್ ಕುಡಿಸಿದ್ರೆ ಏನು ರಿಕವರಿ ಮಾಡ್ತಾರ್ರಿ? ಕಾರಿನಲ್ಲಿ ಹತ್ತಿ ಇವನ ಜೊತೆ ಹೋಗಲು ಹೊರಟಾಗ ಕಾರಿನಲ್ಲಿ ಒಂದು ಕೂಲ್ ಡ್ರಿಂಕ್ಸ್ ಅನ್ನು ಕುಡಿಯಲು ಕೊಟ್ಟಾಗ ನಾನು ಕುಡಿದ ನಂತರ ಸ್ವಲ್ಪ ಪ್ರಜ್ಞೆ ತಪ್ಪಿದಾಗ ಆಗಿತ್ತು. ನಂತರ ನನಗೆ ಪ್ರಜ್ಞೆ ಬಂದಾಗ ನೋಡಲಾಗಿ ಸುತ್ತ ಕಾಡು ಇರುತ್ತದೆ. ನನ್ನ ಮೈ ಮೇಲೆ ಇದ್ದ ಬಟ್ಟೆಗಳು ಸರಿಯಾಗಿರ್ಲಿಲ್ಲ. ನೀನು ಏನ್ ಮಾಡಿದೆ ಅಂತ ಕೇಳಿದಾಗ ನಾನು ದುರುಪಯೋಗ ಪಡಿಸುತ್ತೇನೆ. ಇನ್ನು ನನ್ನ ಮೊಬೈಲ್ ನಲ್ಲಿ ಫೋಟೋ ವಿಡಿಯೋ ತೆಗೆದಿರುತ್ತೇನೆ ಎಂದು ಹೇಳಿದನು. ಇದನ್ನು ಯಾರಿಗೂ ಹೇಳ್ಬೇಡ ಅಂತ ಹೇಳಿ ಈ ಕಾಸ್ ದಿ ಥ್ರೆಟ್. ಆಯ್ತು, ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ ತಗೊಳ್ಳಿ. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ ರೀ? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಆಗ್ಲೇ. ವೆದರ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಸೆಕ್ಷುವಲ್ ಆಕ್ಟ್ ಆಗಿದ್ದು ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದ ಅವಾಗ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹ್ಮ್ 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 6 ತಿಂಗಳು ಅಂದರೆ ಜುಲೈನಲ್ಲಿ. ಹ್ಮ್ 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 6 ತಿಂಗಳ ಮೇಲೆ ಏನು ಎಕ್ಸ್ಟರ್ನಲ್ ಇಂಜುರೀಸ್ ಇರುತ್ತೆ ಕೌನ್ಸಿಲ್ ಡೋಂಟ್ ಆರ್ಗ್ಯೂ ಲೈಕ್ ಪೊಲೀಸ್ 6 ತಿಂಗಳ ಮೇಲೆ ಏನಿರ್ತದೆ ಇಂಜುರೀಸ್ ಹಾ ಹ್ಮ್ 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 ಏನ್ರಿ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಐಮನ್ ಹ್ಮ್ 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 And then again you made use of the same and started extorting money. ಕಳಿಸಿದ್ನ 164 ಇದೆಯಾ ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಇಲ್ಲೂ ಬಂದಿಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಹಾಕಿ ಯಾವಾಗ ಹಾಕ್ತೀರಿ ನೋಡಿ ವಾಟ್ ದಿ ಪಿಟಿಷನರ್ ತಗೋಬಿಡಿ ನೀವು ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ 6 ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ ನಿಮ್ಮ ಹತ್ರ ತರಿಸ್ಕೊಂಡ್ರೆ ಅಷ್ಟೊಳಗೆ ನೀವು ಚಾರ್ಜ್ ಶೀಟ್ ನ ಆಗಿರ್ಲಿಲ್ಲ ಆಯ್ತು ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಟು ಪ್ಲೇಸ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಮಿಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 6th ನೆಕ್ಸ್ಟ್ ಮಂಡೇ 6 Joseph Joy absent ಇದ್ದಾರೆ ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿ ಹಿಂದಿನ ಅರ್ಲಿಯರ್ ಅಕೇಶನ್ ಕೂಡ ಅಬ್ಸೆಂಟ್ Petitioner counsel is absent. Oh. Bail ಆಗಿದೆ ಅದಕ್ಕೆ ಬರ್ತಾ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ This petitioner counsel was absent on 3 occasions and counsel appearing for the state it submits that already bail has been granted and in view of the submission petition is dismissed as infructuous. K. Shyamasundar. A 1 to 3. Charge sheet ಹಾಕಿದಾರಾ? Case registered against unknown person. Offense ಏನು 307. Unknown 6 persons. Unknown 6 persons. Then substitute state and complaint use of state. ಮೂರು ಜನ ಮಾತ್ರ ಸೈಟ್ ಮಾಡಿ ವಾಪಸ್ ಆಯ್ತು ನಿಮ್ಮವನು ಎಷ್ಟು 1 to 3 ಅಲಿಗೇಷನ್ ನಿಮ್ಮವ್ರ ಮೇಲೆನಾ ಅಥವಾ ಬೇರೆಯವ್ರ ಮೇಲೆ 6 ಜನ ಇದ್ದಾರೆ 1 to 3 ಮೇಲೆ ಏನ್ರಿ ಅಲಿಗೇಷನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಲ್ಲ ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕುವಾಗ ಏನ್ರಿ ಅಲಿಗೇಷನ್ ಅಂದ್ರೆ ಮತ್ತೆ ಅನ್ನೋನ್ ಪರ್ಸನ್ ಅಂತ ಹೇಳಿ ಐ ವಿಟ್ನೆಸಸ್ 1 2 3 4 5 ಐಡೆಂಟಿಫೈ ಮಾಡಿದಾರಾ ಆಮೇಲೆ ಎ ಪೀರಿಯಡ್ ಮಾಡಿಲ್ಲ ಆಮೇಲೆ ಏನ್ ವಾಟ್ ಇಸ್ ದಿ ಕಂಡೀಷನ್ ಇಂಜೂರ್ಡ್ charge sheet is there. Column number 17 charge sheet. What is the condition of the injured? ಆಮೇಲೆ ತಿರ್ಕೊಂಡು ಸತ್ತೋಗಿದ್ದಾನ ಆಮೇಲೆ ಡೈಡ್ ಈ ಡೈಡ್ 307 ಅಂತೀರಿ Injured himself has given the complaint. There are also others also injured. There are 1 to 7 are eyewitnesses. Lots of the blood stains. One and two ಕಡೆ ಸೀಸ್ ಆಗಿದೆ.
First complaint 6% assault ಮಾಡ್ತಾರೆ. All these ಇದೆಲ್ಲ ಎರಡು ಗಾಡಿಯಲ್ಲಿ ಬಂದಿತ್ತು.
ಆಯ್ತು, ಐಡೆಂಟಿಫಿಕೇಶನ್ ಹೆಂಗ್ರಿ ಮಾಡಿದಾರ? ಐಡೆಂಟಿಫೈ ಹೇಗೆ ಮೊದಲು ಅನ್ನೋನ್ ಪರ್ಸನ್ಸ್ ಅಂತ ಆಯ್ತು. ಹೇಗೆ ಹೌ ದೇ ಆರ್ ಇಂಪ್ಲಿಕೇಟೆಡ್? ವಾಟ್ ಇಸ್ ದಿ ಬೇಸಿಸ್ ಫಾರ್ ಇಂಪ್ಲಿಕೇಶನ್? ಫೋನ್ ರೆಕಾರ್ಡ್ಸ್. So these injured persons have identified the assailants in the police station. Phone details ಅಂದ್ರೆ ಏನು? ಅಂದ್ರೆ ಆ ಜಾಗದಲ್ಲ ಟವರ್ ಲೊಕೇಶನ್, ಪ್ಲೇಸ್ ಆಫ್ ಇನ್ಸಿಡೆಂಟ್ ಟವರ್ ಲೊಕೇಶನ್ ಮೇಲೆ one of the witness ಏನ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದಾರ, ಅದನ್ನ ಕೇಳ್ತಾರ. Incident of assault was recorded by one of the victims. Based on that, they have been apprehended and recovery also made. ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಹೇಳಿ, ಆಮೇಲೆ ನೀವು ಹೇಳಿರಂತ್ರಿ. ಎರಡ್ ಶರ್ಟ್ ಹೆಂಗ್ರೆ ಹಾಕತ್ತಾನ ಅವನು? ಒಂದೇ ಹಾಕಬೇಕು. ಅದ ಎರಡ್ ಹೆಂಗೆ ಅಂದೆ? ಒಂದೇನಾ ಅಥವಾ ಬೇರೆ ಒಂದು? ಒಂದ್ಗೆ ಹೆಂಗ್ರಿ ಒಂದ್ ಟೀ ಶರ್ಟ್ ಒಂದ್ ಶರ್ಟ್ ಬರುತ್ತೆ, ಎರಡ್ ಹಾಕೊಂಡಿದ್ನ ಅಂತ ಅದಕ್ಕೆ ಕೇಳಿದ್ವಿ. ಶರ್ಟು ನೈಫು. A2 ಇದೇನ್ ರಿಕವರಿ? A2 ಕಾಮನ್ ರಿಕವರಿ. ಎಲ್ಲಾರ್ದೊಂದು ಮುಚ್ಚಿಟ್ಟಿರ್ತಾರೆ, ಆಮೇಲೆ ಹೋಗಿ ರಿಕವರಿ ಮಾಡಿರ್ತಾರೆ. ರಿಕವರಿ ಮಾಡುವಾಗ ಯಾರು ಇದ್ರು? A1 and 2 ಮಾತ್ರನಾ? All 4 were there at the time of recovery. Recovery of including knife. ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಇದು ಸೀನ್ ಆಫ್ ಇನ್ಸಿಡೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ ಯಾರು? ಮೊಬೈಲ್ ಏನಿದೆ ಮೆಟೀರಿಯಲ್? Who speaks about the recording of scene of occurrence? ಇವನು A3 ಗಾಡಿ ನಿಲ್ಸ್ಕೊಂಡು ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದ ಅಂತ. ಉಳ್ದವ್ರು ಹೊಡೆದ್ರು ಅಂತ. ಆಗಿದೆಯಾ? Conducted TA period. So, heard the petitioner, counsel, and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 12/9/2021 at 10:30 PM, CW1 and victim standing in front of Sri Krishna Industries factory. These petitioners with an intention to commit to extract the money from the people who are proceeding in the road. Came in two-wheeler. And accused number 3 stopped the vehicle and he was watching, and accused number 1, 2, 4 inflicted injury with the knife on the CW1. And accused number 1 inflicted injury on the victim and both CW1 and injured tried to escape from the spot and started running towards the factory. At that time, CW2, 3, 4, 5 and 6 also tried to pacify the incident. At that time, accused number 1, 2, 4 inflicted injury on them also with knife. As a result, CW1 to 6 have sustained simple injuries, and the injured Manish Kumar Singh was immediately taken to MS Ramaya Hospital in an ambulance, and on the very next day he succumbed to the injuries. It is the case of the petitioner counsel that at the first instance case has been registered against 6 unknown persons. And now the police after the investigation have filed the charge sheet against 4 accused persons. And also no TI period is conducted. And no any basis to connect these petitioners that they are the assailants. Hence, these petitioners may be enlarged on bail. The counsel also submits that investigation has already been completed and charge sheet is also filed, and no need of custodial trial. Hence, they may be enlarged on bail. The counsel appearing for the state would submit that bloodstained cloth of accused number 1 and 2 were seized, and also knife was seized, and there was a joint recovery at the instance of these petitioners. And apart from that, PI period was conducted by CW27, and injured witnesses have identified these petitioners that they inflicted injury. The injured 1 to 6 are also eyewitnesses to the incident. and hence there was sufficient material against the petitioner's hearing. Having heard the respective counsel and also on perusal of material and also on perusal of FIR, no doubt case was registered against unknown persons, 6 in number. And now police have investigated the matter and filed the charge sheet. The allegation against these petitioners that they were watching the movement of persons who are proceeding in the night, and that on 12/9/2021, when the injured CW1 and the victim were found, and these petitioners have committed an offense of inflicting injury with steel knife and iron knife. As a result, CW1 also sustained injuries and CW and injured also, and the victim who suffered the injuries also was taken to hospital, and when CW2 to 6 have made an attempt to pacify the incident, they were also subjected to assault by these petitioners. And the recovery is also made at the instance of the petitioner, that is cloth and knife, and joint recovery was made. And TI period is also conducted. In considering the material available on record, it is not a fit case to exercise the discretion in favor of the petitioners, since an attempt was made to commit the offense of robbery, and when the resistance was made by CW1 as well as victim, they were inflicted injury with the deadly weapons like steel knife and also the iron knife, and recovery is also made. Hence, it is not a discretion in favor of the petitioners. Notraj. Last time absent. This matter is listed on 19/4/22, and there was no representation. And again listed on 23/5/22, and again counsel was absent, and today also absent, and hence petition was dismissed for non-prosecution. 77 Pallavar.
For the petitioner, my lord, petition under section 438 of CRPC. The petitioner number 1 and 2 are husband and wife. The complainant, my lord, the de facto complainant is the deceased sister's daughter of the petitioner number 1.
One second. Someone has filed. 1 second, counsel. Someone has filed wakalat on behalf of Deenabandhu. ಏನು ವಕಾಲತ್ was returned ಏನೋ ಇದೆ, office objections ಏನೋ ಇದೆ ನೋಡಿ. ವಕಾಲತ್ filed by N Deenabandhu Rai is returned with office objections ಅಂತಿದೆ. ಏನದು?
Rank of the complainant to be stated correctly ಅಂತ.
Rank of the complainant ಏನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ? ಕಂಪ್ಲೇನೆಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ ಕಂಪ್ಲೇನೆಂಟ್ ಪಾರ್ಟಿ ಇನಿಷಿಯಲಿ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ, ಆದ್ರೆ ಬಟ್ ಆಫೀಸ್ ರೇಸ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ ಸಿನ್ಸ್ ದಿ ವಿಕ್ಟಿಮ್ ಇಸ್ ಅ ಮೈನರ್, ಅವ್ರನ್ನ ಡಿಲೀಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆಸ್ ಪರ್ RJ circular, so therefore respondent number 2 was deleted. But however no notice was issued to respondent number 2 victim complainant, but however wakalat came to be filed.
What is the age of complainant?
17 years ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ FIR.
17 years. R2 ಅಂತ ಹಾಕಿದ್ದಾರೆ. R2 is not a party. ವಿಕ್ಟಿಮ್ ಅಷ್ಟೇನೆ ಅಲ್ವಾ? ವಿಕ್ಟಿಮ್ ವಕಾಲತ್ ಹಾಕಿದ್ರಿ. ಹೇಳಿ, ಏನ್ ಹೇಳಿ, ನೀವು ಹೇಳಿ. ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ.
Lord, the petitioner number 1 and 2 are the husband and wife. The complaint came to be filed by the deceased sister's daughter of the petitioner number 1. Lord, the petitioner number 1 is son of one Kuriakos. He had left behind certain properties. With respect to those properties, my lord, there was a dispute between the first petitioner, his mother Mariamma, and the daughter of the deceased sister of the first petitioner. In that regard, my lord, annexure D, E, F, G, H, and J are produced, my lord. In this background, my lord, a false complaint came to be filed by the complainant at the behest of Mariamma, the mother of the first petitioner, on 5/2/2022. Case and counter case, my lord. The allegation against these petitioners are that, my lord, when the victim girl was watering areca plants at her garden, this first petitioner all of a sudden grabbed her from behind and and held her chest and allegedly stated that since you go on telling others that I would rape you, or today I'll in fact rape you, and then pushed her to the ground and then undressed her pant is the allegation. And insofar as the second petitioner is concerned, the allegation is that when the complainant made a hue and cry, she also came to the spot and allegedly slapped the victim. An FIR came to be registered by the police, my lord, under section 323, 354, 34 IPC and section 7 and 8 of the POCSO Act. My lord, I have produced annexure D, E, F, G and H and J to show that there was enmity between the first petitioner and his mother Mariamma, and several suits and revenue proceedings are pending. And the victim, the alleged victim, my lord, is staying with Mariamma, the mother of the first petitioner, since her father had married after the death of her mother, had married somebody else. So therefore, the complainant is staying with Mariamma, her grandmother. The submission is that, my lord, this false complaint came to be filed at the behest of Mariamma for the first petitioner having filed original suit as well as initiating revenue proceedings with respect to properties left behind by his father, late Kuriakos. On the very same day, my lord, another complaint came to be filed, case and counter case, which is at annexure J, my lord, by the second petitioner regarding the same incident, which tells
complaint against whom?
Complaint against Mariamma and others, my lord. The mother of
now there are case and counter cases.
Case and counter case, my lord. Insofar as the second
164 statement. What is the relationship between this first petitioner and the victim girl? What is the relationship between the first petitioner and the victim girl?
ನನ್ನ ಅಕ್ಕನ ನನ್ನ ತಂಗಿಯ ಮಗಳು, my sister's ಹೌದೌದು. She is no more. ಹೌದೌದು, she is no more. She and victim's father married somebody else after the death of the wife. So therefore she is staying with grandmother, my mother.
Property disputes ಎಲ್ಲ ಇದೆಯಲ್ರಿ, ಏನು ಸಿಕ್ಕಾಬಿಟ್ಟೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಇದೆ ನೋಡಿ. There is a dispute with regard to the property left by the father and grandmother and also the petitioner's hearing. Annexure A to B. Matter is also before the assistant commissioner.
TA is also granted in my favor, my lord.
Section 8 and 12. ಹೇಳ್ರಿ ನೀವೇನ್ರಿ? Case and counter case. ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡ್ತೀರಿ? ಈಗ ಹೇಳಿ ಫಸ್ಟ್. ಹೇಳಿ. ನೀವು ವಾಲಂಟರಿ ಹಾಕಿರೋದು ವಕಾಲತ್ತು, ಹೌದಲ್ಲ? ನಿಮಗೆ ನೋಟಿಸ್ ಕೊಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಆಯ್ತ್ರಿ, ಬೇಲ್ ಪಿಟಿಷನ್ ಕೊಡ್ಬೇಕು, ಯಾರು ಸರ್ವ್ ಮಾಡಿದಾರ? ನೀವು ಆಕೆ 17+17+, why court has to give notice to her? When they have made the party, office objected, no need to make her as party to the proceedings and she has been deleted. Now voluntarily appeared before the court through a counsel. ನಿಮಗೆ ಸರ್ವ್ ಮಾಡಿದಾರ? ಯಾವಾಗ? ಏನಿದೆ? Is there any direction to serve the copy on the victim? Statute doesn't say anything about to serve a notice. POCSO ಅಂದ ತಕ್ಷಣ ಮಾಡಕ್ ಬರೋದಿಲ್ರಿ. ಏನೈತೆ ನೋಡಿ. They would file power for the de facto complainant and seeks time to file objections ಅಂತ 24 ನೀವು ಕೇಳಿದಿರಲ್ಲ. ಇವನ್ 24ರಿಂದ ಇನ್ನೂ ಮತ್ತೇನ್ ಟೈಮ್ ಕೊಡೋದು ನಿಮ್ಗೆ? ಸೀನಿಯರ್ ಹುಷಾರಿಲ್ದವ್ರೆ, ನೀವು ಬೇಲ್ ಪಿಟಿಷನ್ ರೀ ಇದು. Supreme Court says bail petition has to be decided within 1 week ಅಂತ. ನೀವು 24 ಅಲ್ಲಿ learned counsel Deenabandhu Rai submit that he would file power for the de facto complainant. No type down after hearing the matter. First of all, no notice is required also. Victim girl is aged about 17 years and all. Below 16 other matra statute says notice has to be given. And offenses also section 8 and 12. Not the offense under section 4 and 6. Not an heinous offense also. Third, dispute between the parties, that's why invoking ಹೇಳ್ರಿ civil dispute ಗೋಸ್ಕರ ಮಗುವಿನ ಚಾರಿತ್ರ್ಯ ವಧೆ ಮಾಡಕ್ ಕೊಟ್ಟಿರಿ. Says 8 and offense 8 and 12. Or the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the complainant is studying in, the victim girl is studying in PUC. And her father, her mother passed away, and thereafter father contacted the second marriage, and hence the victim girl is staying along with her grandmother. And there are agriculture land, and the same is looked after by complainant, victim mother, and also the complainant. It is an allegation that on 5/2/2022 at 7 a.m. when the victim girl was watering in the Areka land, Kushi Adike Tota, her maternal uncle suddenly came and held her hands and assaulted on her head and scolded that he would rape her and dragged her and tried to remove the pant. And when she screamed at the spot, mother-in-law rushed to the, grandmother rushed to the spot. And the second petitioner assaulted. And the said incident was witnessed by the others, and hence based on the complaint, police have registered the case. Invoking the offences in 323, 354, and also section 8 and 7 and 8 of POCSO Act. The counsel appearing for the petitioner submits that there is a dispute between the grandmother of complainant and also these petitioners. And counsel in support of this contention also placed the documents annexed B, E and F. And also with regard to the suit in OS number 358 of 2021. And matters are also pending before the assistant commissioner. And only with an intention to harass the petitioner, a false complaint is filed at the instance of grandmother of complainant, and no such incident was taken place. And hence, and offences are also not punishable with death or imprisonment for life, and hence may be enlarged and paid. For contra, the counsel appearing for the state would submit that a specific allegation is made that the first petitioner made an attempt to outrage the modesty of a girl who is aged about 17 years. And also assaulted the grandmother when she came to rescue the victim girl. The counsel appearing for the de facto complainant would vehemently contend that an attempt was made and also threatened that he would rape her. And also assaulted both the victim girl as well as the grandmother. Hence, there is a prima facie material. Having heard the respective counsel and also in reply to the arguments, the counsel also submits that case and counter case also registered in crime number. What is that crime number? Another crime number?
Crime number 11 of 2022.
Crime number 11 of 2022. And this case is in crime number 10 of 22. Having heard the respective counsel and also on perusal of material available on record regarding the relationship between the parties, the fact that the complainant is staying along with The victim girl, staying along with her grandmother is not in dispute. And also records reveals that there are civil disputes and also the matters before the revenue authorities in respect of the property. And also the victim girl is none other than the first petitioner's sister's daughter. And when the case and counter cases are also registered, and also an allegation is that he came and held her hands and also threatened that he would commit rape. And having taken note of nature of injuries, nature of allegations made and offences invoked section 323, 354 and section 7 and 8 of POCSO Act, it is appropriate to enlarge the petitioner on bail with conditions.
Great.
Vikyat. ಯಾವ್ದ್ರಲ್ಲಿ ಯಾರು ಹೇಳಿದ್ನಲ್ಲ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ. 419 420. What is the allegation? Hmm. 51/1, 50/1, not 151. 51/1. Impersonation. Document was registered in the year 2004 itself. 15. Sale transaction of the year 2004. In the complaint itself, they have stated that there was a sale deed of the year 2004. Anwar Saab ಹಾಗೂ ಮರಿಯಂಬಿ ಸೇರಿಕೊಂಡು ದಿನಾಂಕ 26/7 50,000 ರೂಪಾಯಿಗಳಿಗೆ ಸರ್ವೆ ನಂಬರ್ 7 ಗುಂಟೆ ಜಮೀನು ಕುಣಿಗಲ್ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಸುಖತ್ರಯಕ್ಕೆ ನನಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. Third, the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that in Herur village, in survey number 51/1, measuring about 3 hectares 22 quintals of farmland, jointly was in the name of Madar Saab, Anwar Saab, Ali Akbar, Muhammad Ibrahim. And there was no any partition. And there was an understanding between themselves. And they were enjoying the scheduled property. And complainant had acquired about 35 quintals of land in the said land. And he is cultivating the said ragi crop. And these petitioners came and told that his father, along with all his brothers, have sold the property 1 acre 5 quintas with sale deed dated 26/7/2004 for valuable sale consideration. And hence, the complainant had made an allegation in the complaint that no such property was sold. And document was created. And father was passed away on 2011-2015 itself. And hence they have committed an offence pursuant to 419 and 420 of IPC. The counsel appearing for the petitioner would submit that the very complaint itself discloses that it was the sale deed of the year 2004. And also the father died in the year 2015 itself. And false allegation is made in the complaint. After almost 18 years of the sale was made. And hence, the petitioner may be enlarged on bail. Per contra, the counsel appearing for the state would submit that a specific allegation is made that document was created and no such document was executed by the father of the complainant. And serious allegation is made that with an intention to knock off the property, document was created. Having heard the petitioner counsel and also the allegation made in the complaint, that petitioner was claiming that property was sold on 26/7/2004 to the extent of 1 acre 5 acres. And no such sale deed was executed by the father. And there was no any partition also. And having taken note of that there was a sale transaction of the year 2004. And also the father of the complainant was died in the year 2015 itself. And after 7 years of death of the father of the complainant, a specific allegation is made in the complaint that no such sale deed is executed. And hence it is a matter of probe. And having taken note of the contents of the complaint and sale transaction taken place almost 18 years, it is a fit case to exercise the discretion in favor of the petitioner with conditions to cooperate with the IO for the investigation of the matter. 79. Ramesh and Naeem Pasha. Withdrawal ಏನು ಹಾಕಿದ್ದಾರೆ ನೋಡಿ ಮೇಡಮ್. Petition ಏನು withdrawal ಹಾಕಿದ್ದಾರೆ ನೋಡಿ. Petitioner counsel has filed memo. Seeking permission of this court to withdraw the petition with the liberty to approach the sessions court for bail, since bail on the charge sheet. And in lieu of the submission and in lieu of the memo filed by the petitioner, counsel permitted to withdraw with liberty for bail. 80. Vikas Banavane. ಇಲ್ವಾ ಏನಾಯ್ತು ನೋಡಿ, ಅಬ್ಸೆಂಟ್ ಅಂತಿದೆ ನೋಡ್ರಿ. ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಬೇಲ್ ಆಗಿದೆ ನೋಡ್ರಿ. List none present. ಏನಾದ್ರು ಆಗಿದೆಯಾ? ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆಯಾ? Total. Petitioner counsel is absent and last and in the previous occasion also on 24/20/22 also absent, and hence however one more opportunity is given to the petitioner counsel. If counsel doesn't appear in a state of hearing, petition will be dismissed for non-prosecution. This matter on 6th June. Darshan. Last time absent, ಇವತ್ತು absent, same order madam. ಇದು date 24, ಅದು ಯಾವ ಡೇಟ್ ಅಂತ ನೋಡ್ಕೊಳ್ಳಿ. In the previous occasion and 24 also absent, today also absent. Next, Murali, a memo for withdrawal. Petitioner counsel has filed memo. Has not pressed. On the ground that petition become infructuous. Why it becomes infructuous? Nothing. In lieu of the memo, permitted to withdraw and dismissed as infructuous, as mentioned in the memo on the list. Dilraj Jude Rohit Sikwara. 376/420. Really counsel. Right, next, don't. ಅದಕ್ಕೆ ಸಿಕ್ ಪರ್ಸನ್ ಅಂತೀರಾ? ಯಾವಾಗಿಂದ ಇದನ್ನ ಕಸ್ಟಡಿಲಿ? ಯಾವಾಗಿಂದ ಇದನ್ನ ಕಸ್ಟಡಿಲಿ ಇಟ್ಕೊಂಡು? 10/2/2022 ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರ 13/1 ಅಲ್ಲಿ ಅರೆಸ್ಟ್ ಆಗಿರೋದು ಫೆಬ್ರವರಿ ಅಲ್ಲ ಏನ್ರಿ? ದುಡ್ಡು ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ? ಬರೀ ಯಾರ್ದೋ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲಿ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀನಿ 6 ಲಕ್ಷ, ಆಮೇಲೆ ಒಟ್ಟಿಗೆ 10 ಲಕ್ಷ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ ಟು ಗೆಟ್ ದಿ ಜಾಬ್ ಅಂತ. ವಾಪಸ್ಸು ಕೊಡೋದೆ. ಹೆದರಿಕೆ ಹಾಕಿದ ಅಂತ. ಸರಿ ತಗೊಳ್ಳಿ. Out the petitioner counsel and also the counsel appearing to the state. Charge sheet material ಹಾಕಿದೀರಾ? ಎಲ್ಲಿ ಹಾಕಿದ್ರಿ? ಯಾವಾಗ? ನಿಮ್ಮ ಹತ್ರ ಕೈಯಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದೀರಿ? ಮತ್ತೆ ಎಲ್ಲಿ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿ ಎಲ್ಲಿ ಹಾಕಿದಿರಿ? ಆಫೀಸ್ಗೆ ಹಾಕಿದ್ರಾ? ಯಾವಾಗ? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯೇನ್ರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್? ಇಲ್ವಾ ಒಂದು ಕಾಪಿ ಕೊಡಿ ಅವರಿಗೆ. Petitioner counsel has filed memo along with memoನು ಇಲ್ಲ ಹಾಕಿದೀರಾ with additional documents and also submit the copy on the state and hence this matter on 6th Lord ನೀವು ಓದ್ಕೊ ಬಂದ್ರಿ ಅಷ್ಟೊಳಗೆ 6th memo for withdrawal. Vijay Singh, Petitioner counsel has filed memo. Seeking permission to withdraw the petition has not pressed and permit to file the fresh petition based on the charge sheet which has been filed. And is permitted to withdraw and file with liberty as sought. Office objection raised on memo for conversion. ಏನ್ ಮೆಮೋದಲ್ಲಿ ಆಫೀಸರು ಮಾಡಿಲ್ಲ ಅಂತ ಏನ್ ಕನ್ವರ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? The petitioner counsel has filed memo seeking permission to convert this petition as appeal. And a copy of the memo is now served on the HCGP. In view of the memo file permitted to convert the same as appeal. List this and for the statistical purpose, the criminal petition is disposed of. ಅಂತ ಹಾಕ್ಬಿಡಿ. ಮೊನ್ನೆ ಯಾವುದೋ ಒಂದು ಹಾಗೆ ಮಾಡಿದ್ರೆ ನನಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಆರ್ಡರ್ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕಲ್ ಪರ್ಪಸ್. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 6th ನೋಡ್ರಿ ಅದು ಆಲ್ರೆಡಿ ನೋಟಿಸ್ ಆಗಿತ್ತು ಈಗ ನಾವು ಕನ್ವರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೇವೆ 6th ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 6th ಕನ್ವರ್ಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಷ್ಟೇನೆ. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ನಮ್ಮ ಮುಂದೆನೆ ಬರುತ್ತಲ್ವ? ಹೌದು ಅಪೀಲ್ ಆದ್ ನಮ್ಮ ಮುಂದೆ ಬರಲ್ವಾ ಮೇಲ್ ಪಿಟಿಷನ್ಸ್? ಹೌದಾ ಅದು ಬೇಲೆ ತಾನೆ ಓನ್ಲಿ ಅಂಡರ್ ದಿ ಸ್ಟ್ಯಾಚ್ಯೂಟ್. ಹೌದಾ ಆಯ್ತು ತಗೊಳ್ಳಿ ಹಾಗಾದ್ರೆ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಏನಾಯ್ತು ಅಲ್ವ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕಲ್ ಪರ್ಪಸ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಪರ್ಮಿಟೆಡ್ ಟು ಕನ್ವರ್ಟ್ ದಿ ಸೇಮ್ ಆಸ್ ಅಪೀಲ್ ಅಷ್ಟೇ ಆಗ್ಬಿಡಿ ಸರ್. 86 Yeah, now investigation has been completed and charge sheet is also filed. ಹೌದಾ? As per the complaint allegations, the incident has been taken place in the year 2016. ಈಗ petitioner is 24, so 18 years ಅಲ್ಲಿ ನಾವು ಮೈನರ್ ಅಂತ ಏನು ಹಾಕಿಲ್ಲಲ್ಲ ಅವ್ರು ಕೇಸ್ ಹಾಕಿರೋದು 376 ಡೇಸ್. ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು 2016 ಅಲ್ಲಿ. Now what is her age now? ಯಾರ ಅವನಾ? Victim girl, what is the age of victim girl? ನೀವು 24 ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ದಾಖಲೆ? ಅವರು 24 ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ. ನಿಮ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ 24 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಏನ್ರಿ? What was her age in 2016? When she was married?
ಬಗ್ಗೆ ಅವರು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನಿಲ್ಲ 2017 ಅಲ್ಲಿ ಗಂಡ ಮನೆ ಬಿಟ್ಟೋದು ಅಂತ 2015 ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಒಂದು ಗಂಡು ಮಗು ಇರ್ತದೆ, ಒಂದು ಹೆಣ್ಣು ಮಗು ಇರ್ತದೆ, ಒಂದು ಹೆಣ್ಣು ಮಕ್ಕಳು, ಒಂದು ಗಂಡು ಮಗು ಇರ್ತದೆ. ನಾನು ಗಂಡ ಮಕ್ಕಳಲ್ಲಿ 2015ನೇ ಸಾಲಲ್ಲಿ ಮನೆ ಬಿಟ್ಟು ಹೋಗಿರ್ತಾರೆ. ತದನಂತರ 2016ನೇ ಸಾಲಲ್ಲಿ ನಮ್ಮ ಮನೆಯ ಪಕ್ಕದಲ್ಲಿ ಸುಳ್ಯ ಎಂಬುವರು ನನ್ನನ್ನು ಆಗಾಗ್ಗೆ ಮಾತಾಡುತ್ತಿದ್ದು
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿದ್ದಾರೆ ಮದುವೆ ಆಗಿದ್ದ ಬಗ್ಗೆ ಅವಳಿಗೆ ಆಕೆಗೆ
ಮದುವೆ ಆಗಿರೋದಿಲ್ಲ. ಮಕ್ಕಳು ಆಲ್ರೆಡಿ 2 ಮಕ್ಕಳು 3 ಮಕ್ಕಳು ಇದ್ದರೆ ಮದುವೆ ಆಗಿದ್ದೆ ಅನ್ನೋದು ಹೇಳಿದ್ರು. ಬಚ್ಚಾಲ ಆಂಧ್ರ ಪ್ರದೇಶದಿಂದ ಬಚ್ಚಾಲ ಮದುವೆ ಫಸ್ಟ್ ಲೈನ್ಸ್ ನೋಡಿ.
ಅದು ಆಕೆ ಗಂಡ ಕಂಪ್ಲೇಂಟ್ ಯಾರು ಕೊಟ್ಟಿರೋದು? ಆಕೆ ವಿಕ್ಟಿಮೇ ಕೊಟ್ಟಿರೋದ ಕಂಪ್ಲೇಂಟ್? ಏನ್ರಿ ಇದು? ನನ್ನ ತಾಯಿಯೊಂದಿಗೆ ವಾಸವಾಗಿದ್ದುಕೊಂಡು ಮಣಿಪಾಲ್ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೌಸ್ ಕೀಪಿಂಗ್ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಜೀವನ ಮಾಡಿಕೊಂಡಿದ್ದು. ನಾನು ಈಗ ಸುಮಾರು 11 ವರ್ಷಗಳ ಹಿಂದೆ ಆಂಧ್ರ ಪ್ರದೇಶ ಮೂಲದ ಪಂಚಾಲಯ ಎಂಬುವರನ್ನು ಮದುವೆ ಆಗಿದ್ದು ನಮಗಿಬ್ಬರು it was the incident of the year 2016 that she is also a married woman and also having children. Charge sheet agide iga heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that this petitioner used to follow her when she used to go to job, and he was warned. And in the month of September 2016, he committed sexual act against her wish in her house. And also he had promised that he would marry her, and also caused threat not to reveal the same to anyone. And he used to he continued the sexual act. As a result, she became pregnant. On 16/10/2021 also made an attempt to commit sexual act forcibly. And when she questioned about the marriage, he postponed the same. And he refused to marry her. And hence the police complaint is given, and police have investigated the matter and filed the charge sheet based on the complaint invoking 376, 417, 323, 504, 506 of IPC. The counsel appearing for the petitioner would submit that this petitioner is in custody from November 2021. November 2021. And also in the complaint, she has categorically stated that her marriage was solemnized 11 years ago with one Penchalaya resident of Andhra Pradesh. And in the said wedlock, she gave birth to 2 daughters and a son. And he left her in the year 2015 itself. And allegation was made that she was subjected to sexual act in the year 2016. And no complaint was given. And she is a major and also married woman. And only allegation is made that when he refused to marry her, the present complaint is filed. The police already investigated the matter and filed the charge sheet, and the allegation made in the accusation made in the charge sheet has to be proved during the course of trial. Hence, it may be enlarged on bail. The counsel also would submit that the petitioner age is shown as 24, and our allegation is that incident was taken place in 2000. 16. By that time, the age of this petitioner was 18. And the allegation made in the complaint also cannot be believed. For contrary, the counsel appearing to the state would submit that the age of the petitioner is mentioned as 24 in the charge sheet. An alleged incident was taken place in 2016. And the counsel also would submit that specific allegation was made that he had sexual intercourse with her continuously from 2016 with a promise to marry her. And hence the PIO has collected material and filed the charge sheet, and there is a prima facie case. Having heard the respective counsel and also on perusal of material and also taking into note of contents of the complaint, the victim has stated that her marriage was already solemnized with one Penchalaya 7 years ago, and he left her in the year 2015 itself, and thereafter the alleged sexual act was committed in 2016. And having taken note of this fact into consideration that she is a married woman and also a major, and also taking into note of the age of the petitioner in the year 2016, he was 18 years, and already investigation has been completed whether he had promised to marry her, and with that promise he had sexual intercourse with her. It is a matter of trial, and hence petitioner is entitled for bail with conditions. Money transaction ಬಗ್ಗೆ last time HCP press time ಅಂತಿದೆ ನೋಡ್ರಿ. ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ 27 ನೀವೇ ಇದ್ದಿದ್ದು. ಅಲ್ಲ ಅಲ್ಲಿ ಏನಾಯ್ತು, ನೀವು HCP seeks time to verify whether any money transaction was made in the name of this petitioner regarding fraud and creation of documents ಅಂತಿದೆ. ಬಸವ್ರು ಆಯ್ತು 230 ಅವ್ರ ಫೈಲ್ ಇಲ್ಲ ಅಂತ್ರಿ ಅವರು. ಅಲ್ಲ ಅವ್ರಿಗೆ ಫೈಲ್ ಇಲ್ಲ ಅಂತ್ರಿ, ಅವ್ರ ಹೆಂಗ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ? 230 ತಗೊಂಡ್ ಬಿಡಿ. 230 ಹೇಳಿ ಅವ್ರು. ಯಾಕೆ ನಿಮ್ಗೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ನಾಡಿದ್ದು ಆಗ್ಬೋದಾ? 438 ರೀ ಇದು. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ತಗೊಳ್ಳೋಣ. That's why ಇಲ್ಲಿ ಬ್ಯಾಂಕ್ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿರೋ, ಅದಕ್ಕೋಸ್ಕರ I directed you to verify whether amount has been transferred to the account of something. ಆಯ್ತ್ರಿ 230 ಇಲ್ಲ ನಾಡಿದ್ದು ಯಾವತ್ ಬೇಕು ಹೇಳಿ. ನಾಡಿದ್ದ ಆಯ್ತು. HCP seeks time on the ground that file is misplaced and hence this matter day after tomorrow. ಆಗ್ಬೋದಾ? ಆಯ್ತು. ಆಯ್ತ್ರಿ, ಈಗ ನಿಮ್ಮನ್ ಕೇಳ್ಬೋದು, ಅವ್ರ ಹತ್ರ ಫೈಲ್ ಇಲ್ಲ, ನಾನು ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. ಆಮೇಲೆ ನನಗೆ ಅವಕಾಶ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳೋದ್ ಬೇಡ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋನೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ಟಾರ್ಟ್ ಡೇಟ್. ಸರಿ, ಅವ್ರ ಹತ್ರ ಫೈಲ್ ಇರ್ಬೇಕಲ್ಲ. ರವಿಚಂದ್ರ ವಿ A1 307 ಕೊಡಿ ಮೇಡಮ್. ಇಲ್ವಾ? ಕೌನ್ಸಲ್ ಇಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಆಬ್ಸೆಂಟ್, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತಿದೆ. ತಗೊಳ್ಳಿ, ಪಿಟಿಷನರ್ ಕೌನ್ಸಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್. this matter on 6. Syed Jafar Mohyuddin.
For the petitioner, my lord.
Counsel 457, 454, 380. ಎಷ್ಟು ಕೇಸ್ ಇದೆ? ಒಂದೇನಾ ಅಥವಾ ಇನ್ನು ಜಾಸ್ತಿ ಇದಾವ?
My lord, as per our records, my lord, there are 2 cases pending with the respondent police station. For both, we have filed 439 application. One application is to come up before this honorable bench on 1st, my lord. These are the 2 cases that we are aware about. And there is one case in Rajasthan for which the accused is already in custody. Jaipur district jail ali custody ali idare swami. So after this case was registered, the respondent police station have registered an FIR and secured the custody from Jaipur jail, produced the accused before the learned trial judge, after which investigation has been completed, charge sheet has been filed, my lord. After the charge sheet has been filed, the accused has been sent back to the original jurisdictional central jail. As investigation in this case is complete, my lord, and the accused in this case has not been convicted so far in any of the offences, my lord. My lord, the accused is willing to abide by any terms and conditions that this honorable court may impose. My lord, the accused in this case is a resident of Rajasthan, and the allegation is that when the complainant had gone out from his house, the accused had broken into the house of the complainant and stolen.
I read the contents. 4,12,000 cash and also 103 grams of gold was stolen.
Please, my lord. Please, my lord. In this regard, my lord, the respondent police have completed their investigation, filed the complete charge sheet.
Is there any recovery? Is there any recovery?
So far, no recovery, my lord.
No recovery. Agidya? 61 cases. Total. Karnataka ಎಷ್ಟಿದೆ? ಶ್ಯಾಮನಗರ ಇವೆಲ್ಲ ಶ್ಯಾಮನಗರ ಎಲ್ಲ ಅಲ್ಲಿದಿರ್ಬೇಕ್ರಿ. ಶ್ಯಾಮನಗರ ಅಂತ ಯಾವ್ದು ಕರ್ನಾಟಕದಲ್ಲಿ ಇಲ್ಲ. ಮೈಸೂರು, ಗುರ್ಗಾಂವ್ ಎಲ್ಲ ಸ್ಟೇಟ್ ಅಲ್ಲೂ. ಗುರ್ಗಾಂವ್ ಕರ್ನಾಟಕದಲ್ಲಿ ಎಷ್ಟಿದಾವೆ? ಕರ್ನಾಟಕ, ಕಾರವಾರ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಟೌನ್ ಕರ್ನಾಟಕ, ಶಿವಮೊಗ್ಗ
FIR number 16.
ವಿನೋಬನಗರ PS ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕರ್ನಾಟಕ. ಇನ್ನೇನ್ರಿ habitual offender.
Lord, he's not been convicted of any offense, my lord.
Maybe not convicted. It takes another 10 years for conviction, because he will not be available for particular court, because there are 61 cases.
Lord, some leniency.
Expect conviction when there are 61 cases. All cases to be tried. It takes time.
Please, my lord. My lord, with the
conviction is not the criteria.
Please, my lord. My lord, with the respondent police station, there are 2 cases that are registered in.
ಇದನ್ನ ರಿಕವರಿ ಆಗಿದೆಯೇನ್ರಿ? ಏನ್ ರಿಕವರಿ ಆಗಿದೆ ಈ ಕೇಸಲ್ಲಿ? ಏನ್ ರಿಕವರಿ? ಕ್ಯಾಶ್ ಮತ್ತೆ ಗೋಲ್ಡ್ ರಿಕವರಿ ಮಾಡಿದಾರಾ? ಈ ಸೋಲ್ಡ್ ಅನ್ನೋನ್ ಪರ್ಸನ್ ಅಂತಿದೆ ಇಲ್ಲಿ. ಮಾಡಿಕೊಂಡು ಹೋಗಿ ಸದರಿ ಒಡೆಗಳಲ್ಲಿ 40,000 ಬೆಲೆ ಬಾಳುವ 10 ಗ್ರಾಂ ತೂಕದ ಬಂಗಾರದ ಬಳೆಯನ್ನು ತನ್ನ ಬಾಪ್ತು ಮೇಲ್ಕಂಡ RJ 45 CM ಅನ್ನು ಹುಂಡೈ ವೆನ್ಯೂ ಕಾರ್ನಲ್ಲಿ ಇಟ್ಟು ಉಳಿದ ಬಂಗಾರದ ಒಡೆಗಳನ್ನು ಬೆಂಗಳೂರು ನಗರದ ಶಿವಾಜಿನಗರದ ಶ್ರೀ ರಾಮಲ ಸನ್ನಿಧಿ ಸ್ಟ್ರೀಟ್ ನಲ್ಲಿ ಯಾರೋ ಓರ್ವ ಅಪರಿಚಿತನಿಗೆ ಮಾರಾಟ ಮಾಡಿ ಬಂದ ಹಣವನ್ನು ಮತ್ತು ಕಳವು ಮಾಡಿದ ಹಣವನ್ನು ಖರ್ಚು ಮಾಡಿಕೊಂಡಿದ್ದು ಅಂತಿದೆ. ಎಲ್ಲಿದೆ? ಕೊಡಿ, ಮತ್ತೆ ನಿಮ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅದೇನಿಲ್ವಲ್ಲ, ಕೊಡಿ, ಅವ್ರಿಗೇನ್ ತೋರ್ಸಿ. ಅಮಾನತು ಪಡಿಸಿಕೊಂಡಿದ್ದು ಅಂತ ಇದೆ ಅಲ್ಲ. ಇದು ಹೂಂಡೆ ವೆನ್ಯೂ ಕಾರ್ ಅನ್ನು ಮತ್ತು ಅದರಲ್ಲಿ ಇಟ್ಟಿದ್ದ ಸದರಿ ಪ್ರಕರಣದ 40,000 ಬೆಲೆ ಬಾಳುವ 10 ಗ್ರಾಂ ತೂಕದ ಬಂಗಾರದ ಬಳೆಯನ್ನು ಅಮಾನತು ಪಡಿಸಿಕೊಂಡಿದೆ. ಏನ್ ಕಾರಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ನ? ಅಲ್ಲ ಸರಿ ರೀ, ಕಾರಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ನೆ ಕದ್ದಿದ್ದನ್ನ. ಯಾವಾಗ ಕದ್ದಿದ್ದು? ಕದ್ದಿದ್ದಾವಾಗ ರಿಕವರಿ ಆಗಿದ್ದಾವಾಗ 23/1 ಇನ್ಸಿಡೆಂಟ್. ಸೀಸ್ ಮಾಡಿದ್ದಾವಾಗ 10/8 10/8 ಕಾರಲ್ಲೇ ಇತ್ತಾ ಗೋಲ್ಡ್? ಫಾರ್ 8 months ಕಾರಲ್ಲೇ ಇಟ್ಕೊಂಡಿದ್ನ ಅಂತ. ಅದುವೆ 10 ಗ್ರಾಮ್ 103 ಗ್ರಾಮ್ ಅಲ್ಲಿ 10 ಗ್ರಾಮನ್ನ ಅದೇ ಹೇಳಿದ್ದು 10 ಗ್ರಾಮ್ ಅದು ಇವನಿಗೆ ಸೇರಿದ್ದ. ಅದಕ್ಕೆ ಕೇಳಿದ್ದು. ಕಳ್ತನ ಆಗಿರೋ ಜನವರಿ ಇಲ್ರಿ, ರಿಕವರಿ ಆಗಿರೋದು 10/8/2021 ಕಾರಲ್ಲೇನಾ? ಅಲ್ಲ, 10/8 10 ಗ್ರಾಂ ಶೇಕದ ಬಣ್ಣದ ಬಳೆಯನ್ನು ಅಮಾನತು ಪಡಿಸಿಕೊಂಡಿದ್ದು ಅಂತಿದೆ. Anyhow, whatever it may be, but he is an habitual offender. There were 61 cases. So, heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 23/1/2021, when the CW 1, 2, 3 are not in the house. ಯಾವೂರ್ಲಿ ಮಾಡಿರೋದು? ಇದು ಶಿವಮೊಗ್ಗನಾ? went to Bangalore. On return, comes to know that on 28/1/2021, committed the offence of 454 and 380 by breaking open the door of the house and took an amount of rupees 4,12,000 cash and also 103 grams of gold. ಇಲ್ಲ 1 second. Cash ಬರೀ 20,000 ಏನಾಯ್ತು ಮೇಡಮ್? Committed offence of house trespass, house breaking to the tune of rupees 103 gram of gold worth of rupees 4,20,000 and 20,000 cash. And out of 103 grams of gold, 10 grams gold was kept in his car RJ45 CM 8315, and remaining gold was sold to resident unknown resident of Shivaji Nagara and spent the amount. On 2/3/2021, comes to know that he is in judicial custody in Rajasthan, Jaipur, Shamnagar police station, crime number 59 of 2021 for the similar offence. And hence he was taken to custody by issuing body warrant, and recovery was made worth of rupees 40,000 value of gold bangles. And case and after the completion of the investigation, filed the charge sheet. The counsel appearing for the petitioner submits that this petitioner is in custody in connection with other crimes at Rajasthan, and this petitioner was secured by issuing the body warrant, and alleged recovery is made. And no need of custodial trial. And offence also not punishable with death or imprisonment for life. He has been falsely implicated in several cases invoking the very same offences. Hence, he may be enlarged and bail. Further, the counsel appearing for the state would submit that there were 61 cases. Out of that, there are 5 cases in Karnataka registered at Karwar as well as Shimoga.
ಬೇಗ ಮಾಡಿ. My lord.
ಅದನ್ನ ಮ್ಯೂಟ್ ಆಗಿದೆ ನೋಡ್ರಿ. ಟೆನ್ಷನ್ ಆಗಾಯ್ತಿರಿ ಬಿಡಿ ಸರ್, ಹೋದ್ರೆ ನಿಂಗೆಲ್ಲ ತಿರುಗಿಸಿ ಅಲ್ಲೆಲ್ಲ ನಾವು ಅವರೇ ಮ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. ಟೋಟಲ್ 17. 90 ನಮ್ದೇ ಓಡ್ತೈತೆ. ನಡೀತದೆ. ಎದುರಾಗಿರ್ಬೇಕೇನಂದ್ರಿ
Court officer. Hello, court office. Hello. Court of- Sir, ಇದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ 14442 of 22 ಅದು ಅಡ್ಜರ್ಮೆಂಟ್
ನಂಬರ್ ಹೇಳಿ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ ಸರ್. ಎಷ್ಟು?
76 ಸರ್.
76. ಕಂಡಿಲ್ಲ.
ಅದು ಮಾರ್ನಿಂಗ್ ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದೆ, ಬಟ್ ಅದು ನೋಟಿಸ್ ಇದು ಮಾಡೋದಕ್ಕೆ ಹೇಳಿ.
ಸರ್ 1442 ಅಲ್ಲ?
ಹಾ ಹೌದು ಸರ್.
ಡಿಎಂಪಿ ಆಗಿದೆ ಸರ್.
ಏನ್ ಸರ್?
ಡಿಎಂಪಿ.
ಓಕೆ ಸರ್.
Hmm. 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 Huh. Hmm. Hmm. ಆರೋಪಿಗೆ ಶರಣವಾಗಂತೆ 4 ಗುಂಡುಗಳನ್ನು ಗಾಳಿಯಲ್ಲಿ ಹಾರಿಸಿದ್ದು ಶರಣಾಗದ ಲಾಂಗ್ನಿಂದ ಹೊಡೆಯಲು ಪ್ರಯತ್ನ ಮಾಡಿದ ಆತ್ಮರಕ್ಷಣಾ ಉದ್ದೇಶದಿಂದ ಫಿರ್ಯಾದಿ ಆರೋಪಿ ಎಡಗಲಿ ಗುಂಡನ್ನು ಹಾರಿಸಿದಾಗ ಕಿರುಬೆರಳಿನ ಬಳಿ ತಾಗಿ ರಕ್ತಗಾಯವಾಯಿತು. ಹಾಗೂ ಫಿರ್ಯಾದಿ ಆರೋಪಿಯನ್ನು ಹಿಡಿದುಕೊಂಡು ಆತನ ಹೆಸರು ವಿಳಾಸ ಕೇಳಿದಾಗ ಆತನ ಹೆಸರು ಸೀನಾ. ನಿಮ್ಮವನ ಹೆಸರಲ್ಲಿ ನೀವೇ ಇವನೇನ್ ಮಾಡ್ತಾ ಇದ್ದೆ? ಡ್ರೈವಿಂಗ್ ದಿ ವೆಹಿಕಲ್ ವಿಚ್ ಇಸ್ ವಾಟ್ ಇಸ್ ದ ವೆಹಿಕಲ್? ಟಾಟಾ ಸುಮೋನ. ಏನ್ರಿ? ಡೀಸೆಲ್ ಕಳ್ಳತನ ಮಾಡಲು ಟಾಟಾ ಸುಮೋನ ಬದಲು ಬಂದಿದ್ದ ನೋಡಿ ಮೇಡಮ್. What the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that this petitioner, along with other accused persons, made an attempt to take away the life of the police who are on gust duty. And in spite of given instructions, he did not stop the vehicle. This petitioner was driving the vehicle at the time of the incident. And when the police fired at the vehicle, the tire was busted. And also again, firing was made, and as a result, an injury was caused to his left leg. And he revealed his name as Sina. And this petitioner was driving the Tata Sumo. And hence case has been registered against the petitioner and also other accused persons. The counsel appearing for the petitioner would submit that this petitioner was arraigned as an accused number 2. The allegation that he was driving the Tata Sumo and made an attack with the police. And counsel also would submit that no other criminal antecedents and the injuries sustained by the police officials are also simple in nature. An allegation that they were making an attempt to commit the offense of diesel kaltanana. And attempting to steal the diesel from the vehicle. And hence case has been registered. The matter is under investigation. And offense also not punishable with death or imprisonment for life, and hence petition may be enlarged on bail. The counsel appearing for the state would submit that this petitioner and others armed with weapons and made an attempt to take away the life and also prevented in discharging of public duty by the complainant and police staff. And with an intention to take away the life, an attack is made. Having heard the respective counsel and also in perusal of material available on the record, particularly the allegation made against this petitioner is that he was driving the Tata Sumo vehicle, and other accused persons are also having deadly weapons. And nature of injuries sustained by the police officials are also simple in nature, and when suspending the material, and when there is no any Other criminal antecedents against the petitioner. It is a quick case to exercise the powers of 430. 8 of 439, 439 of CH-17. 93, Parmeshwara Negda.
Despite having the amount was selected not being registered in their name. Because when they require the society as a developer, because they that is the property of the school in other person. That is the allegation. I'm the developer in this. Because in fact, this entire property has been developed and the subject has been filed and site has been ordered. Sites have been ordered. The father and his father. In fact, the memorandum of understanding is also entered into the department. Within 6 days around. Within the site has been allotted. And I have developed the property into the itself. And they will only allotment must be pending. Because of the delay allotment.
Amount is paid in favor of whom? Society, not in favor of this developer. Allotted by the society. So, heard the petitioner, counsel, and also the counsel appearing to the state. The factual matters of the case of the petitioner, on the case of the prosecution is that the complainant and his father, with an intention to purchase the 2 sites from the society called as Health and Family Welfare Department Employees House Building Society Limited. And the land was also developed by this petitioner. Instead of having received an amount of more than 24 lakhs, 24,30,000, no site was allotted. No sites were allotted in favor of the informant as well as his father. And hence he had lodged the complaint. And police have registered the case and the matter is under investigation. The counsel appearing to the petitioner submits that complaint was given on 10/3/2022. The counsel also placed the copy of memorandum of understanding entered between the society as well as the complainant herein, making allotment of site and site number 18 and 61, and the process of registration is in progress, and hence question of no fraud as alleged in the complaint. And this petitioner is only a developer, and the society has to allot the site and register the document in favor of the complainant and his father. For counter, the counsel appearing for the state would submit that the specific allegation is made in the complaint that this petitioner being the developer and society also not come forward for execute any sale lead. And hence an allegation of fraud is alleged. Having heard the respective counsel and also on perusal of allegations made in the complaint, and also an allegation is that an amount of rupees 24,30,000 was paid, and the complaint is dated 10/3/2022, and the document placed before the court is dated 18/3/2022, and memorandum of understanding was also taken place between the society and the petitioner. And when such being the subsequent development subsequent to the filing of complaint, it is appropriate to enlarge the petitioner on bail conditions. No, sir, Pasha. 392, 395. Case number? ಕಾಪಿ ಇದೆಯಾ? ಇಲ್ಲ. ನಾವೇ ಮಾಡ್ರದ? ನಂಬರ್ ಏನು? 33 88 of 22 2022 ನ 21 ಇರ್ಬೇಕು. 22 ನ 23 88 33 88 of 22 A3 4 and 5 ಕೊಟ್ಟಿದೀವಿ. ಆಯ್ತು ನೀವೇನ್ರಿ? ಈಗ ಕೇಸ್ ಇರೋದು A2 and A3 ನ ಅವನ ಮೇಲೆ 15 ಕೇಸ್ ಇದೆಯಾ? A3 ಮೇಲೆ ಅಕ್ವಿಟಲ್ ಆಗಿದೆಯಾ? ಎಷ್ಟು ಕೇಸಲ್ಲಿ? 8 ಕೇಸಲ್ಲಿ ಅಕ್ವಿಟೆಡ್. ಆಮೇಲೆ A3 ಮೇಲೆ ಮಾತ್ರನಾ? A2 ಮೇಲಿಲ್ಲ. ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಅಲ್ಲ. ಈಸ್ ಆಲ್ಸೋ ಎ ರೌಡಿ ಶೀಟರ್. ಅಲ್ಲಿ ರಾಡ್ ಹಾಕಿದಾರ? ಯಾಕೆ ರಾಡ್ ಹಾಕಿದ್ರು? ಅದೇ ಸರ್ಜರಿ ಈ ಕೆಲಸ ಮಾಡಕ್ ಹೋದಾಗ ಏನೋ ಹೊಡೆದಿರ್ಬೇಕು ನೋಡಿ. ಹೌದು, ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಲೆಫ್ಟ್ ಲೆಗ್ ಫೀಮರ್. ಆಯ್ತು, ಅದು ರಿಮೂವ್ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ ಇದೇ ಕೆಲಸ ಮಾಡ್ತಾನೆ. ಡೇಟ್ ಆಫ್ ಸರ್ಜರಿ 15/12/21. ಈ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದೆ ಯಾವಾಗ? ಈ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದೆ ಯಾವಾಗ ರೀ? 15/12 ಅಲ್ಲಿ ಸರ್ಜರಿ ಆಯ್ತು. ಇದು ಯಾವತ್ತು? 24/2/22 ಸರ್ಜರಿ ಮಾಡಿಸ್ಕೊಂಡು ಒಂದೇ ತಿಂಗಳಲ್ಲಿ ಮತ್ತೆ ಹೋಗಿದ್ದಾನೆ ಮಾಡಕ್ಕೆ ಕೆಲಸವ. ಮಾರ್ಚ್ ಅಲ್ರಿ 24/2 ಠಾಣೆಯಲ್ಲಿ ವರ್ತಮಾನ ಸ್ವೀಕರಿಸಿದ 24/2 ಅಂತಿದೆ. ನೀವು ಮಾರ್ಚ್ ಅಂತ ಹೇಳ್ತೀರಿ. ಕಂಪ್ಲೇಂಟ್ ಆಲ್ಸೋ 24/2 24/2 ಮಾರ್ಚ್ ಅಂತಿರಲ್ಲ. ಮತ್ತೆ ಬೆಳಗಿನ ಜಾವ 2 ಗಂಟೆ ಸಮಯದಲ್ಲಿ 5 ಅಸಂಬ್ಲಿ ಕೈಯಲ್ಲಿ ರಾಡು, ದೊಣ್ಣೆ ಹಾಗೂ ಚಾಕು ಹಾಗೂ ಇತರ ವಸ್ತುಗಳನ್ನು ಹಿಡಿದುಕೊಂಡು ಏಕಾಕಿ ನನ್ನ ಬಳಿ ಬಂದು ಅವುಗಳನ್ನು ಎದುರಿಸಿ ನನ್ನ ಬಳಿ ಇದ್ದ ಮೊಬೈಲ್ ಅನ್ನು ಕಿತ್ತುಕೊಂಡು ಎಲ್ಲಿ ಸೆಕ್ಯೂರಿಟಿ ಸಿಬ್ಬಂದಿಗಳು ಇರುತ್ತಾರೆ ಮಾಹಿತಿಯನ್ನು ತಿಳಿಸಿ ನನ್ನನ್ನು ಇಬ್ಬರು ಅಸೆಂಬ್ಲಿಯನ್ನು ಹಿಡಿದುಕೊಂಡವರು ಸೆಫುಲ್ಲಾರ್ ಅವರ ಮೇಲಿದ್ದ ಕಾರಣ ನನ್ನ ಪ್ಲಾಂಟ್ ನಲ್ಲಿ ವೆಡ್ಡಿಂಗ್ ಮೆಷಿನ್ ಮತ್ತು ಮೆಕ್ಯಾನಿಕಲ್ ಐಟಮ್ ಮತ್ತು ಇತರ ವಸ್ತುಗಳನ್ನು ಧಾರಣ ಮಾಡಿಕೊಂಡು ಹಿಂಬದಿ ಗೇಟ್ ಬಳಿ ನಿಲ್ಲಿಸಿದ್ದ. ಎಷ್ಟು ವರ್ತ ಎಷ್ಟು? 4 lakh. ಮತ್ತೆ ಆಯ್ತು, ಅವನಿಗೆ ರಿಜೆಕ್ಟ್ ಮಾಡೋಣ, A2 ಕೊಡೋಣ ಬಿಡಿ. ಸೀಸ್ ಆಗಿದೆ, ಮತ್ತೆ ಇನ್ನೇನು ಸೀಸ್ ಆಗುತ್ತೆ? He has already sold it to someone else. But the other 3 ಕಾಸಿಗೆ ಮಾರೋದು ಇನ್ನೇನು ಕೆಲಸ ನೋಡಿ. Order the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that these 2 petitioner along with other accused persons on 24/2/22 came and threatened the security personnel and snatched the mobiles which were there with their custody, and all of them confined in the shed, and also took welding machine. ಇನ್ನೊಂದು and mechanical items worth of ಎಷ್ಟು 4 lakhs 4 lakhs. And hence case has been registered and the matter is under investigation. The counsel appearing for the petitioner would submit that accused number 3 to 5 3 to 4, 5, 6 and have already been enlarged on bail by this court in criminal petition number 3388 of 22. And these petitioners are also entitled for bail on the ground of parity. Per contra, the counsel appearing state would submit that accused number 3, who is the petitioner, number 2, is facing 15 cases. And also recovery is made, and recovery of welding machine is also recovered at the instance of this petitioner, since he has sold the same to someone else. And there is a prima facie case and he is a habitual offender. And also apart from that, he is a rowdy shooter, and hence he is not entitled for bail. The counsel also would submit that the counsel appearing for petition would submit that out of 15 cases, in already 8 cases, which are 7 cases registered in 2008, ended in acquittal, and in no case he was convicted. Having heard the respective counsel and also on perusal of material, the counsel appearing for the petitioner also not disputes the fact that 15 cases are registered against the accused number 3, who is the second petitioner. And also the contention of the state that welding machine was also recovered at the instance of this petitioner. When this petitioner was indulged in almost 15 cases, whether it is acquittal or conviction is not a matter. When this petitioner indulged in other criminal antecedents, and court also take note of the criminal antecedents against this petitioner. And apart from that, he is a rowdy shooter as contended by the CJT. Hence, he is not entitled for bail. However, the accused number 2 is not having any criminal antecedents. And only allegation that he involved in the offense committing of punishable under 392, 395 of IPC. And this court already exercised discretion in favor of accused number 4 to 6 in criminal petition number 3388 of 2022. When considering the case when the no criminal antecedents, so he is entitled for bail, subject to conditions partly allowed, one is rejected. Yatisha KJ 304B. Akidar memo for the petitioner counsel has filed memo for withdrawal. Seeking permission to withdraw the petition. And liberty may be given him to file the fresh petition after charge sheet. Man is permitted to withdraw. It's liberty to file the petition after filing of charge sheet. Nursery ready, Henry. Complainant. Complainant brother-in-law. ಇದ್ಯಾವುದು ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಯಾವ್ದು ದೀಪಾ ಹಚ್ಚಿನ ಕೇಸ್ ಬಂದಿತ್ತಲ್ರಿ ಯಾವಾಗಲೂ Bail order ಯಾರಿಗೆ ಕೊಟ್ಟಿರೋದು? A3 ಗೆ why this court has granted that only she only informed ಅಷ್ಟೇನೆ. But A2 ಗೆ allegation.
A1 is the his brother. The head to. Allegation ಅವರು ಸ್ಮಾರ್ಟ್ ಆಗಿ ಅವರು ಇನ್ಸಿಡೆಂಟ್ ಆದಾಗ ಹೊರಗಡೆ ಇಲ್ಲ. ಹಸ್ಬೆಂಡ್ ಬಂದು ಅವರು ಮಕ್ಕಳ ಅಲಿಗೇಷನ್ ಇಲ್ಲ. ಹೊರಗಡೆ ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಮತ್ತೆ ಇನ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ ಅವರು ನೋಡಕ್ ಬಂದಿದ್ದಾರೆ. ಆವಾಗ ಅದೆಲ್ಲ ಅರೆಸ್ಟ್ ಆಯ್ತು.
ವೆಂಕಟೇಶ್ ನಾಯ್ಕ್ ನಾ? ಎಂಕಾ ನಾಯಕ ವೆಂಕು ನಾಯಕ್ ಅವನು A1 ಬ್ರದರ್. ಏನ್ ಇವ್ರ ಮೇಲೆ ಏನ್ ಅಲಿಗೇಷನ್ ಇದೆ? ಓನ್ಲಿ ಅಬೇಟ್ಮೆಂಟ್. Or the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the husband and mother-in-law committed the murder as well as abetting suicide of the victim, and this petitioner, who being the brother of the husband of the victim, instigated the mother as well as his brother. Then case has been registered and invoked the offence section 302, 306, 323, 324, 904 and 114 Red Section 34 of IPC. The counsel appearing for the petitioner would submit that this court already enlarged the mother-in-law in criminal petition number 3670 of 2022. And this petitioner was not present, and only allegation that he instigated other accused persons, and hence at the most attract 114 Red Section 34 of IPC. And not 302, 306 and other offences. For contra, the counsel appearing for the state also not discuss the fact that an allegation of abetment is alleged, instigation. An allegation of instigation is alleged against the petitioner. Having taken note of the said fact into consideration and also the contents of the complaint, the only allegation that he instigated other accused persons in committing the offence. And whether he instigated or not is a matter of time. And that matter also has to be proved. And this petitioner is already in custody from Yavaginda 28/3/2022. And hence no need of further custody, custodial investigation or custodial trial. And hence enlarged on bail with conditions. Memo for retirement filed by advocate for petitioner. ದಾಖಲೆನ ಕೊಟ್ಟಾರ ರಿಟೈರ್ಮೆಂಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟರ ಬಗ್ಗೆ ಏನು ಕ್ರಿಮಿನಲ್ ಪ್ರಿಸನ್ 22 received back the file on 27/4/2022. ಸುಮತಿ petitioner ಸುಮತಿ ಅಂತಿಲ್ಲ, ಪ್ರಮೋದ್ ಅಂತಿದೆ ಅಲ್ವಾ? ನೋಡಿ ಇನ್ನೊಂದು ವಾರ ಟೈಮ್ ಕೊಡಿ ನೋಡೋಣ. Petitioner counsel has filed memo along with acknowledgement issued by one Sumati, and on perusal of the petition, petitioner is one Pramod Murthy, not Sumati, and hence retirement memo is not accepted. This matter on 6. Yes, madam. A1 302. Yeah. Sole accused or any other accused? Only sole accused. Accused number 1. there are 3 accused. Right. But there are eyewitnesses, CW 2 to 8. There was a quarrel and he inflicted injury with club.
Very sure
No need, madam. You read section only column number 17 of charge sheet. That is the allegation. Then what are the grounds for enlarging on bail? What are the grounds? There are eyewitnesses. PM report entry. PM. Cause of death. Head injury. Injury also corresponds with allegation made in the statement of eyewitnesses. Inflicted with club on the head. That's why I am asking you, what are the grounds to release him, madam? Then Ray. Right. What are the grounds? What are the grounds? I am asking, what are the grounds? Minor injuries. Cause of death? Head injury. That is according to, is it a minor injury? Abrasion. PM report hogi 168 ಅಲ್ಲಿ ಇದೆ ನೋಡ್ರಿ. ಆಯ್ತು. ಮೂಗಿನಿಂದ ದ್ರವ ಬರೋದು ತಲೆಗೆ ಹೊಡೆದಾಗ ಮೂಗಲ್ ಬಂತು ಅಂತ. Death is due to head injury sustained. ಹೌದು. ರಕ್ತ ಬರ್ತಾ ಇತ್ತು ಅಂತ. Blood was oozing from the mouth ಅಂತ. ಆಯ್ತ್ರಿ, eyewitnesses there are direct eyewitnesses. ನಾನು ಸೌಂಡ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಇದ್ರೆ ಕೊಡಲ್ಲ, ಇನ್ನು ಡೈರೆಕ್ಟ್ ಎವಿಡೆನ್ಸ್ ಇದ್ರೆ ಕೊಡ್ತೀನಿ ಅಲ್ರಿ. ಇಲ್ಲ ಕೊಡಲ್ಲ, ಸುಮ್ಮನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ. ಲೈಫ್ ಆಫ್ ಎ ಪರ್ಸನ್.
He was not the alert and not taken into hospital. Where not in the history of they have taken that close to that. Although they have not been shown before, the guns but that initial report also from no not
ಹೇಳ್ರಿ ಸ್ಟ್ರೇಟ್. ಹೆಡ್ ಇಂಜುರಿ ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ weapon, that is club. ನಮ್ ಕೋರ್ಟ್ರಲ್ಲಿ ನೀವು ಬಂದು ಸುಮ್ನೆ ನಿಂತ್ಕೊಂಡ್ರೆ ಉಪಯೋಗ ಇಲ್ಲ. ಕೌನ್ಸಿಲ್ ಮೊದ್ಲೇ ನೋಡ್ಕೋಬೇಕು, ಹೇಳ್ಬೇಕು, ಹೇಳಿದ ತಕ್ಷಣ ಉತ್ತರ ಕೊಡ್ಬೇಕು. ಮತ್ತೆ ಹೋಮ್ವರ್ಕ್ ಮಾಡ್ಬೇಕು. ಸ್ವಲ್ಪ ಫೈಲ್ ತಗೊಂಡೋಗಿ ಹೋಮ್ವರ್ಕ್ ಮಾಡ್ಬೇಕು, ಇಲ್ಲವ್ರು ಆಗೋದಿಲ್ಲ. ನಾನು ಹೋಮ್ವರ್ಕ್ ಮಾಡ್ತೀನಿ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೇನೆ ನಿಮ್ಗೆ. ಐ ನೆವರ್ ಪ್ರೀಚ್, ಫಸ್ಟ್ ಐ ಪ್ರಾಕ್ಟೀಸ್, ದೆನ್ ಐ ಪ್ರೀಚ್. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that this petitioner, being the accused number one alla even A1 inflicted the injury with the club on the head. And other accused persons are also shared the common intention in eliminating the victim. And due to the said inflicting of injuries, injured succumb to the injuries. When he was taken to Care Hospital, the counsel appearing for the petitioner would submit that the injuries mentioned in the wound certificate are simple in nature. And apart from that, counsel would submit that the alleged eyewitnesses are not witnessed the incident, and they are the planted witnesses. And only complainant comes to know about his brother was lying. The case has been registered and no material against the petitioner hearing. For count of the counsel appearing for the state, which submits that weapon which was used for committing the murder was seized at the instance of this petitioner. And also there are eyewitnesses CW 2 to 8 who have witnessed the incident, and they have categorically alleged against this petitioner that he inflicted injury with the club. And medical evidence also supports the case of prosecution, and it is a matter of trial. Having heard the respective counsel and also on perusal of material available on record, particularly specific allegation is made against this petitioner that he inflicted injury with the club. As a result, the victim sustained head injury. And cause of death also in terms of the post-mortem report, due to the head injury he had suffered. And there are eyewitnesses to the incident, that is CW 2 to 8. And when there is a direct evidence against the petitioner hearing, also the alleged 8 and 9 madam, 8, 2 to 9. And there is a direct evidence and the alleged court act allegation made against this petitioner corresponds with the injury noted in the post-mortem report. It is not a fit case to exercise the discretion in favor of the petitioner hearing. 174 ಹೇಳಿ ಕೊಲೆ ಪ್ರಕರಣದಲ್ಲಿ ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದ ನಕಾಶೆಯನ್ನು ತಯಾರಿಸಿಕೊಡಲು ಕೋರಿ ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್ ರೀ. ಈಗೇನ್ ಮಾಡತ್ತ? Page number 13. Mother was not an eyewitness. Contradictions alla ನೀವು ಟ್ರಯಲ್ ಅಲ್ಲಿ ಉಪಯೋಗಿಸಬೇಕು. ಶ್ರೀಮತಿ ಗೀತಾ
And there is no motive for not ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದ.
ಏನ್ರಿ ಎಲ್ಲಾ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಕಾಂಟ್ರರಿ ಇದಾವಲ್ರಿ ಐ ವಿಟ್ನೆಸ್ ಬಗ್ಗೆ? ಇಲ್ಲಿದೆ ಒಂದೊಂದೊಂದೊಂದು ಹೇಳ್ತಾರಲ್ಲ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮೇಡ್ witness number 2 to 9 are eyewitnesses. ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ನೋಡಿ ಹೆಂಗಿದೆ ಎಲ್ಲ 2 to 9. All these persons speaks about that, they comes to know about that he was lying. And also earlier also ಕುಡ್ದು ಬಿದ್ದವನೆ ಅಂತ ಹೇಳಿ ಏನೋ ಗೊತ್ತಾಯ್ತು ಅಂತ. ಹೋಗ್ಲಿ, ಏನೋ ಕುಡ್ದಿದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರು ಇದೆಯಾ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ, PM ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ? ಏನಾಯ್ತು ಮೇಡಮ್ ತಗೊಳ್ಳಿ, ನೀನು ಹೇಳಿದ್ದು ಹಿಂಗೆ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಎಲ್ಲಕ್ಕೆ ಹೋಗ್ಬಿಡಿ. there are direct evidence against the prosecution against the petitioner herein, and having taken note of contents of the statement of eyewitnesses, in the beginning it is stated that they comes to know about the victim was lying, and subsequent paragraphs of the alleged eyewitnesses statement, it is stated that they have witnessed the incident. The alleged witnesses are made contra statement, and hence there is a force in the contention of petitioner counsel that these witnesses are planted witnesses as eyewitnesses. ಏನಾರು ರಿಕವರಿ ಏನಾರು ಇದೆಯೇನ್ರಿ? ಕ್ಲಬ್ ಅಲ್ಲಿ ಏನಾರು ಬ್ಲಡ್ ಸ್ಟೈನ್ಸ್ ಇದೆಯಾ? ಹೋಗ್ಲಿ, ಇವ್ರದ್ದು ಏನಾರು ಬಟ್ಟೆ ಏನಾರು ಸ್ಟೈನ್ ಕ್ಲಾತ್ ಏನಾರು ಇದೆಯಾ? ಏನು ಇಲ್ಲ. ಓನ್ಲಿ ಅಲೆಜ್ಡ್ eyewitnesses, and hence it is a good case to exercise the discretion in favor of the petitioner with conditions. ಇದನ್ನ ತೆಗೆದುಬಿಡಿ. ಆಫೀಸ್ ಕೇಸ್ ಅದ್ರಲ್ಲಿ ಇತ್ತಲ್ಲ ಮೊದಲು ಹೇಳಿದ್ದೆ, ಅದು ಕರೆಕ್ಷನ್ಸ್ ಮಾಡಿ ಕೊಡಿ ನಮಗೆ. 99 ಜಯಪ್ರಕಾಶ್ A4. I think this matter was listed earlier. Same similar case. ಇನ್ನೊಂದು ಯಾವ್ದೋ ಒಂದು ಕೇಸ್ ಸೇಮ್ ಅಂತ ಇದಾರು ನಂಬರ್ 4 ಇದೆ. ಡೈರೆಕ್ಟರ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್, ಇದು ಹಿಂದೆ ಆಗಿರೋದು. ಮೊನ್ನೆ ಯಾವ್ದೋ ಒಂದು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ವಿ, ಏನೋ ಮಾಡಿದೀವಿ ಈ ಕೇಸಲ್ಲಿ. ರಿಕಲೆಕ್ಟ್ ಮೈ ಮೆಮೊರಿ. ಅದೇ ಚುಡಾಯಿಸಿದಾಗ ಕೆಟ್ಟದಾಗ ಮಾತನಾಡೋದು ಹೋಗೋದು ಬರ್ತಾ ಇದ್ರು ಹುಡುಗರು 3-4 ಜನ ಸೇರಿ ಅಲ್ವಾ? ಏನ್ ಮಾಡಿದ್ವಿ ನೋಡಿ, ಇದು ಕ್ರೈಮ್ ಯಾವ್ದಾರು ಹೊಡೀರಿ ಮೇಡಮ್, ಇನ್ನೊಂದು ನಂಬರ್ ಬರುತ್ತೆ ನೋಡಿ, ಇದು ಕ್ರೈಮ್ ನಂಬರ್ಗೆ ಏನೋ ಡಿಸ್ಕಸ್ ಮಾಡ್ದಂಗಿದೆ ಅವನು. ಸೇಮ್ ಸಿಮಿಲರ್ 38/538/21 ಬೇರೆ ಪಿಟಿಷನ್ಸ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ವಿ ನನಗೆ. ಐ ರಿಮೆಂಬರ್ ಹುಡುಗಿ ಹೋಗಿ ನೇಣಾಕೊಂಡ್ಬಿಡ್ತಾಳೆ ಹೋಗಿ. ಇವರು ವೇಲ್ ಹೇಳೋದು ದೈಹಿಕ ಮತ್ತು ಮಾನಸಿಕ ಹಿಂಸೆ ಮತ್ತು ಕಿರುಕುಳ ನೀಡಿದ್ದು ಸದರಿ ಆರೋಪಿಗಳು ದೈಹಿಕ ಮತ್ತು ಮಾನಸಿಕ ಹಿಂಸೆ ಮತ್ತು ಕಿರುಕುಳವನ್ನು ತಾಳಲಾರದ ಅಪಾರ್ಥ ವಯಸ್ಕರ ರಾಧಿಕಾಲ ಮಾನಸಿಕ 19/12 ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 2 PM ವೇಳೆಯಲ್ಲಿ ಮನೆಯಲ್ಲಿ ಯಾರು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಮನೆಯಲ್ಲಿ ಹಟ್ಟದ ನೀರಿಗೆ ನೇಣು ಹಾಕಿಕೊಂಡು ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಂಡು ಇರ್ತಾಳೆ ಎಂದು ದೃಢಪಟ್ಟ ಮೇರೆಗೆ 1-3-4 ಕೊಟ್ಟಿದೆ. ಒಂದು ಡಿಸ್ಕೌಂಟ್ ಮಾಡಿದೆ. ನನ್ನ ಐ ರಿಮೆಂಬರ್ ಐ ಹ್ಯಾವ್ ರಿಜೆಕ್ಟೆಡ್ ಅದರ್ ಅಕ್ಯೂಸ್ಡ್. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು ಯಾವ್ದು ಅಂತ ತೆಗೀರಿ ಅಂತ. ಇವನು 4 1 2 3 ನಲ್ಲಿ ಯಾರ್ದೋ ಒಬ್ಬಂದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ನಾನು ನೋಡಿದ್ವಿ. ಏನ್ ಸ್ಟೇಜ್ ಏನಿದೆ ಈಗ? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಯಾವಾಗಿಂದ ಇದ್ದಾನೆ ಕಸ್ಟಡಿಲಿ ಯಾವಾಗಿಂದ ಇದ್ದಾನೆ? ಯಾವಾಗ? ಡಿಸೆಂಬರ್ ಇಂದ ಇದ್ದಾನ? ನಾನೇ ಅವತ್ತು ಅಂದೆ ಹೋಗಿ 4 ಜನ ಸೇರ್ಕೊಬಿಟ್ಟು ಪಾಪ ಹುಡುಗಿ ಸಾಯಿಸ್ಬಿಟ್ರಲ್ಲ ಅಂತ. ದಟ್ಸ್ ವೈ ಐ ಆಮ್ ರಿಮೆಂಬರಿಂಗ್. ಮೋಸ್ಟ್ಲಿ ಅದು 438 439 ಗೊತ್ತಿಲ್ಲ. ಸಿಕ್ತಾ ಮೇಡಮ್? ಅದು ಇರ್ಬೇಕು ನೋಡ್ರಿ, ಅದಿಲ್ಲ. ಶಾಲೆಗೆ ಹೋಗಿ ಬರುವಾಗ ಇವರೆಲ್ಲ ಹೋಗೋದು ಚುಡಾಯಿಸೋದು, ವೇಲೆಲ್ಲ ಹಿಡಿದು ಕಾಲೇಜಿಗೆಲ್ಲ ಹೋಗಿ ಬರುವಾಗ ವೇಲೆಲ್ಲ ಹಿಡಿದು ಎಳೆದು ಬೈಕಲ್ಲೆಲ್ಲ ಹಿಂಬಾಲಿಸಿ ಬರ್ತೋದು, ಕಡೆ ವೇಲು ಎಳೆದು ದೈಹಿಕ ಮತ್ತು ಮಾನಸಿಕವಾಗಿ ಹಿಂಸೆ ಮತ್ತು ಕಿರುಕುಳ ನಡೆದಿದ್ದು ಅವನು ದೈಹಿಕ ಮತ್ತು ಮಾನಸಿಕ ಹಿಂಸೆ ತಡೆಯಲಾರ್ದು ಮನೆಗೆ ಬಂದು ಸೂಸೈಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. I remember the facts of the case. ಟ್ರೈನ್ ನಂಬರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಎಸ್ ನಂಬರ್ ಇರುತ್ತೆ ನೋಡಿ. ಈಗ ಎಸ್ ಸಿ ಆಗಿದೆಯಾ ಈಗ? ಟ್ರೈನ್ ನಂಬರ್ 538 of 2021. ಪೋಕ್ಸೋ ಇದೆ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ರೆ ವೆರಿಫೈ ಮಾಡಿ ಮೇಡಮ್, ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ನೋಡಿ ಅಷ್ಟೊಳಗೆ ಹುಡುಕಿ ಮೇಡಮ್, ಬೇರೆ ತಗೊಂಡಿರ್ತೀನಿ.
I appear for petitioner, my lord.
Yes, counsel. Really.
Petitioner, my lord, is accused number 4, my lord.
A4.
A4, my lord. Crime number 100 of 2022 of CN Police Station. Accused number 1 is the manager, my lord. The allegation against A1 was, my lord, without following the procedure, if he has granted the my lord loans.
And ಇದು ಅಷ್ಟೇ ಸಿಮಿಲರ್ ಏನೋ ಮಾಡಿದೀವಿ ಇದ್ರಲ್ಲೂ.
The allegation
almost 101 persons ಗೆ ಕ್ಯಾಶ್ ಕ್ರೆಡಿಟ್ ಸಾಲವನ್ನು ವಿತರಿಸಿರುತ್ತಾರೆ.
ಅಲ್ಲ ಇವ್ರ ಮೇಲೆ he is only a mediator ಅಂತ. He is not an employer. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ ಇವೆಲ್ಲ
ಹೆಸರಲ್ಲಿ ಸುಳ್ಳು ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ಸಾಲ ಮಂಜೂರು ಮಾಡಿರ್ತಾರೆ. ವಿಜಿಲೆನ್ಸ್ ತಂಡ ಸಾಲ ಮಂಜೂರು ಮಾಡಿದ ಸ್ಥಳಗಳಿಗೆ ಭೇಟಿ ನೀಡಿ ಪರಿಶೀಲಿಸಿದಾಗ ಯಾವುದೇ ಮಳಿಗೆಗಳಾಗಲಿ ಇತರ ಯಾವುದೇ ಸ್ವತ್ತುಗಳಾಗಲಿ ಇರಲಿಲ್ಲ. ದೇವರಾಜನ
ಇವನ್ ಮೇಲೆ ಓನ್ಲಿ ಮೀಡಿಯೇಟರ್ ಅಂತ. ಓನ್ಲಿ ಎಲಿಗೇಷನ್ ಮಿಲೋಡ್ ಆನ್ ಪೇಜ್ 13 ದಿ ಕಂಪ್ಲೇಂಟ್ ಲಾಸ್ಟ್ ಅಲ್ಲಿ. ಆದ್ದರಿಂದ ಇವರ ವಿರುದ್ಧ ವಿಚಾರಣೆ ನಡೆಸಲು ಸಹಾಯ ಕೋರಲಾಗಿದೆ ಹಾಗೂ ಈ ಮೇಲೆ ತಿಳಿಸಿರುವ TS ಅರ್ಜುನ್ ಪ್ರಕಾಶ್, ಅರ್ಸೇಗೌಡ, ಶ್ರೀಮತಿ ಗೀತಾಮಣಿ ಮತ್ತು ಮಧ್ಯವರ್ತಿಯಾದ ದೇವರಾಜ್ ಇವರು ಮಾಡಿರುವ ಅಧಿಕಾರ ದುರುಪಯೋಗ, ವಂಚನೆ, ಸೋಗು ಹಾಕು ಮಾಡಿ ಇತ್ಯಾದಿಗಳ ಮೇಲೆ ನಮ್ಮ ಬ್ಯಾಂಕ್ ಹಿತದೃಷ್ಟಿಯಿಂದ ಇವರ ವಿರುದ್ಧ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕೆಂದು ವಿಚಾರಿಸುತ್ತೇನೆ. ಮಿಲಾಡ್ ಇನ್ಸಿಡೆಂಟ್ ಮಿಲಾಡ್ is of the year 2007 and 2008. Complaint
17 and 18.
Complaint, my lord, came to be filed, my lord, after 4 years. That is 2022, 8/3/2022. So far as my accused is concerned, the allegation is, my lord, he only, my lord, a middleman. He is not an employee of the bank. Long delay, my lord, in filing the complaint. The allegations are made for as the other accused, my lord, in the complaint. Only in the last paragraph, my lord, they add. So far as my role is concerned, my lord. So, in view of the long delay, my lord, and offense not punishable with death or imprisonment, life, but he is a resident of the Hassan district. not imposing not any suitable condition, your Lordship may kindly consider his prayer for anticipated bail.
Well, that is in respect of the accused number 1 to 3, it's okay. But he is only the mediator. Mediator of Kelly. ಅಧಿಕಾರ ದುರುಪಯೋಗಿಸಿಕೊಂಡ್ರು A1 to 3 being the employees of the bank. ಮಧ್ಯವರ್ತಿಗಳ ಸಹಾಯದಿಂದ ನಕಲಿ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ಅಂತ
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
ಫೋರ್ತ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Where is that vigilance report? What is the role of this petitioner? ಆಯ್ತು, ಎಲ್ಲಿದೆ ಅದು ವಿಜಿಲೆನ್ಸ್ ರಿಪೋರ್ಟ್? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಈಗ? ತರ್ಸ್ಕೊತೀರಾ? HCGP 6 time to get the vigilance report regarding involvement of this petitioner, and hence this matter on 6th.
Please. 6th. Please.
363, 376, 468, 12.
Subsequently, my lord, 376 is added after the girl makes a statement.
What is her age?
Age, she is 17, my lord.
17.
How?
What is the medical evidence?
I don't have, because the charge sheet is not yet filed. I don't have the copy of the medical certificate.
Prosecutor is having ಇದೆಯಾ? 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನ್ ಹಾಕಿದ್ದು? ಕೊಡಿ ನನಗೆ ಕೊಡಿ, ನಾನೇ ನೀವೊಂದ್ಸರಿ ಓದೋದು ನಾನೊಂದ್ಸರಿ ನೋಡೋದೇನ್ ಬೇಕಾಗಿ. Medical evidence alliga. She says he took her to the Dharmasthala and Subramanya and subjected her for sexual act.
Allah, in view of her age and the conduct, my lord. 3-4 days she freely moves around with that person.
You mean to say that it is a consent? Whether a minor girl can give consent?
No, that is why, my lord, I am only on the conduct, my lord. Therefore, I did not submit. It is a consent, my lord. Our remand application ಹೇಳ್ತಾರೆ. That is what they say, my lord. She moves around with him, my lord, to Dharmasthala, then Kukke Subramanya.
Heard the petitioner, counsel, and also the counsel appearing to the state. The factual matters of the case of the prosecution is that this victim girl was pursuing for education in Morarji School.
Yes.
And victim father and this petitioner both took the victim girl to Chitradurga, and when the father went to purchase soap and shampoo, leaving the victim girl with this petitioner, both were not there. This petitioner forcibly took her to Dharmasthala and Subramanya and subjected her for sexual act against her wish. And hence case has been registered and matter is under investigation. The counsel appearing for the petitioner would submit that petitioner is the victim girl is aged about 17 years. Court has to take note of the conduct of the victim girl. She accompanied with the petitioner, who stayed along with him for a period of 3 days. And the allegation is made in the 164 statement that the sexual act is forcible sexual act. The same cannot be believed. And he is in custody.
Since
will be enlarged and bail. Under the counsel appearing to the state, it submits that 164 statement is clear that he forcibly took her. He subjected her for sexual act against her wish. And also medical reports also is clear that her hymen was ruptured. And the 164 statement as well as medical evidence discloses prima facie case against the petitioner. Petitioner is not entitled for bail. Having heard the respective counsel, curriculum material, the victim girl is pursuing her education in first UC. And specific allegation is that he took her to Dharmasthala and Subramanya and subjected for sexual act. The very contention of the petitioner counsel that the victim herself accompanied with the petitioner and court has to take note of the conduct. And the very section 2D of special enactment says that the girl is below the age of 8, she is a minor. When such case, the question of consent doesn't arise. The special enactment was brought into force with an intention to protect the children from sexual act. And when such being the object in bringing the special enactment, and also 164 statement clearly discloses that subjected her for sexual act against her wish. And also the medical evidence also supports the case of the prosecution that her hymen was ruptured and she was subjected to sexual act. Hence, it is not a fit case to exercise the discretion in favor of the petitioner to grant the bail. The very contention that this petitioner is in custody is not a ground to enlarge him when heinous offense of subjecting the victim girl who is minor for sexual act.
Please.
103. 107, 340.
Accused number 2, my lord.
So, and what are the injuries?
Injuries, my lord. Abdomen ಮೇಲೆ
ಅಲ್ಲಿ ಮಾಡಿದ
Allah, he was immediately, my lord, discharged, and now he is here and healthy, my lord. It was a dispute, my lord.
One certificate ಏನಾದ್ರು ಇದೆ ಅಂದ್ರೆ ಏನ್ nature of injuries ಏನು? Nature of injuries. Simple in nature, huh? So, heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that this petitioner with an intention to take away the life. Number 2.
ಮೂರು ಜನ ಇದ್ದಾರೆ.
Petitioner along with other accused persons with an intention to take away the life. Trespass the house by breaking down the door and inflicted injury with the knife on his stomach. And when the injured came out from the house and screamed at the spot, complainant father and other 3 persons. And the complainant father came to rescue him, and he was also subjected to assault. And hence, case has been registered and matter is under investigation. The counsel appearing for the petitioner will submit that is put in connection with watering the land and causing of breaking of removing of water
pipe.
Water pipe. The court has to take note of the circumstances under which an incident was taken place. Our counsel also submits that the injuries are simple in nature and he is out of danger and there was no any intention. But under the counsel appearing to the state would submit that injury is inflicted with knife on the stomach and also on the chest. And not disputes the fact that nature of injuries are simple in nature. Having heard the petitioner counsel and also the counsel appearing to state and also taking into note of the circumstances under which the incident was taken place and also the nature of injury is also simple in nature. We took place to exercise the powers and report of the 8 of 439 of CRPC since injury is also out of danger. Considering the gravity and the seriousness of allegations made in the complaint. Hemalata D. The petitioner counsel absent list this matter on 6th. Giving Satish Chandra. A1 and A3. Santosha Manjunatha. One is Manjunatha, another is Santosh. I3, don't repeat again and again. I can understand once it is made submission. What are the counts for release? Really? No test identification period. 245. Again, reasons not seized any bloodstain cloths of these petitioner to show that they have committed the alleged, but the prosecution has relied upon only on the last seen witnesses who was not having any acquaintance with these petitioners and also material disclosure. Right, it was used for the alleged act was thrown at the spot itself and same was recovered after the apprehension of these petitioners. Test identification period was not conducted. Hence, there is no democracy material. Same. ಇಲ್ಲ ಇದು ಆಲ್ರೆಡಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ 2, 3, 4 and ಎಲ್ಲ ಮಾಡಿದ್ವಿ. Heard the petitioner counsel and also the counsel appearing to the state. But accused number 1 was having motive anta. The factual matters of the case of the prosecution is that there was a love affair between the deceased and the sister of accused number 1. And when the deceased refused to marry the sister of accused number 1, the accused number 1 having motive against the deceased, with the help of other accused persons, he committed the murder of deceased, inflicting injury with the knife and machete. The police have investigated the matter and filed the charge sheet. The counsel appearing to the petitioner would submit that case is based upon the circumstantial evidence. Though there is a specific court act allegation against these petitioners, there are no witnesses to the alleged incident. And prosecution only relied upon the last seen witnesses who have not having any acquaintance with these petitioners. No material except the alleged joint recovery. According to the counsel appearing to the state would submit that the victim has sustained 17 injuries on his body. And deceased motorcycle was also recovered at the instance of accused number 1. On nimmaindala recovery agide A1 inda. Ade ಹೇಳಿದ್ದು. And hence there is a prima facie case. The counsel also would submit that this court already granted bail in favor of accused number 245 in criminal petition number 7957 of 2021, wherein also observed that no connecting material except relying upon the last seen witnesses who are not having any acquaintance with these petitioners. Hence, these two petitioners are also entitled for bail. Combined the counsel appearing to the state would submit that specific court act allegation is made against this petitioner, and though there were no eyewitnesses, knife was also seized at the spot. Since the assailants have thrown the same at the spot, the same was recovered after the apprehension of these petitioners. And there is a prima facie material. Having heard the respective counsel and also on perusal of material cases of arrest upon the circumstantial evidence, the prosecution mainly relies upon the last seen witnesses. No test identification period was conducted. Nothing on the record that the last seen witnesses were having acquaintance with the petitioner's hearing, and this court already granted bail in favor of other accused persons. And when suspecting the material and record, and these two petitioners are also entitled for bail on the ground of parity also. And the last done bail with conditions. That's 7. Ram Singh. Petitioner counsel is absent. This is matter on 6th. Srinivasan. A1 and A3. 307 ಇದೆ injured eyewitness ಇದಾನೆ. Injured eyewitness ಇದಾನೆ. ಏನು ಗ್ರೌಂಡ್ ಏನು ಹೇಳಿ ಬೇಗ ಹೇಳ್ಬೇಕು. A1 ಅಂತಲೇ specific allegation. PM report ಏನು 20 injuries. No out act allegation against them ಅಂತ. Weapons also recovered. 11 to 13 are eyewitnesses. So, how did the petitioner, counsel, and also the counsel appearing for the state? Due to earlier enmity, committed the murder of the victim, and specifically overt act allegation is made against accused number 1, 2, 3, and these two petitioners are accused number 1 and 3. That is assaulted with knife, machete and knife. Only katina. ಕತ್ತಿಯಿಂದ ಮತ್ತೊಮ್ಮೆ ಕಬ್ಬಿಣದ ಕತ್ತಿ with machete. And A2 assaulted with knife. Knife, other not before report. And police have investigated the matter and registered the police have registered the case and investigated matter and went to 13 for the eyewitness. The counsel appearing for the petitioner supports that though an overt act allegation is made against these two petitioners inflicting injury with machete, and this court already granted bail in favor of accused number 4 to 6, 4 to 6. And these petitioners are also he was informed. Not aware. And counsel
submitted no overt act allegations made against this petitioner inflicted with injury with knife. This court already granted.
And also he has gotten information that other accused persons were enlarged on bail, and no details are furnished. And based on the charge sheet material, it discloses that A1 and A4. A1 A1 A4 matra. A4, 5 and 6 are enlarged on bail, and hence these petitioners are also entitled for on the ground of parity. The counsel also submits that investigation has already been completed and charge sheet is also filed. No need of custodial trial. For contrary, the counsel appearing for the state would submit that the CW2 is the injured witness. He has specifically stated in his statement that these two petitioners inflicted injury with machete. And there were 21 injuries. And wound certificate also discloses the incised wound and also the chop wound. And also there are eyewitnesses CW 11 to 13. And hence there is a prima facie case. Having heard the respective counsel and also on perusal of material, specific allegation is made against these two petitioners that they are inflicted injury with machete. And also the postmortem report discloses incised wound and also the chop wound. And also there were 21 injuries. And also prosecution mainly relies upon the direct evidence of CW 11 to 13. And also injured CW2 made the specific court act allegation against these two petitioners. When suspecting the case, when there is a direct evidence against these two petitioners, and the very contention that other accused person have been enlarged on bail cannot be a ground to extend the benefit, extend the parity. The apex court also, while considering the ground of parity in the judgment of Ramesh Pavan Rathod, reported in 2021 within bracket 6 Supreme Court cases 230. Court held that bail on ground of parity with co-accused, manner in which to be determined, held that applying principle of parity, court cannot exercise its powers in a capricious manner and has to consider the totality of circumstances before granting bail. Parity while granting the bail must focus upon role of accused and not only on weapon carried by accused. In deciding aspect of parity, the role attached to accused, their position in relation to incident and to victims is of utmost importance. Having considered the principles laid down in the judgment, and when there is a specific court act allegation against this petitioner, the question of parity doesn't arise as contended by the petitioner counsel, and hence accepted. Now, not my Naushad Pasha, 20B. Which kg? 28 kg. Still under investigation, huh? 3 kg. Okay. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಇದ್ರನ್ರಿ ಹಾ ಬರೀ FIR ಬರೀ ಇದು ಮಾತ್ರ ಇದೆ ಸೀಸರ್ ಏನು ಹಾಕಿಲ್ವಲ್ಲ ನೀವು ಹಾಕಿದ್ದೀರಾ 20 24 ರೈಲ್ವೆ ಬ್ರಿಡ್ಜ್ ಹತ್ತಿರ ಸೋನ್ಸೋ 9:20 ಗಂಟೆಗೆ ನಗದು ಹಣ 3,300 40 ಗ್ರಾಂ ತೂಕದ ಗಾಂಜಾ ಪ್ಯಾಕೆಟ್ 3 kg 160 ಗ್ರಾಂ ತೂಕದ ಗಾಂಜಾ ಸುಜುಕಿ ಆಕ್ಸಿಸ್ ಸೈಯದ್ ಮನ್ಸೂರ್ ಸೋನ್ಸೋ ಗಾರ್ಡನ್ ಬ್ಯಾಂಗ್ಳೂರ್ ನಗರ ಏನ್ರಿ ಎಲ್ಲಿಂದ ಬಂತು 28 kg ನಿಮ್ಗೆ ಒಟ್ಟು ಹೆಂಗೆ ಗಾಂಜಾವನ್ನು ಮಾರಾಟ ಮಾಡುತ್ತಿರೋನು ಸೋನ್ಸೋ ರಾಮನಗರದಲ್ಲಿ ಗಾಂಜಾವನ್ನು ಮಾರಾಟ ಮಾಡಿ ಹಣ ಸಂಪಾದಿಸುವುದಾಗಿ ಹೇಳಿದ್ದು 28 That is from A to A. ಒಂದು ಆರೋಪಿ ತಿಳಿಸಿದಂತೆ A2 ಆರೋಪಿಯು ಮೈಸೂರಿನ ಒಬ್ಬ ಅಪರಿಚಿತ ವ್ಯಕ್ತಿಯಿಂದ ಮಾರ್ಗವಾಗಿ ನಿಲ್ಲಿಸುವಂತೆ ತಿಳಿಸಿದ ಮೇರೆಗೆ ಜನಾಂಗ 14 ಕಂದು ಬಣ್ಣದ ದೊರೆತಿದ್ದು ಅವುಗಳಲ್ಲಿ ಒಂದನೇ ಪಂಚಾಂಗವನ್ನು ಬಿಚ್ಚಿ ನೋಡಲಾಗಿ ಅದರೊಳಗೆ but in his presence only. A1 only took near the A2. ಬೇರೆ ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಏನಾದ್ರು ಇದೆಯೇನ್ರಿ? NDPS ಇದು NDPS ಯಾವ್ದು ಇಲ್ವಾ? ಯಾವಾಗಿಂದ ಇದ್ದಾನೆ ಕಸ್ಟಡಿಲಿ? ಯಾವಾಗಿಂದ ಇದ್ದಾನೆ ಕಸ್ಟಡಿಲಿ? ಯಾವಾಗಿಂದ ಇದ್ದಾನ್ರಿ? Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that based on the credible information, this petitioner was apprehended along with 3 kg 160 grams of ganja and also 580 grams separate ganja and 58 empty covers, the cash of rupees 3,300 and also 40 gram ganja packet along with Suzuki Axis 125 vehicle. And thereafter, this petitioner took the IO and other panchas and showed accused number 2, and he was apprehended and found 28 kg 360 gram of ganja. And case has been registered against this petitioner and also the accused number 2. The counsel appearing to the petitioner will submit that at the instance of this petitioner only 3 kg total is 3 kg 740 grams of ganja. The same is intermediate quantity, and only at the instance of accused number 2, 28 kg 360 grams of ganja was seized. And the petitioner is in custody from March 2022. 4th March and after March 2022. And no need of further custodial investigation and trial, and no criminal antecedents in respect of the very same offences. For contra, the counsel appearing for the state would submit that no ganja was seized at the instance of this petitioner 3,740 grams. But at the this petitioner only pointed out the accused number 2, and from him 28 kg 360 grams of ganja was seized. Hence, it is clear that both of them are indulged in committing an offence against the society at large. And apart from that, this petitioner is having other 6 cases. And though these offences are not pertaining to the NDPS, but other offences are IPC offences. And hence, he is an habitual offender. Having heard the respective counsel and also on perusal of material, and court has to take note of quantity of ganja seized at the instance of this petitioner. That is 3 kg 740 grams. And the same is an intermediate quantity. And apart from that, no criminal antecedents in respect of the NDPS offences. And though other 6 cases are registered for the IPC offences. And hence, the very contention of the state that he is a habitual offender cannot be accepted at this juncture. And only 1 case is registered under the NDPS Act. And hence, it is a good case to exercise the discretion and no custodial further investigation is required in the absence of any earlier criminal antecedents in respect of NDPS offences. Janesh. Last time in a CCTV footage. ಏನ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆ? ಹೌದಾ? Whether they were present or not.
The voice over
ಹೊಡೆದ ತಕ್ಷಣ ಸಾಯ್ಬೇಕಿತ್ತು ಅಂತಾನ. Statement of
the complaint itself, allegation is they randomly made allegation. So based on the information given by the cashier, this complaint will be lodged by the disease. Cashier ಹೇಳಿದ ಮೇಲೆ complaint lodged.
But each war act against all the accused persons. ಅವನೊಬ್ಬನೇ ಅಂತಿಲ್ರಿ, ಎಲ್ಲಾರ ಮೇಲೂ ಇದೆ. ಈತನ ವೈನ್ ಶಾಪ್ ನಲ್ಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದ ಸಂಜೆ 6 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ವೈನ್ಸ್ ನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಯತು ಅಲಿಯಾಸ್ ಯಶಪಾಲನಿಗೆ ಶ್ರೀಧರ, ಯತೀಶ, ರಘು, ಪ್ರಕಾಶ್, ಮಂಜುನಾಥ ಮತ್ತು ಸಂಜಯ್ ರವರು ಗಲಾಟೆ ಮಾಡಿ ಯದು ಅಲಿಯಾಸ್ ಯಶಪಾಲ್ ಕೈಗಳಿಂದ ಫೋನ್ ನಲ್ಲಿ ಎದೆಗೆ ಗುದ್ದಿದ್ದರಿಂದ ಇವನು ಸುಸ್ತಾಗಿರುತ್ತಾನೆ. ಈತನಿಗೆ ಚಿಕಿತ್ಸೆಗೆ ಆಸ್ಪತ್ರೆಗೆ ತೆಗೆದುಕೊಂಡು ಹೋಗುತ್ತಾ ಈತನ ಮರಕುಮದ್ದೆ ಹಾಸನ ನಗರ ಬಳಿ ಮೃತಪಟ್ಟಿದೆ ಅನ್ನೋದು ಪೊಲೀಸ್ ಕರ್ತಕೊಂಡಾಗಿ ಎದುರವರು ಮೃತಪಟ್ಟಿರ್ತಾರೆ. ಅತ್ತಾಯ್ತ ಲಕ್ಷ್ಮೀ ಸುಶೀಲ್, ಯತೀಶ, ರಘು, ಪ್ರಕಾಶ್, ಮಂಜುನಾಥ್ ಮತ್ತು ಇವರಿಗೆ ಅಂಗಡಿಗೆ ಬಂದು 6 ಬೇರ್ ಬಾಟಲ್ ಮಾತುಕತೆ ನಡೆಸಿದರು. ಸೇಮ್ ಇನ್ಸಿಡೆಂಟ್ ದೇ ಹ್ಯಾವ್ ನರೇಟೆಡ್ ಇನ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಆಲ್ಸೋ. ಈಗ ಏನಿದೆ ಸ್ಟೇಜ್ ಏನು? ಆಯ್ತು ದಿ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ ಏನು ಫುಟೇಜ್ ಏನ್ ತಂದಿದ್ದೀರೇನ್ರಿ? ಸಿಡಿ ಲ್ಯಾಪ್ಟಾಪ್ ಏನಾರು ಇದೆಯಾ? ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಸಿಡಿನ, ಅವ್ರು ನೋಡ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಬಂದು ಹೇಳಿ ನಮ್ಗೆ. ಕಾಪಿ ಮಾಡ್ಕೋಬೇಕು. ಇದೆಯಾ? ಎರಡಿದೆಯಾ? ಎರಡಿದೆ. ಅಲ್ಲ ನಿಮ್ ಕಡೆಗೆ ಒಂದಿದೆ, ಇವ್ರ ಕಡೆಗೆ ಒಂದು ಕೊಡ್ತಿದ್ದೀರಿ. ಈಗ ಎರಡಿದೆ ನೋಡಿ. ದಿ HCGP submitted CCTV footage copy to the petitioner counsel also, and hence Wish this matter day after tomorrow. Rosal MC. 307, 353. Any injuries anything? ಏನ್ರಲ್ಲಿ ಹೊಡೆದ್ರು ಅಂತ ಇದ್ದಾರೆ ಮೋಟರ್ ವೆಹಿಕಲ್ ಡಿಕ್ಕಿ ಹೊಡೆದ್ರು ಅಂತ ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ಏನ್ರಿ ಅವನಿಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡಿದಾಗ ಗ್ರೀವಿಯಸ್ ಏನ್ ಇಂಜುರೀಸ್ ಆಗಿದೆ within 48 hours ಏನಿದೆ ದಾಖಲೆ ಇದರಲ್ಲೇ ಇದೆಯಾ history of assault external injury swelling with tenderness present over the left parietal temporal region of the scalp headache with several episodes of vomiting and loss of consciousness following assault. Investigation. Short focal subarachnoid hemorrhage in right parietal region. Linear undisplaced fracture in left high parietal bone with fracture line extending up to Thomas mostoid part of left temporal metatarsals. Injury previous in nature. ಎಲ್ಲಿದೆ ನಿಮಗೆ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಏನಿದೆ ಆಗಂತ 9 ಡಿಸ್ಚಾರ್ಜ್ 11/3 ಹೌದು ಹೌದು ನೀವು ಸ್ಟಾಪ್ ಮಾಡ್ದಲ್ಲ ಯಾಕೆ ಡಿಕ್ಕಿ ಹೊಡೆದ್ರಿ ಅವ್ನು ಬೈ ಮೋಟರ್ ಸೈಕಲ್ ಆಯ್ತು Incident on 8/3/22. Case was registered on the same day. I put arrest pada. Case registered on the very same day or different day? 9/3. 8/3/93. 9/3 on the same day ಮಾಡಿದ್ದಾರೆ. ನೀವು ತಪ್ಪಿಸ್ಕೊಂಡು ಹೋದ್ರೆ ಅರೆಸ್ಟ್ ಮಾಡೋಕೆ ಒಂದು ತಿಂಗಳು ಡಿಲೇ ಆಗಿರ್ತದೆ. ನಾಟ್ 48 hours ರೀ 3 ದಿವಸ ಇದ್ದಾನೆ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ 8ನೇ ತಾರೀಕಿಂದ 11ರವರೆಗೆ 9 ಅಂದ್ರೆ ಬೆಳಗ್ಗೆ ಎಷ್ಟು ಗಂಟೆಗೆ ಹೋಗಿರೋದು ಆಸ್ಪತ್ರೆಗೆ 48 hours ಹೆಂಗಾಗುತ್ತೆ 3 ದಿವಸಕ್ಕೆ 9, 10, 11 ಆಗ್ಲಿಲ್ಲ 3 ದಿವಸ ಏನಿರ್ತದೆ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಬೇರೆ ಏನಾದ್ರು ಕೇಸ್ ಏನಾದ್ರು ಇದೆಯೇನ್ರಿ ಅವ್ರ ಮೇಲೆ ಬೇರೆ ಏನಾದ್ರು ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಇದೆಯಾ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು ದೇವರ್ ಕ್ಯಾರಿಂಗ್ ವೆಪನ್ಸ್ ಇನ್ ದಿ ಆಟೋ ರಿಕ್ಷಾ ಅಂತ NDPS ಕ್ರೈಮ್ ನಂಬರ್ ಏನು ಇಲ್ವಾ 563 20 21 Third, the petition counsel and also the counsel appearing from the state. The factual matters of the case of the prosecution is that on 9/3/2022, when the complainant complainant and other staff were on gust duty found an auto rickshaw was proceeding at 12:37 a.m. on Kamanalli Main Road near Suksagar Hotel. Wherein 3 unidentified persons were carrying deadly weapons with criminal intention to do illegal activities. And hence they were chased and given instructions to stop the vehicle, but they did not stop the vehicle and recklessly driven the same and caused the accident to complainant. As a result, the complainant sustained the injuries. And complaint was given and case has been registered. The counsel appealing to the petitioner would submit that these petitioners are in custody from the date of arrest. This petitioner is in custody and who has been arraigned as accused number 1. After 1 month, he was arrested from the date of alleged incident. The counsel also would submit that no details of auto rickshaw was given, and without any basis, these petitioners have been implicated. And when they were not acquainted with the petitioners, it is nothing but implication, and hence may be enlarged on bail. Karnataka Council appeal for the state would submit that the injured has sustained the previous injuries, and there was a fracture. And though admitted for 2 days in the hospital, the court has to take note of the gravity of the offense, and also this petitioner, along with other accused persons, caused the accident when they were discharging their public duty, and the same is nothing but an obstruction of discharging of public duty, and hence petitioner is not entitled for bail. Having heard the respective counsel and also on perusal of material available on record, and the medical records discloses that there was any previous injury, and the records also discloses that within 2 days injured was discharged from the hospital. And when this petitioner is in custody from 8/4/2022, no any other criminal antecedents except the one more case of NDPS. Uda NDPS. Wherein also the petitioner has been arraigned as an accused. And mere filing of other case itself is not a ground for rejecting the bail application, and taking into note of gravity of the offense and also the allegations made in the complaint. No doubt, the accident was caused in preventing discharge of public duty of the complainant, and no need of further investigation in the matter, and whether with an intention to take away the life, cause the accident or not, it's a matter of trial. And hence, Pradeep Casey. FI. 1 and 2 na? Again offense ಏನು? One more case offense ಏನು? ಏನ್ ಅಫೆನ್ಸಸ್ ಏನಂತ ಹೇಳಲ್ಲ. What the petitioner counsel, ಏನ್ nature of injuries ಏನಿದೆ? 307 ಅಲ್ಲ? Previous sir, how long he was in the hospital? Huh? Well, what is the reason for assaulting him? ಅಪರಿಚಿತ 5 ಜನರು ಅಂತಾರೆ ಮತ್ತೆ. Bloodstains hurt of this petitioner was seized. ಅಲ್ಲ ಎಷ್ಟು ದಿವಸ ಇದ್ದ ಆಸ್ಪತ್ರೆಯಲ್ಲಿಂದ? ಏನಿಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ವಾ? ಹೋಮ್ ಸೆಕ್ರೆಟರಿ ಗ್ರೀವಿಯಸ್ ಇನ್ ನೇಚರ್ ಅಂತ. ಏನ್ ಇಂಜುರಿ ಏನು? ಫೇಶಿಯಲ್ ಬೋನ್ ಫ್ರಾಕ್ಚರ್. ಏನ್ರಿಂದ ಹೊಡೆದಿದ್ದು? ದೊಣ್ಣೆ. Heard the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that on 23/2022. When he was in auto stand, a person aged about 20 years came and took the auto rickshaw for Maranayanahalli village. And when he was proceeding, he told that some his friends are also coming to go to the place. And immediately 4 persons came and suddenly started assaulting him with the club. As a result, he had sustained injury to his face and also inflicted injury with rod on his head. And kicked him mercilessly. And when he found a motorcycle was coming and informed about the incident to his friends, and he was taken to hospital in an ambulance. And made an allegation against A1 and A2 also, apart from unknown persons. Based on the case, the complaint case has been registered. The counsel appearing to the petitioner would submit that already accused number 1 and 2 have been enlarged on bail. In exercising the powers of 438 of CRPC. And accused number 4 also enlarged on bail, invoking section 439 of CRPC. The counsel also submits that the injured is out of danger and no need of further custodial investigation, and this petition may be enlarged on bail. By contrary, the counsel appearing to the state would submit that this petitioner inflicted the injury with club, and the stained cloth of this petitioner was also seized, and there was an enmity with the complainant, and hence assault was made with club. And also the injury is grievous in nature. Having heard the respective counsel and also on perusal of material, this petitioner was arrested on 13/3/2022. 30/3/2022. And injured is also out of danger. And already bail was granted in favor of A1 and A2 and also A4 by exercising the powers of 439 of CRPC. When suspecting the factual aspects, when omnibus allegation made against each of the accused persons inflicting injury with club and iron rod, and when the injured is also out of danger, it is appropriate to enlarge this petitioner also on bail. No need of further custodial investigation in the matter, and whether with an intention to take away the life, inflicted injury or not, that is a matter of trial. Prasad BS.
For the petition, 438 petition, my lord, offense is 376, 506/114 read with 34 of IPC, my lord. This petition is accused number 1. Accused number 2 and 3 is concerned, my lord, this petition's brothers. They are already enlarged on bail before the trial court. This a present petitioner, my lord, is working in CRPF, Jammu, and presently working in Jammu Kashmir, my lord. Case of the prosecution, my lord, is a promise to marry. And it's a clear allegation, clear concocted complaint. It's a clearly shows that, my lord, even though it's a matter of alibi, kindly see, my lord, one moment, my lord. She said that on 23/4/2021, I came to the native place and have a sexual intercourse with her. But on the very same day, my lord, kindly see, I already produced the document, attendance list extract, and that extract before before this honorable High Court, along with memo, my lord. Original, I have kept original is in with me, my lord. And on that day, my lord, he was in working in CRPF at Jammu Srinagar, my lord. And as per the complainant, my lord, complainant aged about 25 years. And she said that, my lord, 2 occasions he came to his native place, and they are have love with each other since 3 years. And now, my lord, after lapse of when he came to his native place, on that day, my lord, her uncle came visited his house and requested him to marry that girl. But he refused that, my lord. The instead he demanded one Royal Whitefield bike and 14 gram gold and 3 lakh is the cash. And for her false implication clearly shows that, my lord, his only to mess up this petitioner and his family. She lost 3 line, my lord. ರಾಘವೇಂದ್ರನ ಸಹೋದರರಾದ ಪ್ರವೀಣ ಬಿನ್ ಶಂಕರಪ್ಪ, ಮಂಜಪ್ಪ ಬಿನ್ ಲೇಟ್ ಕರಿಯಪ್ಪ ಇವರುಗಳು ಕುಮ್ಮಕ್ಕಿನಿಂದ ರಾಘವೇಂದ್ರ ಇದುವರೆಗೂ ನಮ್ಮ ಕಣ್ಣಿಗೆ ಕಾಣದೆ ತಲೆಮರೆಸಿಕೊಟ್ಟಿರ್ತಾನೆ. To implicate entire family, my lord, she one by one they created concocted story, and both are major. And he is working in CRPF more than 9 years. And if this honorable court not enlarge the bail, he will lose the job, my lord, and entire family mess up, my lord. Clear case, my lord, is as per her statement itself, my lord, is complaint itself, my lord, clearly shows that, my lord, is at the most promised to marry. That one is concerned, my lord. And she is aged about 25 years. If some was is come to conclusion that, my lord, is he committed that act, kindly see, my lord, she is 25 years. Since 3 years, she never ever disclosed to anybody. And the after lapse of 3 years, she disclosing that, my lord, he had a sexual intercourse with her. And moreover, my lord,
sexual intercourse was taken place 3 years ago.
3 years, my lord. First time. Sorry, 2 years. 24/1/2010.
Not 2010, council.
Sorry, 20.
23/4/21.
24/1/2020 first time.
23/4/21.
Not 20. 20
ಇಲ್ರಿ.
ಇಲ್ಲ, ಮೇಲ್ಗಡೆ ಇದೆ 4ನೇ ಲೈನ್ 5ನೇ ಲೈನ್ ಅಲ್ಲಿ. 24/1/2020.
14/1/20.
Sorry, 14/1/2020. And 23/4/2021, my lord, kindly see, along with memo, I produced the attendance list extract. He was in Srinagar on duty. And only to some dispute between the parties, she filed making the serious allegation as against this petitioner. And she is aged about 25 years. And moreover, my lord, he will question of escaping from the does not arise, my lord. And he is in CRPF. And also, my lord, he will ready to cooperate. Any stringent condition may be imposed, my lord. He will cooperate with the investigation.
Yes, that's all. Yes, counsel.
Mike on ಆಗಿಲ್ಲ.
ಮೈಕ್ ಆನ್ ಮಾಡ್ಕೋಬೇಕು. ಮೈಕ್ ಇಲ್ಲಲ್ಲ ನಮ್ಮಲ್ಲಿ, ಮೈಕ್ ಇಲ್ಲ. ನೀವ್ ಇಲ್ಲೇ ಇರ್ಬೇಕಿದ್ರೆ ಚೆನ್ನಾಗಿರ್ತಿತ್ತು. ಆಯ್ತು,
ಧಾರವಾಡ ಮ್ಯಾಟ್ರ್ ಇತ್ತು ಅದಕ್ಕೋಸ್ಕರ.
ಹಾ ಹೇಳಿ ಏನು? ಹಾ ಟ್ರೈನ್ ಟಿಕೆಟ್, ಬಸ್ ಟಿಕೆಟ್. ಹಾ ಯಾವತ್ತಿಂದದು? 28/1/2020 he is not disputing. 23/4/21 he is disputing. He was in Jammu and Kashmir on that day ಅಂತ. ನಿಮ್ ಪ್ರಕಾರ ಇಲ್ಲದಲ್ಲ 23/4/2001 ಹಿರೇಕರೂರು ತಾಲೂಕು ಹಳ್ಳೂರು ಗ್ರಾಮದ ಬೆಟ್ಟದ ಮೇಲಿರುವ ರಂಗನಾಥ ಸ್ವಾಮಿ ದೇವಾಲಯಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ನನ್ನ ಮೇಲೆ ಹಠಸಂಭೋಗ ಮಾಡಿ ನಂತರ ವಾಪಸ್ಸು ಜಮ್ಮುವಿಗೆ ಹೋಗುತ್ತೇನೆಂದು ಹೇಳಿ ಹೋದವನು ಇತ್ತೀಚೆಗೆ ಮಾರ್ಚ್ 22, 2020 ಜಮ್ಮುವಿನಿಂದ ಶಿವಮೊಗ್ಗ ತಾಲೂಕು ಸುತ್ತಕೋಟೆ ಗ್ರಾಮಕ್ಕೆ ಬಂದಿದ್ದ. ಹಾ 23/4. ಹಾ ಏನು ಇಲ್ಲ? marry her. She made an attempt to commit suicide. ಅದೆಲ್ಲಿ ಎಲ್ಲಿ ಬಂತದ್ದು ನಿಮ್ಗೆ? ಕೌನ್ಸಿಲ್ ಶಿಫಾ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆಯಾ? ಏನ್ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ಏನಾರು ಇದೆಯಾ? ಫಿನಾಯ್ಲ್ ಕುಡಿದಾಗ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ಸ್. ನೋಡಿ ಮೇಡಮ್. ಫಿನಾಯ್ಲ್ ಕುಡಿದಾಗ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡ್ ಬಗ್ಗೆ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯೇನ್ರಿ? ಇಲ್ವಾ? ಈಗೇನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ? What is the stage of investigation? That's it, not at trial. How did the petitioner counsel and also the counsel appearance of the state? The factual matters of the case of the prosecution is that the victim girl in the complaint has stated that this petitioner and the victim girl both are loving each other from last 3 years. And this petitioner is working in army. That on 14/1/2020, he took her near the hillock of ಪಾದವಾರನಂದನಾಥ ಸ್ವಾಮಿ. ರಂಗನಾಥನದು ತಾಲೂಕಿನ ಕತ್ತಿಗೆ ಪಾದ ಅಂತ ಊರ ಹೆಸರದು, ಕತ್ತಿಗೆ ಪಾದ. ಹೊನ್ನಾಳಿ ತಾಲೂಕ್ ಕತ್ತಿಗೆ ಪಾದ ರಂಗನಾಥ ಸ್ವಾಮಿ ಟೆಂಪಲ್ ಅಂತ. And promising that he would marry her, subjected her for sexual act. And in spite of she resisted, he did not allow her to resist. And when he told that he would tell the same to her parents, he has threatened her not to reveal the same. And taking the advantage of the same again, he subjected her for sexual act. And that on 23/4/2021, once again, he subjected her for sexual act and left the place saying that he is going to Jammu and Kashmir. Jammu. When he came back in the month of March 2022, her father went and asked him to marry, but he refused to marry her and demanded Enfield bike, 14 tola gold, and 3 lakh rupees cash. And hence case has been registered for the offence prescription 376 to 114 506 34 of IPC against this petitioner and also other two accused persons. The counsel appearing for the petitioner submits that the trial court already granted bail in favor of applicant 213, and in respect of this petitioner rejected the bail petition. The counsel also submits that on the allegation of on 23/4/2021, this petitioner was in Jammu, and question of subjecting her for sexual act doesn't arise, and false implication is made. And he is in army, and he may be granted bail, and any conditions may be imposed to assist the IO. For contra, the counsel appearing for the state will submit that he has committed heinous offence of subjecting her for sexual act, and also subjected her for sexual act only on the ground, on the guise of promising her that he would marry her, and subsequently also subjected her for sexual act. The counsel also submits that the medical examination report also says that she was subjected to sexual act. And apart from that, 164 statement of the victim also recorded, wherein also she has categorically stated about the act of this petitioner, and also when he refused to marry her, she made an attempt to commit suicide by consuming the phenol, and she was treated in the hospital. And the counsel appearing for the complainant through the counsel appearing for the state also placed the documents with regard to the both of them have worked in conversation, and screenshots also placed before the court, and call logs between the petitioner and the original complainant also placed before the court. Apart from that, photographs also produced before the court, and CD of the screenshots, photos, and video and audio recordings between the petitioner and the original complainant also placed before the court. And vehemently contend that with the promise to marry her subjected for sexual act, now he turns hostile, and hence is not entitled for anticipatory bail. Having heard the respective counsel and also on perusal of petition, particularly the documents which have been placed before the court, that is the documents of photographs, videographs, screenshots, and call logs, and screenshots of the conversation between the petitioner and the original complainant.
I make only one submission.
Apart from that,
those documents is subject to evidence, my lord. The photographs and all subject to evidence.
Prima facie ಅಷ್ಟೇನೆ. Prima facie ನಾವೇನ್ ಈಗೇನ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ.
Yes.
ಆಯ್ತಾ? Prima facie ಗೋಸ್ಕರ ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
Prima facie, my lord, because if any stringent, if it is my submission, my lord, if it is any bleak chance to go together, that will also spoil, my lord.
ಆಯ್ತ್ರಿ, ಎಲ್ಲ ಮಾಡ್ಬಿಟ್ಟು ಈಗ ಕೈ ಕೊಟ್ಬಿಟ್ರೆ
no, it's not like,
ಮತ್ತೆ ಆರ್ಮಿಲಿ ನಾನು ಬುದ್ಧಿ ಹೇಳ್ಬೇಕು ದೇಶಕ್ಕೆಲ್ಲ. ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಈಗ
that is the reason,
ಊಟ ಮಾಡ್ಬಿಟ್ಟು ನನಗೆ ಊಟ ಬೇಡ ಅಂದ್ರೆ
that is the reason, my lord, this my submission. If it is a bleak chance of
mine is also a fair order, that's all. ನೋಡಿ ಎಲ್ಲ ಎವಿಡೆನ್ಸ್ ತೋರಿಸ್ತಾ ಇದೆ ಇಲ್ಲಿ, ನೀವು ಮಾಡಿರೋದೆಲ್ಲ ಏನೇನಿದೆ ಅಂತ ಇಲ್ಲಿ ಹಾಕಿರೋ ದಾಖಲೆಗಳೆಲ್ಲ ತೋರಿಸ್ತಾ ಇದೆ.
Photograph and
Not only photographs, conversation between the screenshots, chatting between the victim girl and also your client.
it's not amount to rape, my lord. On that point of time, yes,
Not
my
amount
lord.
to rape. Medical evidence shows that she was subjected to sexual act.
Sexual act is concerned, my lord. This the she
No,
is
no,
18 to
counsel, it is
25.
not a case for 438. That's all.
25 years. She is 25 years, my lord.
So 25 years adre. 25 years adre promising to marry and subjecting for sexual act and you can throw her out.
She will consent after lapse of 3 years, my lord. She is filing a complaint. That's my.
Not 3 years, 3.
2 years. Sorry.
2020. ಮದುವೆ ಆಗಿರೋದು 2 ವರ್ಷ ಇಲ್ಲ ಲವ್ 2 ವರ್ಷದಿಂದ ಅಂತ ಹೇಳ್ತಾರೆ.
3 ವರ್ಷದಿಂದ.
ಆಯ್ತು. Don't interpret in a manner which is convenient to you. ಏನಾಯ್ತು ಮೇಡಮ್?
Having with respect to the result of the records, particularly documents which have been placed.
ನಾನು ನಿಮ್ಮನ್ನೆಲ್ಲ ಕೇಳಿದ್ಮೇಲೆ ಆರ್ಡರ್ ಬರೀತಾ ಇದ್ದೆ. ನೀವು ನೋಡಿ ಇಂಟರ್ಫಿಯರ್ ಆಗೋದು ನಮ್ಗೆ ಎಲ್ಲ ಫ್ಲೋ ಹೋಯ್ತು. You are not a junior counsel. You are a senior counsel.
Sorry, my lord.
ಮತ್ತೆ MFC ಅಂತ ರೆಫರ್ ಮಾಡಿದ ತಕ್ಷಣ ಏನ್ ಕಾಂಡಕ್ಟ್ ರೀ ನಿಮ್ದೆಲ್ಲ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಗಳು. ವೆದರ್ ಐ ಅಬ್ಜೆಕ್ಟೆಡ್ ಯು ವೈಲ್ ಆರ್ಗ್ಯೂಯಿಂಗ್ ಮೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಇಲ್ಲಲ್ಲ. ಇದೆಲ್ಲ ಕೇಳಿದ್ಮೇಲೆ ಅದರ್ ಸೈಡ್ ಕೇಳಿದ ಆರ್ಡರ್ ಬರಿತಾ ಇದ್ರೆ ನೀವು ಇಂಟರ್ಫಿಯರ್ ಮಾಡ್ತೀರಿ. ಏನಾಯ್ತು ಮೇಡಮ್?
Having with respect to the concern and on the result of the material on record, particularly the documents which have been placed before the court, that is documents of videograph, photographs, screenshot and call logs, and screenshots of conversation between the petitioner and the original complainant.
And also specific allegation is made by the victim girl against this petitioner that he subjected her for sexual act on the promise that he would marry her. And also medical records discloses that she was subjected to sexual act. And apart from that, she may also made an attempt to commit suicide by consuming the canal. And the same is reiterated in 164 statement. And when assessing the factual aspects, when this petitioner committed a heinous offense of subjecting the victim girl for sexual act, it is not a fit case for exercising the powers of 438 of CRPC. The petitioner being the army person, CRPF cannot be a ground to enlarge him on bail, exercising the discretion under 438 of CRPC. Hence, no grounds to grant anticipatory bail in favor of the petitioner. And material placed before the court, prima facie discloses the allegations made against the petitioner hearing, including 164 statement of victim girl. HCGP hospital records in the last time in the ಕೇಳಿದ್ರು ನೋಡ್ರಿ 307 498 3 and 4. ವಿಷ ಕುಡಿಸಿ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನ ಪಟ್ಟಿರುವ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಬೇಕೆಂದು ಏನಿದೆ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ರೆಫರ್ ಟು ಅಲ್ಲೇನಾಯ್ತು ಅಸಾಲ್ಟ್ ಆನ್ 10/2/22 10:30 AM consumption to her by husband. ಇದ್ಯಾರ್ದು ಪಿಟಿಷನ್ ಬೈ whom? Husband. What about other accused? Already been enlarged on bail. But specific allegation against him that he forcibly ಆಯ್ತು. ನಾಲ್ಕೈದು ಬಾರಿ ಪಂಚಾಯತಿಯಲ್ಲಿ ಆಗಿದೆ ರೀ. No material. Material will be collected during the course of investigation. That's all. They have to record the statement of witnesses who have participated in the panchayat. ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ಗೆನೆ ಕೇಳ್ತಾ ಇರೋದು. That is material itself is, that's why I asked to secure the hospital records. History of assault on 10/2/22 at 10:30 AM. Consumption to her by husband. ಏನ್ರಿ ಟ್ರೀಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಏನಿದೆ ರೀ? ಆಯ್ತ್ರಿ, ವಿಷ ಕುಡಿಸಿ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನ ಮಾಡಿದ್ರು ಅಂತ. ದಟ್ಸ್ ವೈ ಐ ಆಸ್ಕ್ ಯು ವೆದರ್ ಎನಿ ಸಬ್ಸ್ಟಾನ್ಸ್ ಆಫ್ ಪಾಯ್ಸನಸ್ ಇನ್ ಅವರ್ ಬಾಡಿ ಇದೇನ್ರಿ? ಎಲ್ಲಿದೆ? ಮನೆ ರಿಕವರಿ ಆಗ್ಲಿ ರೀ, ನಾನ್ ಕೇಳ್ತಾರದ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ. ಆಯ್ತು, ಅದೆಲ್ಲಿದೆ? ಪಾಯ್ಸನಸ್ ಸಬ್ಸ್ಟಾನ್ಸ್ ಏನಾರು ಇತ್ತ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ವೆದರ್ ದ ಟ್ರೀಟೆಡ್ ಆರ್ ಫಾರ್ ದಿ ಫೋರ್ಸಿಬಲ್. ಆಯ್ತ್ರಿ, ಬರೀ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು ಅಡ್ಮಿಟ್ ಆದ ಬಗ್ಗೆ. ಶಿ ವಾಸ್ ರೆಫರ್ಡ್ ಟು ಇದು MEM ಹಾಸ್ಪಿಟಲ್. ಏನದು? ಅಲ್ಲಿದೇನಿದೆ ಬೇರೆ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್? ಯಾವಾಗ? ಬಟ್ ಮೈ ಪಾಯಿಂಟ್ ಈಸ್ ವೆದರ್ ಶಿ ವಾಸ್ ಫೋರ್ಸ್ಡ್ ಟು ಕನ್ಸ್ಯೂಮ್ ದಿ ಪಾಯ್ಸನ್ ಅಂತ. ಅದಕ್ಕೆ ಏನಾದ್ರು ಸಬ್ಸ್ಟೆನ್ಸ್ ಇದೆಯಾ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ. ದಟ್ ಈಸ್ ದ ರೀಸನ್ ಓನ್ಲಿ ಐ ಡೈರೆಕ್ಟೆಡ್ ಯು ಟು ಗೆಟ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ. ನೀವು ಯಾವ್ದೋ ಒಂದು ಬರೀ ಅಡ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ಸ್ ತಂದ್ಬಿಟ್ರೆ, ವೆದರ್ ಶಿ ವಾಸ್ ಟ್ರೀಟೆಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿ ಪಾಯ್ಸನಸ್ ಸಬ್ಸ್ಟೆನ್ಸ್ ಅಂತ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಆಯ್ತು ತಗೊಳ್ಳಿ. ಅಲ್ಲ ಸರಿ ರೀ, ನೀವು ಹಾಸ್ಪಿಟಲ್ ಕರ್ಕೊಂಡು ಹೋದ್ರಿ, ಬಟ್ ಅಲಿಗೇಷನ್ ಇಸ್ ದಟ್ ಯು ಓನ್ಲಿ ಫೋರ್ಸ್ಡ್ ಟು ಕನ್ಸ್ಯೂಮ್ ದಿ ಪಾಯ್ಸನ್ ಅಂತ. ಫೋರ್ಸಿಬಲಿ ಅಡ್ಮಿನಿಸ್ಟರ್ಡ್ ಪಾಯ್ಸನ್ ಅಂತ. ಅದಕ್ಕೆ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ನೋಡೋಣ ಏನಿದೆ ನೋಡೋಣ. ಬೇರೆ ಮದುವೆ ಆಗುತ್ತೇನೆ ಎಂದು ನನ್ನ ಅಳಿಯ ಶಿವರಾಜು ಮತ್ತು ಅತ್ತೆ ಮಾವ ದೈಹಿಕವಾಗಿ ಮನಸ್ಸು ಕಿತ್ತು ಅಂತಿದ್ರು.
ನಡೀತಿಲ್ಲ, ಹೋಗಿ ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡಕ್ ಮಾತಾಡ್ತೀವಿ, ಒಂದೆರಡು ಮಾತು ಹೇಳಿ ಬಿಡಿ.
Complaint is not given by her. The father has given complaint of 2 days. This is
specific allegation in the complaint that ಮನೆಯಲ್ಲಿ ಶುಂಠಿಗೆ ಹೊಡೆಯಲು ತಂದಿದ್ದ ಔಷಧಿಯನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದು ನನ್ನ ಅತ್ತೆ ಮಾವ ನನ್ನನ್ನು ಹಿಡಿದುಕೊಂಡಾಗ ನನ್ನ ಗಂಡ ನನ್ನ ಬಾಯಿಗೆ ಔಷಧಿಯನ್ನು ಹಾಕಿ ಹೋಗುವಂತೆ ಮಾಡಿದರು. ಸ್ವಲ್ಪ ಸಮಯದ ನಂತರ ನಾನು ಪ್ರಜ್ಞೆ ತಪ್ಪಿ ಹೋದೆ. ಮುಂದೆ ಏನಾಯ್ತು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನ್ನ ಗಂಡ ಅತ್ತೆ ಮಾವ ನನ್ನ ಬಯಸ್ಕೊಟ್ಟಿದ್ದಾರೆ. This is the allegation. That's why. ಏನ್ರಿ ಅವಕ್ಕೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅನ್ನು ರೆಕಾರ್ಡ್ ಮಾಡಿದಾರಲ್ರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ? ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಏನಾರು ಆಕೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದಾರಾ? Father had given the complaint at the first instance. Thereafter, how long she was in the hospital? ಸರ್ ಅದೇನಮ್ಮ ಇದ್ರ KR ಹಾಸ್ಪಿಟಲ್ಗೆ ಏನೋ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ನೋಡಿ. KR ಹಾಸ್ಪಿಟಲ್. She was taken to KR hospital also. ತರ್ಸಿ ಅದು KR hospital ರೆಕಾರ್ಡ್ ತರ್ಸಿ. ಆಯ್ತು ತರ್ಸಿ ನೋಡಿ. The petitioner, the HCGB is directed to get the records of KR hospital and list this matter day after tomorrow. ಯಾವತ್ ಬೇಕು ಹೇಳಿ? 2nd of June ಮತ್ತೆ 2nd ಅಂದ್ರೆ ಫಸ್ಟ್ ಆಗಲ್ಲ, ಫಸ್ಟ್ ಇರಲ್ಲ. ಆಯ್ತು, 2nd of June. 115 ಭದ್ರವಾಡಿ ಸಿದ್ದೇಶ್ವರ. ಸೇಮ್ ಕ್ರೈಮ್. ಸೇಲ್ ಡೀಡ್ PDA ಅದೇನ ಕೇಳಿದ್ದೆ ನೋಡಿ. ಅಲಿಗೇಷನ್ ಏನು? Whether any sale deed is executed by BDA in favor of accused number 1 or not, and documents are forged documents ಅಂತ ಕೇಳಿದ್ದೆ. Only mediators, these petitioners, mediators in selling the property. So, or the petitioner counsel and also the counsel appearing for the state. ಎರಡು connected ಇದೆ ಮೇಡಮ್. ಒಂದು A2, ಇನ್ನೊಂದು A4, A2 and A4. The factual matters of the case of the prosecution is that ಏನು ಹೆಸರೇನು ಹೇಳೋದು? ಒಬ್ಬ ವಿನೋದ್ ರಾಜ್, Naveen Kumar. These petitioner along with one Siddharaju told that the properties are belongs to one Ramesh Babu. And site number 1882 is formed out of survey number 57. And documents are genuine documents. And sale consideration is fixed as 1,25 lakhs. And an amount of 1,25 lakhs was paid in the name of Ramesh Babu by way of 3DD on 3/1/2022. And executed the document in the office of Mahalakshmi Layout Sub-Registrar Office, Rajajinagar. But on 21/2/22, an information was given that site number 1882 was not sold in auction, and the said property belongs to the BDA. A notice was issued. And immediately, complaint was lodged against these petitioners that all of them have indulged in creating of documents and executed the sale deed for a sum of rupees 1,25 lakhs. The counsel appearing to the petitioner would submit that allegation is made against these petitioners that they have acted as mediators, and not the allegation against that they have received any money. And payment is also made in favor of the Ramesh Babu. These petitioners have not indulged in any such acts and have also not signed any created documents. And hence they may be enlarged on bail. For contra, the counsel appearing to the state would submit that sale deed is executed. Sale deed is A1 ಪರವಾಗಿ ರಮೇಶ್ ಬಾಬು ಪರವಾಗಿ ಬರ್ಕೊಟ್ಟಿಲ್ಲ, BDA ಬರ್ಕೊಟ್ಟಿಲ್ಲ. BDA ಸೇಲ್ ಡೀಡ್ ಇದೆಯಾ? ಆ ರೀತಿ ಇಂಡಲ್ಜ್ ಆಗಿ ಇದು ಕಂಪ್ಲೇಂಟ್ ರೀ, ನಾನ್ ಕೇಳ್ತಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ, ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದಾರೆ, ಅದ್ ಬೇಡ. ಅದು ನಾನ್ ಕೇಳ್ತಾರ PDA ಕಡೆಯಿಂದ ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆಯಾ ರಮೇಶ್ ಬಾಬುಗೆ ಆಕ್ಷನ್ ಅಲ್ಲಿ ಪರ್ಚೇಸ್ ಮಾಡ್ಕೊಂಡಿರೋದಕ್ಕೆ, ಎಲ್ಲಿದೆ ಆ ದಾಖಲೆ? ಮಾಡೇ ಇಲ್ಲ ಅಂತ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ಏನಾಯ್ತು ಮೇಡಮ್? No sale deed is executed in favor of the Ramesh Babu by BDA. And these petitioners indulged along with the said Ramesh Babu, that is accused number 1, in creating of document. But these petitioners are not the signatories to any of the documents. Having heard the respective counsel and also on perusal of material, an allegation is made against these two petitioners that they acted as mediators in parting with the money of rupees 1 crore 25 lakhs in favor of accused number 1. And payment also made by way of DD in favor of accused number 1. The alleged document was also registered on 3/1/2022. And no such sale deed was executed in favor of accused number 1, and also no action was conducted in respect of the said property. And serious allegations are made against these petitioners also. But the fact is that they have not signed any documents, and specific allegation is made against who is claiming as owner of the property in creating of document. When such being the case, and no material regarding payment of any amount in favor of these two petitioners. When such being the case, it is a fit case to exercise the discretion in favor of petitioners, directing them to cooperate with the IO for investigation in the matter. 117 AV Ramakrishna. ನಾಲ್ಕು 52 ಏನ್ ನಿಮ್ಮ ಮೇಲೆ ಏನು ಅಲಿಗೇಷನ್? 20. ಏನ್ರಿ ಇವ್ರ ಮೇಲೆ ಅಲ್ಲಿ ಇವ್ರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇಲ್ಲಲ್ರಿ? ಏನು ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಸ್ ಆಲ್ಸೋ ಡೈರೆಕ್ಟೆಡ್. ನೋಟಿಫೈ ಮಾಡಿದೀರಾ? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ನೋಟಿಫೈ ಮಾಡಿದೀರಾ? ಮಾಡಿದಿರಿ. ಯಾವಾಗ? Sorry madam, HCGP submits that already. R2 is notified on 28/5. 28/5 ಅಂದ್ರೆ ಮೊನ್ನೆ ಸಾಟರ್ಡೆ ಹಂಗಾರೆ ಒಂದು 3-4 ದಿವಸ ಟೈಮ್ ಕೊಡೋಣ, ನೋಡೋಣ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ. Notify on 28/5/22 and hence this matter on 6th. Number 18, Mudidhar HM. Non-production of order passed by the learned magistrate with order dated 24/22. ಯಾರಿಲ್ಲ ಮೇಡಮ್, ಏನಕ್ಕೆ ಇದು? 138 ಕಾಂಪ್ರಮೈಸ್. ಇನ್ನೊಂದು ಆರ್ಡರ್ ಏನಂತಿದೆ? Director deposit report within 1 week and pays the receipt for having paid the amount. Amount ಕಟ್ಟಿಲ್ವಾ ಈಗ? If the amount is not paid, it's the matter on 24/22 ಅಂತ ಆಯ್ತು. ಆಮೇಲೆ ಏನಾಯ್ತು 24 ಅಲ್ಲಿ? Learned counsel for the petitioner is directed to produce the order passed by the learned magistrate. Yen order? Having paid the amount. Yar counselor idu? Muralidhar. H.V. Shivakumar. The petitioner was directed to pay the fine of ₹5,000 before the transport and produce receipt. And also further ordered if the amount is not paid, list the matter on 24/22. And accordingly, matter was listed on 24/22. And the petitioner counsel was directed to produce the order passed by the learned magistrate. And today, no one appears before the court and petitioner counsel is also absent. And hence, registry is directed to issue notice to the petitioner for non-compliance of the order. And also notice to the petitioner counsel. List this matter on 10th of June. 119 Shekhar Shetty.
Yes, I apply for petitioner, my lord.
Yes, Haley.
Washington is pleased to see it is now posted for admission, this review petition. It automatically should be admitted because there is no provision under the Civil Procedure Code or the High Court rules. Chapter 3, your Lordship kindly take is chapter P. They are all provisions are deleted and no according to it. Straight away it must be posted before the bench it passed the order. As if it is entered. That's why it is automatically it is admitted. The admission is even otherwise if your Lordship wants, I will straight away give your Lordship a Supreme Court decision on the point. Once there is a High Court rules demonstrates for the admission. Year 1983 Supreme Court 269. I have given the list also before your Lordship.
Yes.
22nd March 2022. First decision. Para 6 and 7, your Lordship kindly see it. I'll read it, my lord. I'll read it.
Yes, you read.
Would your Lordship get that citation?
Yes. That is decided on 6/1/2000. Citation first citation.
First citation, that is 22 March 2022. And again, Monarch list is sorry. 22 March 2022.
No such citation is placed before the court.
Huh?
No such citation is placed before the court. Monarch list is sorry. ಅದಕ್ಕೆ ಕೇಳಿದ್ದೆ.
ಇದೆ 3-4 ಇದೆ ಕೊಟ್ಟಿದೆ.
ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಡೇಟ್ ಹೇಳಿದ್ನಲ್ಲ, ಸೀಲ್ ಇದೆ, ಕೋರ್ಟ್ ಸೀಲೇ ಇದೆ ನೋಡಿ.
Court seal ಇದೆ. Have you served the copy of the citations on the other side?
ಅದರ್ ಸೈಡಿಗೆ ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೆ ಅಷ್ಟೇ, ಕಾಪಿ ಕೊಡಲ್ಲ, ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈಗ 3 ಸರಿ ಹಾಕಿದೀರಾ ನೀವು ಸೈಟೇಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಎಲ್ಲ ಕೊಟ್ಟಿದೆ.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ನಮ್ ಕ್ಲಾರ್ಕ್ ದಿನ ಅವ್ರ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಬರ್ತಿಲ್ಲ.
First of all, no acknowledgement on the other side serving of the citations. ಅದು ನೋಡೋಣ, ಆಮೇಲೆ ನೋಡೋಣ. Now he is relying upon some citations. He has to. That has been considered by this court also.
Now he is execution petitions.
Copies ಕೊಡಿ ಅವರೇ ಕೌನ್ಸಿಲ್, ನೀವು ಕಾಪೀಸ್ ಕೊಡಿ ಅವರಿಗೆ. ಸೈಟೇಷನ್ಸ್ ತಂದು ಕೋರ್ಟ್ ಹಾಕಿರ್ ಸಾಲದು, ಅದರ್ ಸೈಡ್ ಸೈಟೇಷನ್ಸ್ ಕೊಡ್ಬೇಕು. ಇಲ್ಲ ಯಾವ ಕೊಟ್ಟಿದ್ದೀರಿ, ಯಾವ ಸೈಟೇಷನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ. ನೋ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಅಟ್ ಆಲ್.
Lordship says, if he says like that, I am prepared to say, give you one more set. That is not a big thing.
ಕೊಡಿ ಯಾವ ಸೈಟೇಷನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ನೀವು. You are relying upon some citations.
That is true, my lord. But my
petitioner counsel is directed to serve the copy of the citations which he is relying upon.
Only list of the citation, my lord, not copy.
Copy
I need not give him.
List this matter day after tomorrow.
One submission, my lord. Really? With great respect. Last week, last Thursday it came. Your lordship was kind enough to pass an order to post it at the top of the list. But today 119 it came.
Order illenri.
Top of the list you one order.
Top of the list anta bardidola. Ilva order ilva. And then why you have posted as serial number 119? Now non ಕರಿ board branch ಅನ್ನು ಕೊಡಿ. List the matter in the top of the list ಅಂತ ಮಾಡಿದೀವಲ್ಲ ಮತ್ತೆ. ಇಲ್ಲ ಅಂತ ಏನ್ ನೋಡಿಲ್ಲ ಅಂತೆ. ನೋಡಿದಿಲ್ಲ ಅವನೇನ್ ಮತ್ತೆ ಪೋಸ್ಟಿಂಗ್ ಮಾಡ್ತಾನಂತೆ. ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿದಲ್ಲ ಏನ್ ಪೋಸ್ಟ್ ಮಾಡ್ತಾನೆ ಮೇಡಮ್ ಅವನು. ಯಾರೋ ಅವ್ನು ಕರೀರಿ, ಅವನು ಕರ್ಸಿ ನನ್ನ ಚೇಂಬರ್ಗೆ. ನೋಡಿಲ್ಲ ಅಂದ್ರೆ ಏನಕ್ಕೆ ಅವನು ಬರೀ
ಕೊಡ್ತೇನೆ ನಿಮ್ಗೆಲ್ಲ.
In spite of this court ordered to list the matter in the top of the list, the concerned official ignored the order passed by this court and listed this matter as serial number 119, and hence Registrar Judicial is directed to call for explanation from the official and list this matter day after tomorrow in the top of the list. Day after tomorrow. Fast over ಬೇರೆ ಇದೆಯಾ? ಏನಂತ ನೋಡಿ. 11 ತೋಲ್. ಏನಾಯ್ತ್ರಿ ಡಿ ಕೆ ಬಸವರಾಜ್ ಯಾರು ಇದಾರ? ಯಾರೋ ಏನೋ ವಿಡ್ರಾಯಲ್ ಏನೋ ಅಂತಿದ್ರಲ್ಲ ಏನೋ ಬೆಳಗ್ಗೆ. ಇನ್ನೊಂದು ಇದಲ್ವಾ? ತೋಲ್. This matter is listed for court time and this court earlier urgent and cost of rupees 500 payable at the registry and cost also not paid and office objections also not complied. And hence matter is called in the early morning and also in the afternoon at 5 o'clock and no representation and hence dismissed. Next out. ಏನೋ ಮೆಮ್ಮ ಕೊಡಕ್ ಬಂದ್ರಲ್ಲ ಇದ್ರಲ್ಲ ಯಾವ್ದ್ರಲ್ರಿ? ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ ತಗೊಳ್ಳಿ. ಸೇಮ್ ಆರ್ಡರ್ ಮೇಡಮ್, ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇ. 13 ಚೇತನ್ ನಾಗ್ cost paid. The petitioner counsel has filed memo along with cost receipt and praise this court to ಏನ್ ಆಗ್ಬೇಕ್ರಿ ಇದ್ರಲ್ಲಿ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ, ಅವ್ರೇನ ರಿಲೀಸ್ ಮಾಡ್ಬೇಕು ಏನೋ ಅಂದ್ರಲ್ಲ ಅವ್ರು. ವಿಡ್ರಾ and counsel seeks permission of this court to withdraw the petition. Reason ಏನು? And subsequent to the filing of this petition, petitioner was arrested and hence petition become infructuous. In view of the submission Petition is dismissed as infructuous in lieu of the arrest of the petitioner. 14. ಇದು ಅಷ್ಟೇ ಮೇಡಮ್ 11, 12 ಆರ್ಡ್ರೆ 14 ಆರ್ಡರ್ ಆಯ್ತಾ. ಇನ್ನೊಂದಿದೆಯಾ 99. Why it was adjourned? ಸಿಕ್ತದು ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ. ಆರ್ಡರ್ ಮಾಡುವಾಗ ಅದಾ freedom appearing to the respondent court others in this section learned counsel seeks permission of this court to withdraw the petition accordingly. ಇದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗಿಲ್ಲ. ಯಾಕೆ ನಾನು ಕೊಡಲ್ಲ ಅಂತ ಅಂದ ತಕ್ಷಣ ಅವರು ಡಿಕ್ಟೇಷನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ ತಕ್ಷಣ ಅಕ್ಯೂಸ್ ನಂಬರ್ 4 ಅಲ್ಲ, ಬೇರೆ ಅಕ್ಯೂಸ್. ಇವನ್ ಎಷ್ಟು ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಕ್ಯೂಸ್ ನಂಬರ್. ಅಕ್ಯೂಸ್ ನಂಬರ್ ಎಷ್ಟು ಮೇಡಮ್ ಇವನು ಗೊತ್ತಾಗ್ತದ? ಫೈಲ್ ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ದು? 4 ಅದು ಎಷ್ಟನೇ ಅನ್ನೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದೆ. ಈ 438 ದಿಸ್ ಮ್ಯಾಟರ್ 439 ಅಂದೆ. 439 A4 ಅವನು A1 ಇವ್ರು A4 ಆಯ್ತು. ನಾಡಿದ್ದು ನೋಡೋಣ ನೋಡಿ ಅದು ಇಟ್ಟಿರಿ ಮೇಡಮ್. ಕಾಪಿನ ಅದ್ರ ಜೊತೆ ಇಡಿ. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ 1st of June. ಓಕೆ, ನನಗೆ ಮೆಮೊರಿಯಲ್ಲಿ ಇತ್ತು. ನನಗೆ ಐ ಹರ್ಡ್ ದಿಸ್. I heard the matter. When I was about to dictate at that time, then. Madam, 46 disposal. Right.